FIR has been registered. We have registered an FIR. That came to be stayed.
ನಾನು ಎಷ್ಟೇ ಮಾಡಿದ್ದೀನಿ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ.
Tomorrow.
Your Lordship, for the same cause of.
Give all. Monday, but.
Your Lordship, for the same cause of action.
Settlement tomorrow, give.
Proceedings were initiated.
My lord.
Wait, women all come this side. Why are you mixed up? Come this side.
My lord, petition is appended as.
Wait, I'll come. Wait. Fresh matter. ಪರವಾಗಿಲ್ಲ, ಯಾವ್ದು ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ ಕೊಡಿ, ತೊಂದ್ರೆ ಎಲ್ಲರೂ ಸೀನಿಯರ್ ಸಿಟಿಜನ್ಸ್ ಕೊಡಿ. ಗಿವ್ ಇಟ್ ಸರ್, ಇಟ್ ವಿಲ್ ಕಮ್. ಗಿವ್ ಇಟ್. No, don't ask dates in pending matters. They are coming, they will come. Yes. Vacating stay applications ಯಾರ್ದಾರು ಇದೆಯಾ? ನಾನು vacating stay ಅಂತ ಕೇಳಿದ್ದೆ, ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್. vacating stay ತಗೊಳ್ಳಿ. ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಅಲ್ಲೇನೋ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ತಾನೆ? ಆಯ್ತು ಕೊಡಿ, ಡೇಟ್ ಇಲ್ಲ ಕೊಡಿ. Wait. Who gave the date? Here? ಚಾನ್ಸ್ ಇಲ್ಲ, ಕೊಡಿ. We'll see, give it. Yes. 306 ಅಲ್ಲ, ನಾನು ಸ್ಟೇ ಕೊಡಲ್ಲ ವಿತೌಟ್ ಲುಕಿಂಗ್ ಇನ್ ಟು ದಿ ಮಟೀರಿಯಲ್. ಮತ್ತೇನು ಉಪಯೋಗ? ಮಂಡೇ ಫ್ರೆಶ್
My lord.
ಎಲ್ಲ ಕೊಡಿ, ಮೆಮೋಸ್ ಕೊಡಿ.
My lord.
Next week,
Wait, I'm coming. That's it. Wait.
connected matter disclose ಆಯ್ತು.
ಆಯ್ತು ಕೊಡಿ, ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಡಿ.
Clarification ಗೆ ಅಂತ RP ಗೆ security
ಕ್ಲಾರಿಫಿಕೇಶನ್ ವೈ
ಅದು ಇದ್ರಲ್ಲೂ ಟ್ಯಾಗ್ ಮಾಡಿದಾಗ ಎಂಟ್ರಿ ಮ್ಯಾಟರ್ ಕಾಮನ್ ಆಗಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ ಸರ್. ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಬಿಟ್ಟಿದೆ, ಅವು 3 ಡಿಸ್ಕ್ಲೋಸ್ ಆಗಿದೆ.
ಆಯ್ತು ನೋಡಿ
ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಕೊಡಿ, ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಡಿ. ವೈ ನೋ ಪ್ರಾಬ್ಲಮ್, ಕೊಡಿ ಸರ್. No problem. We'll take it on Monday or Tuesday. We'll take it.
The employee Malats has already.
Wait. Give all the memos. Why are you waiting?
Reporting settlement matter.
Settlement, when do you want Barkodi?
4:30. Reporting.
Settlement ella Monday ne.
Plus for withdrawal of.
Yavadu beda. Withdrawal. Just now we'll post it. Give it.
Please.
Withdrawal.
Malas, in this matter, my loss granted the stay of further investigation.
Withdrawal, right?
Please. Malas, police have again, we intimated the police, Malas, then they have filed a charge.
Withdrawing it, right?
Please.
But Adlen submission, kodi.
Please.
Charge.
Post madi.
Employee has succeeded the arbitration Malats. There is a allegation.
Pressure pending, sir.
Pending. Next week Malats.
It will come. Application ಹಾಕಿದ್ದೀರಾ? ಹಾಕಿದ್ರೆ ಕೊಡಿ ಬರುತ್ತೆ.
Milord.
Now tell me.
Milord.
Wait, stop now.
My lord, petitioner is appointed as civil judge, my lord. There is a serious threat from the side of respondent, my lord.
Why?
They have filed false case against the petitioner, my lord. So one day she went to police station, they came there.
What's the urgency?
Yeah, it's very urgent.
Why? What is the urgency? Because you are appointed as a civil judge.
Only false case.
ಆಯ್ತು, ಎಲ್ಲ false. Next week ಬರುತ್ತೆ.
My lord, one.
Give fresh matters ಯಾವ್ಯಾವ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲಿ.
Give me a short date, my lord.
Pending matter.
ಇಲ್ಲ fresh matter.
ಬರುತ್ತೆ, Monday or Tuesday ಬರುತ್ತೆ.
ED matter. ED disposal, my lord.
Give it.
It's an ED.
ನೀವು ಈ ಕಡೆ ಬನ್ನಿ, ಯಾಕೆ?
My lords, ED matter, there's no predicate offense, my lords. The petitioner is disabled, my lords. And we've gotten to know now that the person with
Fresh
whom
matter,
fresh matter, my lords.
My
It was
lords,
taken up today, my lords, 2:30.
Sorry?
2:30,
Why?
my lords. My lords, because we've written an email to them saying that we're not able to come, but they're insisting on physical presence. I'm in West Bengal, my lords.
All right, 2:30.
My lords, for withdrawal.
Act, my lords.
Withdrawal, give it, yes.
Matter is listed today, my lords.
Vacating stay, my lords, vacating stay.
Give it, vacating stay.
Date may be fixed, my lords.
It will be daily 10 are coming, it will come. Yes.
My lords, 498 matter, charge sheet has been filed against the parents. There's no grounds for it. 18 years of delay in order.
Fresh matter.
Fresh matter, my lords. Maybe listed tomorrow, my lords.
No, tomorrow.
But we are finding the vacating stay.
Tomorrow, no matter. Tomorrow is special court day. No matters of
We
this.
are finding the vacating stay, my lord.
It will come.
And petitioner are convicted for the predicate offenses, my lord.
Interim order is granted. We are filing the vacating stay, my lord.
ಹಾಕಿದ್ದೀರಾ? vacating stay.
My lords, moving it to 230, my lords, respondent number 2 has sought for modification of bail order, my lords. The order itself is capricious, my lords, and not judicially tenable.
Sorry?
It's the bail order itself is not judicially tenable, my lords. He's again asked for respondent number 2 has asked for modification of bail order.
Or we give it why?
230, my lords.
Why 230?
My lords,
You are for the respondent,
for the petitioner, my lords, as in the complainant.
complainant.
Yes,
You are
ma'am.
challenging the bail order.
My lords.
No problem, give it. No 230.
My lords.
Give it, yes. Why are you shouting? Give it.
My lord, I'm a retired government servant, my lord. My
So what?
pension has
Give it.
been.
My lord, one
Give it,
submission.
give every pending matter.
Yes, ma'am.
ಬರುತ್ತೆ ಕೊಡಿ.
My lord, one submission.
ಹೇಳ್ತಾ ಇಲ್ವಾ ಅಲ್ಲಿ?
Your Lordship, it's a pending matter for the same cause of action. 2 criminal proceedings were initiated. This is purely of civil nature, but the criminal color has.
Give
been
it,
given,
madam.
and the
There's no
communication-
interim order?
No, your Lordship. it's
Give
not
it.
in-
Come, give it,
Any
yes.
day of the next week.
No, you don't choose the date. I will choose it, yes.
Yes,
My
your
lords, the petitioner is in judicial custody, my lords. The police
Why?
authority
Why?
My lords, one NI act, my lords, convicted case.
Sir, in default sentence.
Yes, my lords, but it was not gone through the procedure, my lords. The police authority colluding with the complainant
Give
has.
it, Monday.
My lords, kindly have it on tomorrow, my lords.
No, give it, yes.
My lords, fresh matter at 230, my lords, in spite of the interim order granted by this honorable court, my lords, the respondent ED has issued the attachment notice, my lord, to the
No
petition.
problem. There's no urgency.
Is urgent,
230.
my lords.
Give it, yes.
Your Lordship, the petitioner is and your Lordship, this
Give
charge
it.
sheet is be filed. Charge sheet will be filed next week, your Lordship. We require a stay in this matter.
It will come Monday or Tuesday.
The petitioner is a non-executive director, but NCLT proceedings.
Give it,
have
all
been
the memos kodi.
Against the company and other directors.
138, right? Give it, yes.
My lords, for the extension of
date,
interim
Give
order, my
it.
lords. Kindly. My lords, pending matter, I don't have the benefit of interim order, my lords.
We'll see, give it, yes.
Pending matter.
Why have you come here? Come this side.
My lords, kindly have it on tomorrow, my lords. Attachment warrant has been issued. my
Monday,
lords.
kodi madam. Yes.
Lordship,
Ah,
stay vacant.
ಆಯ್ತಲ್ಲ ಎಲ್ಲ? ಕಾಮಾಕ್ಷಿ ಪಾಳ್ಯನ? Domestic violence. ಆಯ್ತಾಯ್ತು. ಪರವಾಗಿಲ್ಲ ಕೊಡಿ, ಏನಾಗಲ್ಲ. ಏನ್ ತೊಂದ್ರೆ ಆಗಲ್ಲ. ಇನ್ನೊಂದು ಡೋರ್ ಓಪನ್ ಮಾಡ್ತೀರಾ ಬಿಡಿ ನೀವು ಕೊಡಿ. I have stayed. Okay, yes. Tomorrow. Monday pending matter bad. Tuesday or Wednesday. No, let it come on Tuesday. Give it. Yes. ಪಾದಯಾತ್ರೆ ನಾಳೆ ಕೊಡಿ. Yes. Special court ಯಾವ್ದಾದ್ರು ಮೆಮೊ ಇದ್ರೆ ನಾಳೆ ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ.
Lordship, vacating for stay.
Vacating stay, please give. Yes.
Completion of the trial, 2014 CC.
Give it, sir. Yes.
My lord.
Against the doctor, correct ಆಗಿದೆ. You have not informed. ಏನ್ ಪರವಾಗಿಲ್ಲ. No. ಆಯ್ತು, no urgency in that. Yes.
My lord.
Fresh matter ಅಲ್ವಾ? ಬರುತ್ತೆ.
Madam. My lord. Co-accused ಗೆ stay ಸಿಕ್ಕಿದೆ, my lord. Co-accused ಗೆ stay ಸಿಕ್ಕಿದೆ. 6ನೇ ತಾರೀಕು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಇದೆ, my lord.
ಕೊಡಿ.
My lord.
ಮಂಡೇ ಹಾಕು. ಯಾಕೆ? ಆಯ್ತು.
My lord, it's arising out of 498. Petitioners are 78 years old age, my lord. Pending any date, my lord.
No date, give it.
Single
Yes.
individual has filed 3 FIRs against him. We have got a stay in the single case and subsequent another FIR has been.
All right, give it. Give the memo.
My lord.
Memos ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ.
My lord, now the matter is before the trial court for committal for the sessions court, my lord.
When?
Next week, my lordship.
Date ಯಾವತ್ತು?
In the month of July, my lordship.
I will post it, give it. Yes. When?
There's an accusation against the employee. Based on the accusation against the employee, the owner is also implicated.
That Kurg.
I will show you, not how serious, just please see, I will show you with documentary record. The entire allegation is contradicted by documentary record. But I'm not for the employee, I'm for the homestay owner. But I am for the homestay.
No, Monday ಬರ್ಲಿ.
Bail condition relaxation.
Those homestays need to be regulated. Yes.
My license has been cancelled. Your
Correct ಆಗಿದೆ. Correct ಆಗಿದೆ.
Let come on Monday.
Yes.
There are 48 vendors. But one of the vendors has filed a complaint against him. What the 420 register.
Not such state the matter, no. But day after, not next time, not the police has by drop 420. I filed a charge sheet under 418. That will be taken up Monday, no.
Pending.
No, no, I filed
Fresh
fresh petition.
Monday or Tuesday ಬರುತ್ತೆ. ಕೊಡಿ ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಡಿ.
Condition relaxation.
Give sir.
Husband's petition.
Give it. ಎಷ್ಟೊತ್ತು ತಗೊಳ್ಳಿ ಮೆಮೋಗಳು ಕೊಟ್ಬಿಡಿ.
Filed in last week of April. Was filed on last week of April. There is an NBW issued against the husband. So
It is bail
Why you have not paid?
blood. In fact, I was thrown out of the home.
You were thrown out.
I was thrown out of the home, but and she is earning more than me, my lord. That is the only difficult. And even the appeal before the appeal period, my lord, NBW has been issued.
All right.
Maybe taken on Monday. My lord.
Monday.
This matter, total matter for 4 o'clock, 15 each. This matter is regarding maize farmers, popcorn maize farmers.
Ah.
This matter for 4 o'clock.
Yes.
Okay.
Okay. Vacating stay ತಗೊಳ್ಳಿ.
My lord, one matter.
ಕೊಡಿ ಕೊಡಿ.
One matter, my lord.
ಡೇಟ್ ಕೊಡಲ್ಲ ಸರ್. ಕೊಡಲ್ಲ. ಡೇಟ್ ಕೊಡಲ್ಲ. ಕೊಡಲ್ಲ. ಪರವಾಗಿಲ್ಲ.
One matter, my lord, 230, requesting for 230, my lord.
Why?
My lord, the petitioner is a government employee, not police people are harassing, my lord, for that reason.
Give it, yes. Take bail. No 230. Yes.
Tomorrow, my lord.
Withdrawing, give
Requesting
it.
for tomorrow, my lord.
List 2? 80. 80 charge sheet format. Oh, ನೀವು ಗೊತ್ತಾ ಇವ್ರಿಗೆ charge sheet format ಅಂತ.
Requesting for tomorrow, my lord.
No, tomorrow also. Yes.
Withdrawal, my lord. Till number 14 and 15.
Second list. 14, 15 in terms of the memo withdrawn.
2025 matter, my lord. Matter was
ಕೊಡಿ.
before to vacation.
ಆಯ್ತು ಕೊಡಿ ಕೊಡಿ.
That's 80 and city liberty to calculate.
Charge sheet, yes. All the cases.
List number 1, fresh matter, still number 1.
Petitioner.
In split.
Yes.
Split up.
The accused number 5 ಗೆ ತಾವು ಪಾಸ್ ಮಾಡಿದ್ದೀರಿ. This
Page.
petitioner has accused number 3.
Page.
ಅವಾಗ ಸಿಕ್ಕಿರಲಿಲ್ಲ ಸರ್ಟಿಫಿಕೇಟ್.
ಕೊಡಿ. The petitioner, accused number
3 man.
Accused number 3 is before the court, calling in question the continuance of proceeding in CC 19425 of 2018 hyphen a split up charge sheet drawn against the petitioner for his absence during the trial. The offense alleged against the petitioner along with others, the ones punishable under section 399 and 402 of the IPC. Accused number 5, who was also not available for trial at that point in time, was before this court in criminal petition 10021 of 2024. This court, by an order dated 19th December 2024, has obliterated the crime qua accused number 5 on the score that the other accused 1 to 3 have all been acquitted pursuant to a full-blown trial. The reasons so rendered therein would become squarely applicable to the case at hand, as the present petitioner is the co-accused. Quote the entire order. For the very reasons rendered therein, allowed cost.
Please, public.
Number 2,
In the meantime,
3,
My lord, 2.
state, sir.
3,
Badwa.
The best one.
Yes.
3.
There is no such words used in the entire charge sheet.
In the meantime, yes. ಗೊತ್ತಾಗುತ್ತೆ ಮೇಡಮ್ ಅವ್ರಿಗೆ. Yes.
4.
Allegation is a misappropriation.
Truck terminal.
Truck terminal.
ಅದು ಬೇರೆ ಅಕ್ಯೂಸ್ ಗೆ ಮಾಡಿದೀನಾ?
No more.
Otherwise notice. Serious misappropriation.
No, here, my lord, there's no fund transfer at all. Our check has not been deposited. Check, in fact, my lord, has been returned back.
ಲೋಕಾಯುಕ್ತನಾ?
No, my lord, it's a FIR registered, my lord, and 465 and 420, 406 and 408.
Why is it ಮುಂಚೆ ಏನ್ withdraw ಮಾಡಿದ್ರಾ?
ಇಲ್ಲ, office note, my lord, now I am told it is with respect to typed copy of certain documents.
ಅದಲ್ಲ ಸರ್ಕ್ಯುಲರ್ ಅಲ್ಲಿ ಇಲ್ಲೇ ಬಂದಿದೆಯಲ್ಲ ಯಾಕೆ ಅಂತ. Because it's there is one additional SPP, 2 emergent notice. We'll see, let him go through it and come. List the matter on 15th in the fresh matters list. The learned additional SPP shall go through the papers and make his submission. That's misappropriation, that's why.
But my lord, though check was given, it was taken back the very same day. So there is no fund transfer at all.
We'll see,
At
let
best,
him,
what can be attributed is.
we'll hear him only in pass out.
Please.
Yes. Next.
5.
multiple
Informed that,
FIRs.
The charge sheet has been filed,
Ah,
so liberty may be given.
Charge sheet format. Gota madam ಅವ್ರಿಗೆ? Yes, next.
The respondent.
Husband and wife, partners.
No partners, my lord.
ಮತ್ತೆ?
It's an individual, husband and wife.
ತೊಂದ್ರೆ ಇಲ್ಲ. ಚೆಕ್ ಒಂದ್ರಲ್ಲಿ ನೀವು ಸೈನ್ ಮಾಡಿದಿರಾ, ಒಂದ್ರಲ್ಲಿ ಹಸ್ಬೆಂಡ್ ಸೈನ್
No, my
ಮಾಡಿದ್ರೆ.
lord.
ಇನ್ನೇನು ಇದರಲ್ಲಿ
No, sir.
Mahesh signs it, petitioner is Rekha signs it, petitioner is Mahesh.
No, my petitioner is husband.
ಅದೇ, yes.
Check is not belongs to the husband, my lord.
Belongs to whom, sir?
Wife. We are not executed, drive any check in favor of the.
All are signed by the wife, is it?
My lord, no.
Then?
On behalf of the petition,
No,
wife.
yes. The learned counsel for the petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement. List the matter on 16th in the fresh matters list. 6, 7, 8, more same order. 9. Petitioner is accused number 6. A perusal at the summary of the charge sheet would not indicate even a titter of offense that would become the ingredients of the ones that are alleged. In that light, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. It is made clear further proceedings against the others shall continue. Next.
Charge sheet file.
10 ನಲ್ಲಿ ಇದ್ರಲ್ಲ
Charge sheet file.
ಒಂದ್ ನಿಮಿಷ ಮೇಡಮ್, ವಿದ್ಯಾ ಮೇಡಮ್, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದೀರಾ? ಚಾಲೆಂಜ್ ಮಾಡಿರೋದೇನು?
Charge sheet.
ಚಾರ್ಜ್ ಶೀಟೇ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು.
10 days.
ವಾಟ್ ಇಸ್ ದಿಸ್? ಎಸ್,
So crime ಅಂತ ಕೊಟ್ಟಿದೆ.
ನಿಮಗೆ ಕೊಟ್ಟಿರೋ ಕಾಪಿ ಬರೀ ಕ್ರೈಮ್ ಇದೆಯಾ? ಎಸ್,
326 ಇದೆ, my lord.
ಪೇಜ್ ಮೇಡಮ್, ಪೇಜ್ 52 ಅಲ್ಲಿ ಒಂದು ಪೋರ್ಷನ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ. ಯಾವುದು?
Bill number 9.
ಚಾರ್ಜ್ ಶೀಟ್ ನೋಡಿದ್ನಲ್ಲ ನಾನು. ಇಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಫಾರ್ಮ್ಯಾಟ್ ಮಾಡಿ ನೋಡಿ. Vidya madam, if it's crime, you'll have to challenge the charge sheet because charge sheet is filed now.
Yes, ma'am.
Then challenge the charge sheet and move it, will grant it. Yes. Then charge sheet format. Yes. Next. ನಾನೆಲ್ಲೋ ನೋಡಿದ್ನಲ್ಲ, ಇರ್ಲಿ ಬಿಡಿ. 10 page 52 ಅಲ್ಲಿ ಒಂದು ಪೋರ್ಷನ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ. If this be the allegation against the petitioner, permitting further proceedings would become an abuse of the process of the law. Therefore, there shall be an interim order of stay of further proceedings qua the petitioner till the next date of hearing. 1 HCGP 2 emergent notice. Next. Tag with page 50, same order, 50. Petitioner is accused number 13.
13, 15.
Notice 1 HCGP.
My lord,
Ibru HCGP. Next.
My lord, in criminal petition number 3780, my lord, this honorable court, my lord, has granted stay, my lords.
ಯಾವ್ದದು? Serial number?
12, my lords.
Which is, where is that order?
Protest, my lords.
ಕೊಡಿ, tag this petition along with so and so, same order, 1 HCGP 2 emergent. ನೀವೇ complainant, ನೀವೇ.
Grateful, my lords.
13.
I'm appearing for the petitioner, my lord. My lord, my humble submission is to stay all the further proceedings in CC number.
Any amount of humility will not work.
Petitioner is a rowdy sheeter.
I will not stay.
My lord, there is no prima facie offense in this, my lord.
ಏನ್ prima facie offense? ಪೊಲೀಸರು ಗಲಾಟೆ ಮಾಡ್ತೀರಾ?
My lord, ಆದ್ರೆ ಇದರಲ್ಲಿ 132 section, it states about.
132 and 353 of the IPC, sir.
Yes, sir. It states about criminal force or assault.
ಹೌದು.
But sir, he has not done any physical acts, sir. It is.
ಮತ್ತೇನೆಲ್ಲ verbal?
It is only verbal, sir. I don't consider it as verbal. Even it is a fake, it is due to political rivalry, sir. It can see in the complaint sheet as well, my lord.
Yes, the petitioner is before the court calling in question. The charge sheet ಆಗಿದೆಯಲ್ಲ?
ಆಗಿದೆ, my lord.
Calling in question the proceedings in CC so and so registered.
ಇಲ್ಲಿ complaint.
Wait, please.
Fine.
Registered for offences punishable under section 132 of the BNS, which is 353 of the earlier regime, the IPC. Section 353 of the IPC requires use of criminal force to deter a public servant from functioning, for performing his public duties. A perusal at the summary of the charge sheet nowhere indicates that the petitioner has used any criminal force to stop the petitioner from performing his public duties. In that light, there shall be an interim order of stay of further proceedings quay the petitioner till the next date of hearing.
Much obliged, my lord.
14,
One HCGP to emergent. ಅದು ಆರ್ಡರ್ಗಳು ಕೊಡಿ ಬೇರೆ ಕೇಸ್ ಎಲ್ಲ
For 40 and 41.
40, 41 tag along with same order HCGP emergent notice.
15,
319 and 138 emergent notice to the respondent. There shall be an interim order of stay of the order impugned till the next date of hearing. List the matter on 2nd July. Next.
16,
Naushad. Horrible allegations, yes. No representation on behalf of the petitioner. List the matter on 9th in the fresh matters list.
17,
Prakash.
Petitioner, sir.
138.
Yes, sir.
ಅದೇ ಬುಕ್ ಯಾಕೆ ತೆಗಿತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ.
ಫೈಲ್ ತೆಗೀರಿ.
Same 11 ಗೆ ಈಗ ಏನಾಯ್ತಲ್ಲ ಅದೇ ಸ್ವಾಮಿ ಸೇಮ್
ಸೀರಿಯಲ್ ನಂಬರ್
ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಗೆ ಏನ್ ಮಾಡಲ್ಲ ಸೇಮ್ ಇಟ್ಸ್ ಆಲ್ಸೋ ಸೇಮ್ ಇಟ್ ಇಸ್
ಏನು 11 ಪೇಜ್ 50 ಸೇಮ್
ಹಾ ಸರ್
ಆಲ್ ಇಟ್ ಸೇಮ್ ಪೇಜ್ 7 ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಗೆ ಏನ್ ಮಾಡಿದೀನಿ ಅದನ್ನ ನೆಕ್ಸ್ಟ್
18,
the petitioner is accused number 2 the alleged of the offense punishable under section 85 of the BNS inter alia. A perusal at the complaint charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ sir.
A perusal at the complaint would not indicate any offense against the mother-in-law that could become the ingredients of the offenses under section 85 of the BNS. Therefore, there shall be an interim order of stay of further investigation quay the mother-in-law accused number 2 till the next date of hearing. Next.
19,
Petitioner's counsel. Property dispute.
Heard the learned senior counsel V. Shankar Narayan Rao appearing for the petitioner. A case that is registered in the year 2005 is still languishing before the concerned court on it being repeatedly remitted back on the challenge to the order of cognizance. A perusal at the complaint itself would indicate that the criminal law is set into motion on pure civil and disputes which are ostensibly civil in nature. In that light, there shall be an interim order of stay of further proceedings before the concerned court only if the charges are not framed and trial has not yet commenced.
Charges are framed.
Framed, huh?
Charges are not framed. Charge sheet is, I'm sorry.
Charge sheet. Yes. All right, yes, next.
I'm obliged.
One HCGP to emergent notice, next.
20,
Case and counter case.
Please.
Notice, one HCGP to emergent notice.
In the counter case.
Counter case stay ಆಗಿದೆಯಾ?
Stay ಆಗಿದೆ.
ಕೊಡಿ ಒಂದು ನಿಮಿಷ. Tag ನಂದ ಮೇಡಮ್. My order. Tag along with so and so. Madam, ಈ ಆರ್ಡರ್ ನ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡಿ. Tag along with so and so in the light of the interim order subsisting in the counter case, there shall be an interim order of the kind that is granted by the coordinate bench in the case at hand as well.
Much obliged.
One HCGP to emergent notice.
Please, your lordships, in this
The
matter.
petitioners are accused 1, 2 and 3, the husband, mother-in-law and father-in-law of the second respondent complainant.
College crime, my lordship, charge sheet has been filed.
I was not aware of it, my lords.
Now you are aware.
Now I am aware, my
Yes,
lords.
now
I'll
you do it. Yes.
I'll do it immediately.
Yes, liberty. Yes, charge sheet format. Next.
Grateful.
ಆದ್ರೂ ಹಸ್ಬೆಂಡ್ ಕೊಡಲ್ಲ ಹಾಕ್ಲೇಬೇಡಿ.
Yes, my
2 and 3 will grant.
My lords, there was already a joint settlement in this matter, then the FIR and the charge sheet.
Oh,
is-
then we'll see. Yes, you file it.
Yes, much obliged, much.
22,
The petitioners are accused 1 to 5 are alleged of offense punishable under section 85 inter alia, 85 of the BNS inter alia. A perusal at the charge sheet ಆಗಿದೆ?
Charge sheet.
A perusal at the summary of the charge sheet would indicate all the offences being alleged against the husband accused number 1 and none against the others, i.e. 2 to 5. Therefore, there shall be an interim order of stay of all further proceedings accused 2 to 5 2 to 5 till the next date of hearing is made clear, no proceedings are stayed qua the husband accused number 1.
On submission, accused number 1 gunu yakendre she deserted the the husband. Subsequently, I gave a notice for restitution of conjugal rights. And I filed a complaint on 14/8/2005. She filed a complaint on 16/11.
Parva. That argument will nadiyal. Yes.
Great.
23.
So the petitioner, the section under 69 of the BNS, my lords.
So what?
The petitioner and the respondent are known to each other from past 2014, my lords.
Oh.
So subsequently, when the relationship got sour, the complainant.
Got sour? Why?
Because of the too much of possessiveness of the.
Too much of
by the complainant, my lords.
You should be happy somebody is possessive.
And she is troubling the mother, sister, and the sister has also filed a complaint.
Madhuvene agilla, troubling mother and sister.
Yes, my lord, she is interfering too much into the family of the petitioner, and she has caused too much of harassment, my lords. Like she is calling daily 100 or 200 times the petitioner, calling the petitioner through call, almost like 200 times, my lords, per day. And when he is working and if he is not receiving the call, she is like threatening, I will go to the suicide. So under these circumstances, my lord, she has been harassed, and then she filed a complaint before the police station, stating that
you have a genuine cause.
My lord.
The petitioner, parents idara ille?
Only single person, my lord.
The petitioner is the petitioner and the respondent complainant are known to each other now for 12 years. They were in a relationship for a long time. The relationship turns sour and ends up in a breakup. Incidents that have happened in the year 2022 are sought to be projected by the complaint in the year 2025, and all those incidents being consensual acts. Therefore, there shall be an interim order of stay of further proceedings qua the petitioner till the next date of hearing, failing which it would run foul of the judgment of the apex court in the case of Dhruvaram Mudalayar Sonar, 2019-18 SCC, 2018-19 SCC, page 181. Yes. Next.
24.
497, 24 and 25 both same. The learned, ಇದು additional SPP ಗೆ ಹೇಳಿ madam. Learned additional SPP BN Jagdish is directed to accept notice for the respondent, secure instructions and make his submissions 11th, 10th in the fresh matters list. Yes.
25. 26.
25 same, madam. Sorry.
Hearing for the respondent number 2 in this case, your lordship. The case
The petition, all,
mediation is going on, your
Going
lordship.
on.
9/6 ನಲ್ಲಿ mediation ಗೆ next date ಕೊಟ್ಟಿದ್ದಾರೆ.
ನಿಮಗೆ ಗೊತ್ತಿಲ್ವಾ?
Mediations ಇದೆ, but
List the matter on 15th.
They are not.
The learned counsel for the petitioner, parties submit that the parties are before, the parties are striking out a settlement before in a mediation process. Yes.
Some past ತುಂಬಾ ಸರಿ mediations refer
Your
ಆಗಿದೆ,
lordship,
ಆಗ್ತಾ
last
ಇಲ್ಲ.
mediation ಅಲ್ಲಿ
Even
NCK
the
sir
matter is
ಯಾವ್ದ್ರಲ್ಲೂ
set down for
ಬಂದಿಲ್ಲ. This is the
HPC,
first
my
case
lordship.
where they are
Matter is
present
set
here.
down
ಈ ಪ್ರಾಬ್ಲಮ್ ಏನಂದ್ರೆ ಸ್ಟೇ ಮಾಡ್ಬಿಟ್ರೆ ನೀವು ಹೋಗೋದೇ ಇಲ್ಲ.
My lords, even ನಾವೇ settlement ಆದ್ರೆ ನಮ್ಗೆ ಅನುಕೂಲ.
They are requested to bring all the accused in this case, your lordship, for the mediation. If stay has been granted, they will be not
2 and 3
appearing.
are the parents, my lordships. 4, 5.
Husband, all allegations are against the husband. Why do you want others?
ಅವರು ಬೇಕು ಅಂತ
ಅವರು ಬೇಕು ಅಂದ್ರೆ ನಿಮಗೆ ಬೇಕಾದ್ದೆಲ್ಲ ಆಗಲ್ಲ.
your lordship, mediation ಅಲ್ಲಿ ಬರೋದು.
Mediation ಅಲ್ಲಿ ಕರ್ಕೊಳ್ಳಿ. There shall be an interim order of stay against all other accused except the husband, notwithstanding the fact of the mediation in process, only to enable peaceful mediation.
Yes.
Yes.
Great.
27.
May I beg leave, lords?
Folks,
Lords, there's an allegation of certain offences under the POCSO Act. Lords, the ground, lords, on which we are before this honorable court.
Doubt?
No, but the ground on
Ground?
which we are before this honorable court is. Lords, there are certain materials which have been tendered by the accused, and lords, the persons for whom the accused has vouched for. Lords, here is a case where it pertains to a disciplinarian headmaster. Lords, the victim, lords, was engaged in an act of ragging
during the relevant point of time, owing to which a student consumed poison in the school. Disciplinary action was taken. The STMC also brought the said fact to the notice of the jurisdictional police later on. After this gentleman was transferred from the said school, 8 or 10 months from the date of the incident, this complaint has been lodged. Now, there are, your lordship will always say this is a POCSO case. There are allegations where, or the allegations of bodily touches, nothing beyond that, bodily touches. And in any other case, I would say it is unpardonable where it pertains to a schoolmaster. But kindly see, 80 I would just point out one document at 102. 34 witnesses on my behalf. They have tendered a statement to the police. Does your lordship get it? 102. This includes the STMC also there for a moment at 105. Monitoring committee is also there, and every member of the monitoring committee has signed and sent this declaration. It is acknowledged by the police. Now, the Supreme Court in these cases say that the investigating officer is by and large entitled to exclude such evidence or statements which he shall deem fit from the course of the filing of the charge sheet. But he shall have to make a list of all those statements which he has excluded. This was exactly the law laid down by the Supreme Court while directing all states to amend the rules 2021. My lordships are aware. May I just pass on this? This the previous one, 2021.
You are the headmaster, huh?
He was the headmaster of the school. He was the headmaster of the school. No,
what was the age of the student?
Then she was around 15 years, 15, 16 years. 15, 16 years. Now, thereafter, the Supreme Court relying on this. Now, Karnataka is one of the few states who has not implemented the mandatory guidelines of the Supreme Court. In that 2021 judgment. I'm so sorry. May I just pass this? Now, Telangana was the Telangana High Court has already ordered that these guidelines will have to be incorporated. I'm sorry.
No problem.
Now, Sarala Gupta, the Supreme Court has said it has gone one step forward in 2025. That not only the investigating officer is he has to make a list of that documents, but if such documents and statements are of sterling value, the right of the accused says at the time of discharge also, he can summon them under 91 and place reliance.
File discharge.
Correct. For me, even to file discharge, I need the documents which the prosecution has relied upon. Or if they say I am not going to rely upon these documents, kindly see this is Sarala Gupta for one moment. 27.
Has that stage come?
Yes, now we are exactly at the cognizance has been taken. Then it is for hearing before charge. Now all we are saying is now where are these statements? The statements of 34 different people who have tendered the statements before the police. Their names are also not found in the charge sheet. Kindly see investigation. If I could borrow your lordship's words in a different context.
You urge all that.
I agree. I agree. For a moment, if for one moment, if I could just borrow your lordship's own words in a different context. Investigation is also a pursuit and voyage to discover the truth.
Absolutely, sir.
Is it not? Now, the only point is if 34 different people have their versions differently, I'm saying. Now, I'm dealing with a POCSO case, and in this matter, the reverse onus is there. I would rather say, it is treated as reverse burden itself. Now, where are these statements? I would only request, if the records be summoned, I would request the investigation diary, if it is to be taken note of. These people have tendered the statements. Now, kindly see, in the charge sheet. None of these people, are, their statements are not there. 34 different witnesses, who my ex-students. 34 different people, including my ex-students, who have come to vouch my character and what is the work I have undertaken in the past 6 years. Why there is an amount of, I would say, there is an amount of vengeance against me in the school. Interstate certain schoolmasters. All of that has been narrated. They have tendered the statements. The moment an FIR was registered, Because all these people went before the authorities, Binots, and Binots, once the authorities did not take heed of them, they also went to the jurisdictional SP, and we were redirected. The police have taken the statements. I'm only, Binots, only concerned what happens to those statements. Because, Binots, Sarla Gupta, para 27 and 31 for a moment, Binots.
Yes, sir.
Para 27 and 31. But I'm so sorry, but I have to place that judgment, Binots, of that Supreme Court, where, Binots, the Supreme Court has said one has to necessarily, Binots, make a list of all these documents. Binots, it starts from 22. Then, Binots, may I come down to para 36 Binots for a moment?
Yes, sir.
Now, Binots, the right of an accused to seek production of the documents not relied upon by the prosecution.
Under 207.
Please, Binots,
Yes.
it's rather, Binots,
207 stage is yet to come, sir.
Binots, it is not
207 ಅಲ್ಲಿ, or 91 application.
91 Binots, 91.
You can file, sir.
9 Binots, I'm just pointing out, Binots, there is an inherent lapse in the charge sheet. Binots, what the court
Take
has said.
advantage of that, sir.
Binots, the court, no, Binots, it is a defect, Binots, where your lordships can say that, at least produce that.
Take advantage of
Binots, it's a defect where they can
At the
produce that.
appropriate stage, you take
Binots,
advantage.
may I request only this, Binots, let that list of
You
statements be.
think I will spare a headmaster who has touched the breasts of a
Please don't,
15-year-old child?
Binots, if that is a bit of it is to be true, please don't.
No,
Binots,
I
but-
will not.
Please, Binots,
Yes.
I would rather say, Binots, please don't.
Yes.
Please don't. If that is the case, if that is
That is
the
the
case.
case.
Binots, that is the case made out, alleged by
ಅದಕ್ಕೆ ಅಲ್ಲಿ.
alleged by the prosecution.
Anything else?
Binots, yes, Binots, yes. Binots.
Yes.
For one moment. Binots.
Yes.
Now, may I just, Binots, 36 for a moment, 36 there. Now we come to the decision of this court in criminal trial guidelines.
That is not applicable, sir. Anything else?
This is the.
No, I will answer it, no problem.
Please,
Yes.
not, may I just point out for a moment. May I just point out?
Yes,
Binots,
sir.
May I just point out? What
Yes.
Justice, Binots, his lordship's oak had.
No problem, sir. That is not applicable at all. I will answer that judgment, don't
But
worry.
I'll just
Yes.
point out, Binots, how it might be relevant.
No,
for
it
one.
won't, sir.
Binots, I may just.
All right, yes.
Because, Binots, if your lordship's, Binots, there's one lapse from me that I have not produced that 2021 judgment.
Not necessary, sir.
Binots, your lordship will see that.
No, that I am aware, sir. Not a problem.
Yes, Binots. Now your lordships could also be aware, Binots, in that, Binots, the Supreme Court has said, every state, Binots, has been mandatorily directed. Binots, that the principle, the guidelines which the Supreme Court has set out, Binots, in the 2021 judgment, must necessarily form, Binots, a part and parcel of the rules, the criminal practice rules. And, Binots, so far, Binots, in the southern states, barring Telangana, Binots, no other state has implemented that to my knowledge, Binots. In fact, in Karnataka, Binots, we have not given implementation. So what we could rely still, Binots, is the directives of the Supreme Court in the 2021 judgment. Now, Binots, 2021 judgment, Binots, was again Binots, taken into consideration in this judgment. Binots, the court went on one step ahead. In 2021, Binots, the Supreme Court said the investigating officer has to collect every bit of evidence. Please, every bit of evidence. Wanted, necessary, unnecessary, irrelevant. Now, Binots, he has a right to tender such evidence which he feels, Binots, relevant for the case of the prosecution. So what happens to the other evidence, Binots, which the investigating officer feels it is irrelevant? Binots, he has to make a list within the same charge sheet and, Binots, tender the list along with the charge sheet that this is the evidence which I am not relying upon. And this is the evidence collected but not relied upon. And, Binots, kindly see, now here is the difference. Binots. Here is the
Perfect submission before the trial court.
Binots, here is the difference.
Anything else, sir?
Binots, yes, Binots, yes, Binots, but this is.
You are going on and on. You can't go until the cows come back.
I would only just.
Yes.
Can your lordship just see?
This is 482, sir.
Because I see, if there is a procedural defect which
No,
goes to the root,
procedural defect, yes.
Binots, it vitiates the
Procedural
entire,
defect, take advantage in the trial.
Binots, it vitiates the entire process. Binots, it
No
vitiates the entire
procedural
process.
defect at all here.
Now, Binots, if your lordships could just see only
Now
one.
I'm going to answer it on merits. I will not permit you to withdraw also.
It's only persuasive.
No,
effect.
whatever it is. Now, if you argued at this length, I'm going to answer it on merits only. Yes.
Binots, all right, but I understand where your lordship is. Binots, ಒಮ್ಮೆ ತಾವು 37 and 38.
ಏನ್
because
ಪರವಾಗಿಲ್ಲ, ಅದು ಕೋಟ್ ಮಾಡ್ತೀನಿ ಅದ್ರಲ್ಲಿ, ಜಡ್ಮೆಂಟ್ ಅಲ್ಲೇ ಕೋಟ್ ಮಾಡಿ ಡಿಸ್ಟಿಂಗ್ವಿಶ್
know
ಮಾಡ್ತೀನಿ.
that, I know that your
You
lordships
don't
are
worry,
not,
sir.
I know that your lordships have seen it.
No
Can
problem, sir.
can your lordship just look at it from my perspective?
No.
In light of the current
No,
facts,
sir.
for one moment. All right. Now, my lords, there are statements. There are statements. It is not a part of the investigative record.
No problem.
Now, my lords, what happens now in the course of discharge? My lordship knows. My lords, right from 2007, 2018. My lords, all the courts have said you can make use of the. You can make use of the statements which are a part and parcel of the charge.
Yeah, correct, sir. No problem.
Is it not?
Yes, sir.
And as if, because I come from a civil side, I could compare this to a 7 Rule 11, where on face, possibly someone else sees it and says these are the defects which are emanating out of it, and per se, even if a trial goes on, nothing can be made out of it. This is the test in discharge. Now, if there are materials which the investigating officer finds it, does not rely upon it, and he does not submit to the court, is not the investigation wish. This is not something which possibly the investigating officer will have to answer. What has happened to his crime diary, where all these statements are recorded? Is that not, should that not be made as a parcel to the court to show that I have recorded, it is not necessary? That is where the Supreme Court said, 38 nearly. They said, therefore, it is held that a copy of the list of statements, documents, material objects, exhibits that are not related.
ಯಾಕೆ ಇರ್ಲಿ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಕಾಪಿ ತರಕ್ಕೆ ಅಂತ ಅವ್ರು ಒಬ್ಬರು.
ಇಲ್ಲ.
ಯಾಕೆ ಬೇಕಾಗಿತ್ತು ನಿಮ್ಗೆ? ನೀವು ಕೇಳಿದ್ರಾ?
38 ನಲ್ಲಿ. As held by this court, the object is to ensure that the accused has knowledge of the documents, objects, etc. in the custody of the investigating officer, which are not relied upon, so that at that appropriate stage, the accused can apply for invoking the provisions of 91 CRPC. And for providing those copies of documents which are not relied upon by the prosecution. This decision upholds the right of the accused to apply for the supply of copies of the documents which are not relied upon by the prosecution at an appropriate stage by making an application to the court.
Make an application.
Now, absolutely. I know that your lordships will.
Yes.
That is
the
not.
petitioner.
All I wanted to point out was this is not even a
petitioner
charge sheet.
Sole accused in special case 5 of 2026 stands at the doors of this court. I am not going to permit to withdraw.
Can I apply for discharge?
No, that's withdrawal only.
Can I apply?
I told you at the beginning.
I had to make my effort.
I have to make your case.
I have to make my
So
effort.
how can
It's a persuasion.
you think this court would spare a headmaster? As I told you, the 15-year-old child, you have dragged her, kissed her.
Principally.
What principally? No, then how can you? What is this? You're trying to make submissions. 91 and 207 you file when the trial commences. When 482 jurisdiction on this to a man like this? Unpardonable, sir.
Allow me to urge these grounds in a discharge. Allow me to.
You're a headmaster.
Absolutely,
Nata?
I know that.
What kind of teacher are you?
So, if it is so, it cannot
If
be
it is
pardoned.
so, there are complaints. There are statements. 23 witnesses are there.
I can take your lordship all through one of them. I know, but it is a 482.
Then
nothing there. Nothing.
What?
There.
Nothing there.
I can point out nothing there in that.
Repeatedly, you drag her, kiss her.
There are allegations.
Squeeze. I don't want to use that word again.
Please,
what is
it's
it? Child, sir.
Please.
Yes.
Could it be then to subject to those? Please.
Discharge is discharge format.
Grateful for the audience.
28.
In-laws.
The accused number 1, the petitioners are before this court calling in question a charge sheet ಆಗಿದೆಯಾ? Calling in question registration of a complaint by the second respondent complainant, the wife of the accused number 1 husband who is not before the court. The petitioners are the mother-in-law, father-in-law and the other family members accused 2, 3, 4, 5. In the accused 2, 3, 4, 5, in the light of no ingredients, even prima facie made out against these petitioners, permitting further investigation would become an abuse of the process of the law. Therefore, there shall be an interim order of stay of further investigation qua the present petitioners till the next date of hearing.
59.
In the meantime, next.
30,
ಇದು ಅಷ್ಟೇ, horrible. No representation of the petitioner. List on 10th in the fresh matters list. Next.
31,
In the meantime, yes.
Here for the petitioner my lords. The petitioner is the sole accused in the matter.
108.
108 my lords.
Still crime stage. Investigation papers kodi. List the matter on 10th in the fresh matters list. Investigation papers be placed before the court on the next date.
Oblige my lordships.
33,
33 and 36. Hmm.
Lord, the learned judge, my lord, has taken the cognizance first and then he has directed for recording of the statement. Also similar.
Your
case-
statement.
Out.
Hmm.
This procedural irregularity. Even otherwise, my lord, the offense and defamation, the complainant is someone else. Even if he says that something bad words are used against
No,
him,
whatever, if there is procedural aberration, we'll send it back.
procedural irregularity.
My lords, one submission.
ಹಾ ಹೇಳಿದ್ದಾರೆ. ಯಾರು ಬೇರೆ ಹೆಸರಿದೆ?
Our senior out of station is Natashan Murthy is out of station.
ಹಾ.
CRLP 6612 of 2025 was filed by last year, another accused. It is still pending without any stay.
ಇದು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಪ್ರಾಬ್ಲಮ್ ಏನಾ?
My lords, it is a abuse and misuse of this one, police powers of
You are a
CST Act. Your lordship's judgment on last 13575 culminated into a charge sheet where all the offences of two of police officers and his son and other co-accused have been charge sheeted by the same police department.
Same petitioners.
Please, my lords,
Petitioners,
please,
but
my
he
lords.
did one more new proceedings for defamation, only under 499 is initiated. But complainant is Mr. Abhay, not these people. Yurgo Samanda.
Criminal conspiracy is set up.
Wait, sir.
As lordship, as lordship rightly observed, procedural irregularity there.
If it's procedural irregularity, we'll send it back to set it right.
Please.
Please, may I? Para 5 my lord, ಅದರಲ್ಲೂ ಹೀಗೆ ಇದೇ ತರ.
ಅವ್ರಿಗೊಂದು ಕೊಟ್ಬಿಡಿ ಗಣೇಶ್. ಪ್ಯಾರಾ?
5 my lord.
ಪ್ಯಾರಾ 5 ಏನಿದೆ ಪ್ಯಾರಾ 5 ಅಲ್ಲಿ?
But in
Oh, ಪ್ಯಾರಾ, yes, yes.
page 8, my lord, sorry.
Major illegalities. Yes, Ganesh, we'll send it back following this. ಅಲ್ಲಿ ಸರಿ ಮಾಡ್ಕೊಳ್ಳಿ ಎಲ್ಲ. The petitioner, ಇದು both the orders. The petitioners are before, ಇಬ್ಬರಿದಾರ ಒಬ್ರ? ಸುನಿಲ್ ಕುಮಾರ್ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
ಇದರಲ್ಲಿ ಒಬ್ರು
Total 3.
ಅಲ್ಲ, ಈಗ ಎರಡು petition ಇಬ್ರಾ?
ಇದರಲ್ಲಿ ಒಬ್ರು ಅದರಲ್ಲಿ ಇಬ್ರು.
ಇಬ್ಬ ಸರಿ. The petitioners in these cases call in question the proceedings before the concerned court registered for offence punishable under section 499 and 500 of the IPC. The learned counsel H. Sunil Kumar submits that there is threshold procedural aberration in the case at hand as cognizance is taken and then the statement is sought to be recorded by the concerned court. He would seek to place reliance upon the judgment rendered by the coordinate bench in criminal petition 3622 of 2024 to buttress his submission that in identical circumstances, the coordinate bench has set the order aside and remitted the matter back to the hands of the concerned court. The learned, ನಿಮ್ಮ ಹೆಸರು ಹಾಕ್ಲಾ?
Natashan Murthy.
So and so would not dispute the position of law. Therefore, I deem it appropriate to set aside the order of taking of cognizance in both these cases following the order passed by the coordinate bench and granting the same relief as is granted by the coordinate. ವಾಪಸ್ ಅಲ್ಲೇ. Yes.
We'll redo.
Yes.
Grateful.
ಯಾಕಂದ್ರೆ ಇದು ಆಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ಮೇಲೆ ಈ ಗ್ರೌಂಡ್ ಬರ್ಬೇಕು. ಈಗಲೇ ಸೆಟ್ಲೈಟ್ ಅದು ಸರಿ ಹೋಗುತ್ತೆ.
and
33 and 36.
34,
498, A1 husband.
A1 ಕೊಡದೇ ಇಲ್ಲ. Horrible. The petitioners are accused 1, 2 and 3 are alleged of the offence punishable under section 85 of the BNS inter alia. A perusal at the complaint would clearly indicate horrendous offences by the husband and nothing against the charge sheet ಆಗಿದೆ. Charge sheet ಆಗಿದೆ ಇಲ್ಲ. And nothing against the accused 2 and 3. In that light, there shall be an interim order of stay of investigation qua accused 2 and 3 and accused 2 and 3 till the next date of hearing. It's made clear that the investigation against the husband shall continue. 1 HCGP 2 emergent notice.
35,
In the meantime, next.
37,
Here for petitioner this matter.
2014, sir.
Please no.
Speedy trial ಕೊಡಿಸ್ತೀವಿ.
Milords, ಅಲ್ಲಿ ಇನ್ನೊಂದು ಮುಗ್ದೋಗ್ಬಿಟ್ಟಿದೆ.
ಏನ್ ಮುಗ್ದೋಗಿದೆ?
Case was disposed.
ಹಾ. ಮತ್ತೆ why are you here?
Milord, the complaint filed by me, Milord, original complaint was already disposed on 22/9/2022 itself. Only the counter case is being proceeding against me, Milord. That too, Milord, by accepting further evidences which are not the part of the charge sheet.
Anyway, just.
And Milord, the same PP has.
Jagdish. Just look, counter case and counter case. Different investigating officers ಆಗಿದೆ. ಒಂದಂತೂ ಕ್ಲೋಸ್ ಆಗಿದೆಯಂತೆ. Just check this up. I'll take it on Tuesday, fresh matters. List on Tuesday in the fresh matters list.
Published.
Copy ಕೊಡಿ.
Copy.
Offense alleged under section 376 and 420, my lord. The complainant is a wife, my lord.
Complainant is the wife.
Yes, my lord.
Your wife.
Complaint is a wife of petitioner, my lord.
Petitioner?
Petitioner and complaint is husband and wife, my lord.
376 ಯಾಕೆ?
They have invoked, my lord, 376. It's a civil dispute over a property, my lord. Even civil OS was also pending, my lord.
ಮದುವೆ ಆಗಿದ್ದೀರಾ?
Yes, my lord. Even I have produced the photograph also, my lord.
ಮತ್ತೆ promise.
He has admitted in the complaint also, my lord.
376 420 ಎಲ್ಲ ಇದೆ?
Yes, my lord.
ಎಲ್ಲಿದೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳಿ?
The complaint is in page number 37, my lord. Seven, my lord.
Great. I was married to late Praveen Babu.
She was. It's a second marriage, my lord. She her husband was died before, my lord.
ನಿಮ್ದು ಸೆಕೆಂಡ್ ಮ್ಯಾರೇಜ್?
Yes, my lord.
ಯಾವಾಗ ಆಯ್ತು?
For both second marriage only, my lord. Even I was divorced.
Praveen and his mother. ಅಲ್ಲ ಆಯ್ತು, ಯಾವಾಗ ಆಯ್ತು ಮದುವೆ ನಿಮ್ದು?
The marriage date was on, my lord, 22/8/2021, my lord. It's in page number, my lord, 40, my lord. She only admits that.
Second marriage. 376. In the meantime, yes.
Please, my lord.
Next.
39,
I appear for the petitions in this case.
Notice.
Yes.
1 HCGP 2 emergent notice. Next.
40,
13(1)E.
13(1)E, discharge application is dismissed, 17.4%. Only
Hey, ಗೊತ್ತು,
two
ಕಡಿಮೆ.
items of income has been not.
ಒಂದು ಸರ್ವ್ ಮಾಡ್ಬಿಡಿ. Serve on, this is a case where it should be, I think, we'll see. Serve on BB Patil.
Please.
Counsel BB Patil is directed to accept notice for the respondent, Lokayukta. Respondents list the matter on 11th in the fresh matters list.
Please.
ಇವತ್ತೇ ಕಾಪಿ ಕೊಡಿ.
Agbonis.
41,
For petitioner's counsel, allegation is accused number 1.
ಚಿನ್ಮಯ ಮಿಷನ್
Chinmaya
ಹಾಸ್ಪಿಟಲ್.
Mission Hospital.
ಯಾಕೆ ನೀವು ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಡ್ಲಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ, the negligence with the nurse and we have reported to the, but they have implicated the management and the doctor also.
ವಾಟ್ ಇಸ್ ದ ಮಗು ಏನಾಯ್ತು?
No, they wanted to put canola for the child, 6
Correct.
months old child, while removing some small
No,
finger.
what happened to the child?
The child has been taken care.
Heard the learned senior counsel Devakar appearing for the petitioner. In the meantime, next. Stayed.
42,
My lords, in this matter, I'm for the petitioner, my lords. My lords, the allegation against the petitioner is that the death certificate is post, my lords, and the property is transferred, my lords. There are multiple litigations between the complainant and the petitioners, my lords. For a moment, kindly see page number 319, my lords. There is a court order, my lords, wherein this petitioners are declared as the children of late Chinnappa, my lords. And subsequent to that, page number 332, my lords, there is a report issued by the Tahsildar, my lords, wherein there is an inquiry between the same parties, my lords, and there is a finding that the father of Chinnappa has not produced any document to show that he is the legal heir of Badigiyappa, my lords. My lords, Further, my lords, in page number 339, my lords, there is one more report by the Tahsildar, my lords. That order also shows the same, my lords. And in the petition filed by the father of the respondent number 2, my lords, before the High Court, he has clearly shown the father of the petitioner as Chinnappa, my lords, admitting that they are the legal heirs, my lords. There are multiple civil litigations, my lords.
Anything else? File discharge. I will not. Page 55. ಸಾಕು. ನೀವು ಯಾವ ಪೇಜ್ಗೆ ಯಾಕೆ ಹೋಗ್ತೀರಾ? Not a case for interference.
My lords, actually, there are two different grants, my lords. I'll clarify, my lords. For that also, I've produced documents, my lords. There are two grants, my lords. It's a large extent, my lords, in server number 28, my lords. An extent
Application
up,
is
an extent up
fake
to
death certificate, cancellation of grant, sale.
My lords, there is a confusion, my lords. There is a
Confusion ಅಂದ್ರೆ ಅಲ್ಲೇ ಇಲ್ಲೇ 482 ಆಗಲ್ಲ.
My lords, the investigation is not properly held, my lords,
No,
because there are two grants, my lords. One grant in favor of, my lords, one Pujiga alias Pujarappa, my lords. There is another grant, my lords. There is a document, my lords. That is a grant in favor of Badigappa, my lords. My lords, it's purely a civil in nature, my lords.
Sir.
My lords, there was
creation, impersonation, ಇದೆಲ್ಲ is
no,
not,
my lords. Earlier to this case, my lords, there was one more case, my lords. In that, the B report is filed, my lords. The B report is also produced.
ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಲ್ಲ?
ಇದ್ರಲ್ಲಿ ಮಾಡಿದಾರೆ, my lords.
ಕರೆಕ್ಟ್ ಮಾಡಿ.
ಯಾಕಂದ್ರೆ
ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಳ್ಳಿ, ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬನ್ನಿ. ಡಿಸ್ಚಾರ್ಜ್
notice may kindly be issued.
No notice also.
43.
Great.
The petitioners are accused number 1 and 2, husband and the mother-in-law. There shall be and are alleged of offence punishable under section 85 inter alia. Finding no allegations against the mother-in-law, there shall be an interim order of father-in-law. There shall be an interim order of stay quo. The accused number 2, father-in-law, and the investigation against the husband, accused number 1, shall continue. Yes, next.
Charge sheet has been filed, my
Sorry,
lord.
proceedings against accused number 1 shall
So,
continue.
my lord, she first had a false case against the first
Which
petition.
husband will say?
So, no, my lord,
correct
she has
case
issued a
anta?
mother of the big, first petitioner, so died in the met with an
No
accident.
problem.
She has
Yes.
remanded the.
Yes, next.
44.
In the meantime, next.
Own certificate is page number 32, my.
Page 22. A2 ಗೆ ಕಷ್ಟ. A1 will grant. The petitioners are accused 1 and 2 alleged of offence punishable under prayer ಇದೆ ನೋಡಿ. Finding no of overt acts by the accused number 1, there shall be an interim order of stay quo, accused number 1, and not against accused number 2 till the next date of hearings.
46.
In the meantime,
57.
Appearing for petitioner, my lord.
Siddaramaiah, page 33 allegations ಇದೆ.
Civil disputes are pending, my lord.
Correct.
Notice may be ordered, we will try.
No,
for
that
settlement.
will not. 1 HCGP, 2 emergent notice.
48.
ಇದರಲ್ಲಿ A1 and A2 ಫೈಲ್ ಮಾಡಿರೋದು allowed and remitted back at page 27 I have produced
40?
27 page, ink page 27.
Yes, government.
Referred for investigation, my lord, it is just.
For A1 and A2 same order.
ಹೌದು
ನೀವು A3 ನಾ?
ಇವರು 3 to 7 ಈಗ ಹಾಕೊಂಡಿದ್ದಾರೆ.
Yes. ವಾಪಸ್ ಕಳಿಸಿನಿ 175(3) violation. The petitioners are accused number 3 to 7. Accused number 1 and 2 were before this court in criminal petition 4250 of 2026. This court, by an order dated 7th April 2026, has quashed the proceedings and remitted the matter, quashed the order of taking of cognizance and remitted the matter back to the hands of the concerned court. Since the judgment is concerning the co-accused, the same would become applicable to the facts obtaining in the case at hand as well. This court has held as follows. Full hakpidi. I put same order.
A7 is before this
40?
honorable court, please. My lord, the offence was
49.
Yes, yes.
A7 na?
A7 is before this honorable court, please, my lord, seeking for 49 serial number.
Lakshmi. And for 49, my lord.
I'm sorry.
ಸ್ವಾಮಿ
Petition number,
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಇರ್ಬೇಕು ನೋಡಿ.
my lord, petition number 2 and 3 are mother-in-law and father-in-law of the complainant. Whereas complainant and the accused number 1 were staying in Bangalore, my lord. And they were both working, and once the petitioner, accused number 1, he traveled to the Australia. The complainant also was traveling to the Australia along with them. Because of that, there was a banking transaction, my lord, for application of the visa and other things.
Come to page, what's this, pagination ಸರಿ ಇಲ್ಲ ಇಲ್ಲಿ. Whatever, page 9, page ಗೊತ್ತಿಲ್ಲ, 5 ಅಂತ ಇದೆ ಇಲ್ಲಿ. There are allegations.
My lord, but they were staying separately, my lord.
Enter appearance for
Wakalat.
please.
Even if you see the witness against witness in the charge sheet, my lord, they are stereotypic and exactly matching the same to same, each of the
File your objections.
So I maybe stay for the action number, I mean petitioner 1 and 2, my lord, who are mother-in-law and father-in-law, who's a senior citizen, my
That is what I'm telling. There are allegations against them also at the time when the wife is staying with them.
She has hardly stayed like 1 or 2 days, my lord. More than that, is not stayed there.
1 or 2 days ಅಷ್ಟೇನಾ?
My lord, otherwise there are allegations with respect to
they were staying
is pregnant and all of that. There's
So
a lot of
the
harassment.
allegations are there.
My lord, husband and wife were staying in Bangalore.
We'll see.
So
The learned counsel,
interim stay may
Srimati
be.
Kirti Reddy accepts notice for the complainant, second respondent registry to print the name of so and so. Objections, if any, by the next date, we'll take it on 17th.
My lord, until then, stay against.
17th, yes, we'll see. Pendilla.
Yes. One submit petition one, accused number 1 got issue legal notice to respond number
ಅದೇ
2.
ಆ ಗ್ರೌಂಡ್ ಇಲ್ವೇ ಇಲ್ಲ.
ಅದಕ್ಕೆ ಕೌಂಟರ್ ಬ್ಲಾಸ್ಟ್ ಆಗಿ
ಪರವಾಗಿಲ್ಲ, ಅದೇನ್ ಕೌಂಟರ್ ಬ್ಲಾಸ್ಟ್ ಏನಾಗಲ್ಲ. Accused number?
accused number 1 is suspended.
Come to page 75. 25, sorry. 25.
Yes.
Last 4 lines. ಈ ಪೈಕಿ ಆರೋಪಿ 3.
ಈ ಬಗ್ಗೆ ಆರೋಪಿ 3 ಅವರು ಸಾಕ್ಷಿ 4. But their reside is separately at a different place, my lord. Your lordship kindly see the address.
Yes. 1 HCGP 2 emergent notice. There shall be an interim order of stay only insofar as accused number 2, the father-in-law, is concerned. Insofar as the others, it would be considered on the appearance of the wife.
Hello, once again, they are residing, they are married and residing separately at a different place. Your lordship kindly.
A3 ನಿಮಗೆ ತೋರಿಸಿದ್ನಲ್ಲ ಏನು?
ಅಲ್ಲ,
With that I will not grant. Yes. ಎಳೆದು ಒಡೆದು ಎಲ್ಲ ಯಾಕವೆಲ್ಲ?
ಅವರು ಮದುವೆಯಾಗಿ ಬೇರೆ ಬೇರೆ ಗಂಡ ಮನೆಯಲ್ಲಿ ಇದ್ದಾರೆ.
ಮದರ್ ಇನ್ ಲಾ ಸರ್.
ಅಲ್ಲ, ಬೇರೆಯವರು ಸಿಸ್ಟರ್ ಇಲ್ಲ, ಬೇರೆಯವರು ಎಲ್ಲ ಸೇರಿಸಿದೆ. ತಾವು ನೋಡಿ
ಅದು ಇಲ್ಲಿ ಇರೋದು ಯಾರು? ಸಿಸ್ಟರ್ ಇಲ್ಲ ಬೇರೆ ನೋಡೋಣ ಆಮೇಲೆ ಬಂದಾಗ.
ಅದಕ್ಕೆ
ಈಗ 1, 2 and 3 ಮಾತ್ರ ಇರೋದಿಲ್ಲಿ.
ಅಲ್ಲ, ಉಳಿದವರು ಎಲ್ಲ 7 ಟೋಟಲ್ 7 ಮೆಂಬರ್ಸ್.
7 ಗೆ ವಿಲ್ ಸ್ಟೇ.
ಅಲ್ಲ,
ಎಲ್ಲಿದ್ದಾರೆ 7?
ಅಲ್ಲ, ಟೋಟಲ್ ಪೇಜ್ accused number 1 to 7.
ಒಂದು ನಿಮಿಷ ಕೊಡಿ. ಹಾಗಾದ್ರೆ 3 and 4 ಬಿಟ್ಟು ಮಿಕ್ಕವರಿಗೆ 1, 3 and 4 ನೋ ಸ್ಟೇ.
ಅಲ್ವ, 3 is mother in law.
3 ಮದರ್ ಇನ್ ಲಾನ ಈಗ ಓದಿದ್ದು ನಿಮ್ಗೆ ತೋರಿಸಿದ್ದು. 1, 3 and 4.
4 is resided ಇಲ್ಲಿ ಬ್ಯಾಂಗ್ಳೂರಲ್ಲಿ.
ನೋ ಪ್ರಾಬ್ಲಮ್. ಅಲ್ಲಿ 3 ಕೆಳಗಡೆನೆ 4 ಅಲಿಗೇಷನ್ಸ್ ಇದೆ ನೋಡಿ. 1, 3 and 4 ಬಿಟ್ಟು ಮಿಕ್ಕವರಿಗೆಲ್ಲ ಸ್ಟೇ. Next.
I refer for petition 69 years.
You'll marry now?
Not both are not married. Will
both have got married.
not yet married, your lordship, that there is a chances, we don't know.
Chances of marriage.
Marriage also, 2 years, 2 months, their relationship, your lordship.
No. Yes, one HCGP, two emergent notice in the meantime. Next.
For 2 and 3, your lordship, parents, your lordship, there. No,
2 and 3 granted stay. Yes.
52.
Cricket betting.
Covered.
Covered. Your lordship.
A1 is.
A1 lord.
Page. Last page ಅಲ್ಲಿ ಏನಿದೆಯಲ್ಲ.
Yes, my lord. Page 36.
This court, the petitioners are before this court calling in question so and so. This court, accused number 1 has passed the following order. The present petitioner is accused number 2. In that light, same order.
Please.
53.
Posh committee order ಅಲ್ಲಿ.
Posh committee order is at page.
Page.
At page 86, my lord. Every she has given 86 and 87, my lord.
86.
I'll just take your lordships to
Nothing is proved there.
91, my lord.
ಏನಾಗಿದೆ ಅಲ್ಲಿ?
Ali, charges cannot be.
Where
whatever
do I get
allegation
that?
She has just made, my lord.
Where do I get that?
My lord, ನಂತರ ನಾನು ನಮ್ಮ ವಕೀಲರನ್ನು ಸಂಪರ್ಕ.
ಇಲ್ಲ ಮೇಡಮ್, ಪಾಶ್ ಕಮಿಟಿಲಿ ಆಗಿರೋದು ರೆಕಮೆಂಡೇಶನ್ಸ್ ಎಲ್ಲಿದೆ? ಅದಿಲ್ಲ ಅಂದ್ರೆ I will not grant stay.
They have just given the orders, my lord.
Where is that?
I'll read, my lord. It is in that portion, my lord.
ಎಲ್ಲಿ ತೋರಿಸಿ ನಾನು ನೋಡ್ಕೊಂತೀನಿ.
91 page, my lord. Page 91, paragraph 10. ನಂತರ ನಾನು ನಮ್ಮ ವಕೀಲರನ್ನು.
Where is the order of the committee?
My lord. I'll read it, my lord. Notice has been issued.
ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. List on Tuesday, fresh matters.
Not tomorrow, my lord.
Not tomorrow, Tuesday.
Obliged.
54.
Yes. Sixty?
54.
2012 CC.
Yes, my lord.
ಈಗೇನ್ ಮಾಡ್ತಾ ಇದೀರಾ ಇಲ್ಲಿ?
12/6/26 defense evidence.
Anything else? The petitioner is before this court calling in question the proceedings in CC so and so of 2012. The learned HCGP submits that the charges have been framed and the trial is at its fag end. At this stage, there is no warrant of interference in exercise of jurisdiction under section 48 of the CRPC, leaving open all the contentions to be urged before the concerned court. At the appropriate time, the petition stands disposed. Next.
55.
2024
2024
PD
16 witnesses.
FIR was at
16 witnesses.
FIR is
9
on
months.
2015,
9 months.
please. And there's also one more criminal petition which is pending, where the accused number 1 has challenged this same charge sheet, Your Honor.
ಅದು ಸ್ಟೇ ಆಗಿದೆಯಾ?
That's stay agila. They just say that exemption on appearance of accused number 1, that's all.
ಅದೆರಡು ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಡು. Tag this petition along with so and so Tuesday fresh matters.
Please.
Both will dispose. Number ಬರ್ಕೊಡಿ. Yes.
56.
Appeared for the petitioner.
Split.
Lords, in an appeal, my lord, they were convicted in the CC. Lords, after, my lords, the appellate court's order, my lords, they are acquitted now. Lords, no appeal or revision is filed before this court. Lords, all
Where is
common
the order of the
allegations-
appellate court?
Lords, the order of the appellate court is, my lords, that the state was not able to prove the case beyond reasonable
ಅದು correct. That's the
Lords,
cyclo
page
style.
112, my lords, is the appellate court's order, my lords, of. the
Offense
case.
ಏನು?
Lords, offense under, my lords,
You are accused?
Lords, I am accused 10 and 20 in the original crime, but now, my lords, 2 and 5 in the present.
ಯಾರು acquit ಆಗಿದ್ದಾರೆ?
Lords, all the other accused, my
All the
lords,
other. The petitioners accused 2 and 5 are before this court calling in question the continuance of proceedings in CC 3889 of 2018 registered for offences punishable under so and so. The petitioners get embroiled in a crime along with 32 other accused in, which becomes a crime in which becomes a crime in crime number 301 of 2012. The police conduct investigation and file a charge sheet, and the concerned court registers CC 1995 of 2015. The concerned court tries up all the accused that are available for trial and acquits them and convicts them. An appeal is filed by those accused who get convicted of the offences before the appellate court in criminal appeal. Number
19 of,
in criminal appeal 19 of 2020 and 20 of 2020. The appellate court, in terms of its order dated 29th March 2021, on the score that the prosecution has miserably failed to prove the guilt against these petitioners beyond all reasonable doubt, has acquitted these petitioners, acquitted all the other accused. Who remain in the fray is only the petitioners accused 2 and 5. The appellate court, on the following reasons, has acquitted the Elinda Aniket.
3 minutes.
Page
103. Reasons, my lord, starts from there.
103 103 in the end or Gakpudi. So, in the light of all the other accused getting acquitted of the offences and the petitioners remaining on the score that they were not before the appellate court, would not mean that the petitioners should be permitted to the appellate court would be permitted to try these petitioners and render the very same judgment that is rendered qua the other accused. It would be a waste of precious judicial time. In that light, the petition deserves to succeed. Allowed, quashed.
Great.
57.
Petitioners, my lord.
The petitioners are respondents 2, 3, 4, 5. One ilva?
One is the husband.
Is there?
My lords, yes.
But
I apologize, my lords. In the trial court, the respondent number 1 to 5 are petitioners number 1 to 5.
That's all right. Is the husband before the court now?
Please, my lords.
Emergent notice to the respondent. There shall be an interim order of stay of further proceedings before the concerned court initiated by the wife, invoking the provisions of the Domestic Violence Act only against respondents 2, 3, 4 and 5. It is made clear the proceedings against the husband would continue.
This is for the maintenance.
Huh?
I have filed for the stay on the maintenance, my lords. 7,000 rupees has been ordered by the.
ಅದಕ್ಕೆ ಯಾಕೆ ಎಲ್ಲರೂ ರೆಸ್ಪಾಂಡ್ ಮಾಡಿದ್ದೀರಾ?
But since they were the party here, so I have made all of
Yes.
them.
Maintenance order will not stay. Let the
My lords, already I am paying 8,000 rupees, my lords.
Where?
On the different case. So there are totally 8 cases pending. This is 9th case, and 10th case fortunately was dismissed yesterday.
All right, emergent notice to the respondent. There shall be an interim order of stay of the award of maintenance on the submission of the counsel for the petitioner that maintenance is already awarded in other proceedings and the petitioner is paying maintenance to the wife.
MC 286 of 2023, for which I am paying.
We'll see. Yes, next.
8.
Charge sheet has been filed in this matter.
Challenge Madi. Charge sheet format. Yes, next.
59.
Here for the respondent number 1.
Provisional attachment confirm ಆದ್ರೆ appeal ಇಲ್ವಾ?
Lord, my kindly seek a pass over, my lord. Short pass
Pass over ಆಗಲ್ಲಪ್ಪ. appeal ಇಲ್ವಾ?
ಅಲ್ಲ, two stem I have engaged the senior counsel.
appeal ಇಲ್ವಾ?
And there's an appeal, my lord, and prosecution complaint is also filed in this case.
Choose your lordship. I have.
The list on Wednesday in the fresh matters.
Please.
Yes.
Oblige.
Oblige.
ಮೋಹನ್ ಕುಮಾರ್ 311 ರಿಜೆಕ್ಟ್ ಆಗಿ 2 ವರ್ಷ ಆಗಿದೆ. ಇವಾಗ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ my lords, ರಿಜೆಕ್ಟ್ ಆದ್ಮೇಲೆ we have filed a revision petition, my lords.
ಗೊತ್ತಾಯ್ತು, ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಅದಾದ್ಮೇಲೆ ಇಲ್ಲಿ ಬಂದಿದ್ದೀರಾ. ಅಷ್ಟೊತ್ತಿಗೆ ಅಲ್ಲಿ ನಡೀತಾ ಇದೆ.
ಇಲ್ಲ, ಒಂದೇ ಒಂದು ಚಾನ್ಸ್ ಕೊಡಿ.
No.
ಒಂದೇ ದಿನ ಅವತ್ತೇ
Get the response.
ಒಂದೇ ಒಂದು ಚಾನ್ಸ್.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement of such service. 15th fresh matters. Yes, next.
61.
Lords for the petitioner.
DV Act, except for respondent number 1, all others stayed.
Great.
ಗೊತ್ತಾಗುತ್ತಾ madam? Yes.
62.
ಇದು ನೆನೆ ಬಸ್ ಅದನ್ನ ಜಯಂತಿಯರ್ ನೋಟಿಸ್ ಮಾಡು. Yes. Learned HCGP is directed to accept notice for the respondent. Yes, next.
63.
Learned additional SPP BN Jagdish directed to accept forest.
Only one
there
issue,
Huh?
whether the tree is within the schedule or not. Your Lordship,
Lordship,
next week, my lord.
Okay, so accept
Tempted.
notice, list the matter on 10th in the fresh matters list.
64.
ಇದು SJK ಗೆ ಒಂದು 4 ಕೊಟ್ಟಿದ್ದೀನಿ ಮೇಡಮ್.
I appear for
Speedy
the
disposal.
petitioner.
Where are those orders? Page. Number ಕೊಡಿ.
ಮೊನ್ನೆ ಆಗಿದ್ದು one
ಆಯ್ತು.
ಇನ್ನ ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ.
Number ಕೊಡಿ. Number ಕೊಡಿ. Same order.
65.
Withdrawal, my lords. For the withdrawal, my lords.
Huh?
For the withdrawal.
Withdrawal, ಎರಡು.
Yes, my lords, may I move the memo in the morning for the connected matter? It has not been.
ಇಲ್ಲಿ there are 2 matters. You want another matter also.
That's connected
The
matter.
learned counsel for the petitioner seeks leave of the memo ಕೊಡಿ ಒಂದು.
Yes, may I move morning.
ಇದು ಇದೆರಡಕ್ಕೆ ಮೆಮೊ ಹಾಕಿದ್ದೀರಾ?
Yes, no.
Where is it? ಕೊಡಿ.
I filed it already.
The petitioner files a memo seeking to withdraw the petition, disposed as withdrawn. Yes. 65, 66 both.
Much of.
67.
Meantime,
68.
petitioner is accused number 3 is alleged of the,
Petitioner, my lord.
huh?
See number 68, I am for the petitioner, my lord.
69 ಆ?
68, my lord.
Accused number 3.
Please, ma'am.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರುತ್ತೆ. ನಿಮ್ stay ಆಗಿ. The petitioner is accused number 3 is alleged of the offense punishable under section 85 of the BNS inter alia. A perusal at the complaint would not indicate even an iota of offense against the petitioner for it to be
ಇಲ್ಲ ಸ್ವಾಮಿ,
for it to be permitted to be investigated into. In that light, there shall be an interim order of stay of all investigation qua the petitioner till the next date of hearing.
Lord, even serial number 70, my lord, she is the mother of accused number 1, serial number 70.
Correct, same 68 and 70 tag ಮಾಡಿ.
Please.
Same order.
Obliged.
ಅಲ್ಲಿ accused number 2 ನಾ?
Please, accused number 2.
Accused number, ಇದು accused number 2, ಅದು accused number 3. Latif 505-2. Tag this petition along with so and so. ಅದು A2 stay ಆಗಿದೆ. ನಾನ್ ಮಾಡಿದ್ದೇನೆ.
ಟಿವಿ ಸಂದರ್ಶನ.
ಹಾ?
ಟಿವಿ ಸಂದರ್ಶನ.
Debate.
ಯಾಕೆ ಮಾಡಿದ್ರಿ?
Comment on the, while it's debate on the hijab.
Let's not glorify something. Yes. In the meantime. ಅದು same order. Tag ಮಾಡಿ same order. ತೀರ್ಮಾನ ಮಾಡೋಣ ಬೇಕಾದ್ರೆ. Yes. Tag this petition so list on 2nd July. The fresh 2nd July for admission ಅವತ್ತು close ಮಾಡೋಣ. Preliminary hearing. Yes, sorry.
71.
Petitioner has filed PCR.
ಏನ್ ಇಂಜುರಿ ಆಗಿದೆ?
So he has sustained fractures, my lord. Several fractures he has sustained.
You are the driver.
No, I am, respondent number 2 is the driver of the car. She has caused the accident and she has left the place. They have filed PCR. PCR has been referred for investigation. Criminal case is registered against the second respondent. A false charge sheet is filed against the petition, not against the second respondent.
In the meantime, yes. Next.
72.
Wound certificate ಇದೆಯಾ?
Please, case and counter case.
Correct. Wound certificate.
Please, there is wound certificate.
ಏನು?
There is simple injuries. And it is.
ನಿಮ್ಮ 1 HCGP 2 emergent notice in the meantime. Next.
Maybe connect case, both case.
ಕೊಡಿ tag along. ಅದ್ರಲ್ಲಿ stay ಇದೆಯಲ್ಲ?
Stay ಇದೆ.
ಎರಡು ಕ್ವಾಶ್ ಮಾಡ್ಬೋಣ.
Please.
73.
Multiple FIRs ಇದರಲ್ಲಿ ಫಸ್ಟ್ FIR 2023 ಅದು acquittal ಆಗಿದೆ
85.
Yes,
husband.
Yes, ಮಲ್ಲ.
ಏನ್ ಮಲ್ಟಿಪಲ್ FIR?
ಒಂದು FIR acquittal ಆಗಿದೆ ಮಲ್ಲ 2023 ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿರೋದು. ಮಲ್ಲ ಪೇಜ್ ನಂಬರ್ 63 ಮಲ್ಲ 17 June 2025 ಅಲ್ಲಿ acquittal ಆಗಿದೆ. After that 2nd July 2025 ಅಲ್ಲಿ FIR ಮಲ್ಲ.
All right. But you have never together after that?
My lord.
Acquittal order, you did not stay together?
No, my lord, no, my lord. After that, she filed another FIR also, my lord, in November. That was also.
The
stay by-
petitioner husband is before the court projecting multiple crimes registered against him at various places. The learned counsel takes this court through the documents appended to the petition to demonstrate that the first crime so registered ended in acquittal of the husband. The second crime is registered at a different place. This is the third in line. Therefore, there shall be an interim order of stay of further investigation, quay the petitioner to the next date of hearing.
In the year 2023, 31/7/2023.
Hmm.
After her transfer, it transpires that certain persons have, my lord, interpolated the register. There is no original Sagoli issuance register, Sagoli cheat, my lords.
Hmm.
That is interpolated.
Hmm.
And Extent Commissioner informs her that is related what you say. She gives an explanation, she sees the documents, and it's interpolated, inquiry should be held. Then, my lord, those persons are notified by the Forest Department also, persons who claim that there are documents of Sagoli chit, my lords. They don't have the originals, they give some Xerox copies. And these documents are
we'll have
fake,
to hear
fake
the-
documents.
Jagdish, take notice in this.
Please. Now, my lord, FIR registered against her for Prevention of Corruption Act also.
3 and 4 loci.
No, there are others also. 3 and 4 lokaitha. The learned additional SPP is directed to accept notice for the first respondent state
1, 2, and 5 and 6.
1, 2 and 5, 3 and 4 count lokaitha. A petitioner to serve, the advocate and record to serve requisite set of papers upon the aforesaid counsel if not already served. 10th in the fresh matters.
Meanwhile, my lord, there's no allegation of Prevention of Corruption Act at
Note
all.
ಬಿಡಿ, ನೋಡಕ್ಕೆ.
Take notice
ಒಂದು
of
ವಾರ
6
ಅಷ್ಟೇ.
As my lord.
also. Take notice of 6 also.
ಯಾರ್ಯಾರಿಗೆ
2, 5 and 6.
1, 2, 5 and 6 additional SPP, 3 and 4 Latif. Copies are made. We'll take it on 10th in the heard the learned senior counsel PP Hegde ಅಂತ ಮಾಡಿ ಆಮೇಲೆ ಇದನ್ನ ಮಾಡಿ.
Please.
75.
Petitioner, my lord. Here the conduct of the respondent is that the whatever the incident they have stated, they have been cognizance cannot be taken by the police, and the body cam of the police has not been secured. The CCTV footage which is
ಇದು
by the
an
petition.
additional SPP is directed to accept notice for the respondent. Same 10th fresh matters. Let him see. Avat, that day will grant. Yes.
Number 2 being spoken, still number 1.
ಯಾಕೆ ಮೇಡಮ್ ಇದು?
This, my lord, kindly rectify the typographical error ಇವರು.
ಏನಿದೆ ಮೇಡಮ್?
ಇದರಲ್ಲಿ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ, ಅದರ್ವೈಸ್ ಈ ಆಪರೇಷನ್ ಪೋರ್ಷನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಏನಾಗಿದೆ, ಓರಲ್ ಆರ್ಡರ್ ಏನಾಗಿದೆ, ಬೇರೆ ಕೇಸ್ ಬಂದಿದೆ. ಸಮ್ ಅದರ್ ಕೇಸ್ ಇವರು.
Which case, madam?
ವಾಲ್ಮೀಕಿ ಎಜುಕೇಶನ್ ಸೊಸೈಟಿ ಇದು ಬಂದಿದೆ. Actually, my case is offense under section 498A. Batch number ಕೊಂಡಿರೋದು.
We'll see.
Yes, madam.
ಯಾರದು BSR? Let me see, ನಾಳೆ post ಮಾಡ್ತೀನಿ.
Much obliged.
Correct ಮಾಡ್ತೀನಿ.
Much obliged.
Yes.
Number 2.
Lords, charge sheet number has come in, Lords, instead of the case number in this matter.
ಎಲ್ಲಿ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಇಲ್ಲ, ಎಂಟ್ರಿ ಮಾಡಲ್ಲ.
In the first, fifth and sixth para, my lords.
ನಂಬರ್ ನೀವು
SPLC P50/2025.
ಏನಾಗ್ಬೇಕದು?
ಅದೇ ಆಗ್ಬೇಕು. CC ಇದೆ, ಅದನ್ನ ತೆಗೆದ್ಬಿಟ್ಟು SPLC P.
SPLC ನ ವೈ ಸ್ಪೆಷಲ್ ಕೇಸ್.
ಸ್ಪೆಷಲ್. SPL.CP.
ಆಯ್ತು, CC ತೆಗೆದ್ಬಿಟ್ಟು ಸ್ಪೆಷಲ್ ಕೇಸ್
C in the bracket P 50/2025.
ಬರ್ಕೊಂಡ್ರ?
I will write and give.
All right, yes.
Please.
Number 3.
Appearing for the petitioner, my lordship.
ಏನ್ ಮಿಸ್ಟೇಕ್ ಇದೆ?
Withdrawal ಅಂತ ಇದೆ ಸ್ವಾಮಿ.
ವಿಡ್ರಾ ಮಾಡಿಲ್ವಾ?
Settlement, joint memo settlement, my lordship.
ಡೀಡ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಹಾಕು. ಜವೈ ಇದು ಜಾಯಿಂಟ್ ಮೆಮೊ ಕನ್ವರ್ಟ್ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ.
Much obliged, my lordship.
ನೆಕ್ಸ್ಟ್ ಇದೆಯಾ ಮೇಡಮ್ ಜಾಯಿಂಟ್ ಮೆಮೊದಲ್ಲಿ?
Next matter is number 4.
I appear for the petitioner, Your Honor. On the last occasion, Your Lordship had directed me to file an IA seeking stay.
You have filed?
It's filed.
One. Oh, this, you had not filed the IA then. In the meantime. IA ಇದೆಯಾ? Copy?
It's there.
ಇದು ಅವತ್ತು ಸ್ಟೇ ಕೊಡ್ಬೇಕಾರೆ ಅಪ್ಲಿಕೇಶನ್.
Cannot open.
In the meantime.
I'm grateful.
Yes, madam. IA ಎಲ್ಲಿದೆ? ನಿಮ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ ಇಲ್ವಾ?
ಮಾಡಿದ್ದೀವಿ.
Where is it? Acknowledgement?
B6. Print page. Print page. Print page.
5.
ಸ್ವಾಮಿ ಇದು ರೋಡ್ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋ ಪ್ಲೇಸ್ಗೆ ನಮ್ಮ ವೆಹಿಕಲ್ ರೀಚ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. ಆದ್ರೂ ಕೂಡ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ FIR ಅಲ್ಲಿ ನಾಟ್ ಮೆನ್ಷನ್ ನಮ್ದು ವೆಹಿಕಲ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ನಮ್ನ ಫಿಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದ್ರ ಬಗ್ಗೆ GPS ಕ್ಯಾಮ್ರಾದು ನಮ್ಮ ಹತ್ರನೂ ಎವಿಡೆನ್ಸ್ ಇದೆ.
Request, Mother. Case of the prosecution is that we have chased him and taken the vehicle. But inquest Mother Ali, unknown vehicle. FIR is unknown vehicle. I'll call the officer.
Get the records.
Yes.
Learned additional SPP is directed to accept notice and secure the records. There shall be an interim order of stay of further proceedings quay the petitioner to the next date of hearing.
Proceedings under PML Act.
Madhu?
Petitioner is accused of 56. No predicate offense.
One more matter which is to be attached to this.
ಯಾವುದು?
One more matter. Ajmal Judge. You must have to file objection.
ಅದರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
There's one more matter.
Number
which is
ಕೊಡಿ.
listed today.
Number ಕೊಡಿ. What's your ground?
The other matter is serial number 91.
ಇದೆಯಾ ಅದು? We'll take it at 91 then.
Please,
Yes, if it may be taken up.
ಅದು ಬರ್ಲಿ 91 ಬರ್ಲಿ ಯಾವಾಗ ನೋಡೋಣ.
No predicate offense ಅಷ್ಟೇ.
Okay.
ಅದೇ no predicate offense.
Well, also their contention is that their name is not mentioned in the FIR, but it's there in the ECI.
Charge sheet ಇದೆಯಾ?
Some charge sheet.
ECI ಅಲ್ಲಿ independent ಆಗಿ ಮಾಡಬಹುದು if there is a money trial.
Exactly.
Yes. We'll see. Yes, sir.
7.
Let's appear for the petitioner. Let's kindly pass over. Let's
Why?
seniors just before the coordinate bench.
Enter ಮಾಡಿದ್ಯಾ?
This is a fake disability certificate issued to obtain a medical seat.
In fact, I've not been named in the FIR itself.
Investigation ಆಗ್ತಾ ಇದೆಯಾ?
Please, Malats.
Why are you worried?
We have
So if you are not named in the FIR, why are you here?
Malats, I was suspended because I was detained, Malats.
Suspended?
Please, Malats.
Government servant?
Please, Malats.
Very good. Anything else?
I pass over, Malats. Senior.
Yes. Get the records of investigation. ಇದೆಯಾ? Oh, excellent. ಇವತ್ತೇ ಮುಗಿಸ್ಬೋಣ.
Yes.
Pass over. Next.
8.
Emergent notice to the respondent.
9.
Hearing for the petitioner, my lords, in this matter. My lords, on the last date of hearing, we had furnished a memo of citations. My lords had said, seek bail and come, we'll decide after the vacation, my lords.
No, bail is
We
granted.
have sought bail, my lords, we are enlarged on bail currently.
Hmm.
My lords, I'm just furnishing a copy. Thank you. My lords,
What's the offense?
my lords, the offense is under section 63 and 44 of the IT Act, my lords. My lords, my humble submission, my lords, this is purely a civil dispute that is squarely covered by my lord's judgment itself, my lords. I had furnished a citation on the last date of hearing. If my lords may please take my memo of citations.
You filed your objections?
I filed my objections.
Your objections are on record.
Already filed?
Yes.
Indeed.
Yes.
My lords, that page, my lords, may please take page 69 of my memo of citations, my lords.
Memo of citations ಕೊಟ್ಟಿದ್ದೀರಾ?
My lords, I'll furnish another copy, my lords.
ಇದೆಯಾ madam? ಕೊಡಿ, ಇಲ್ಲದೆ. It's here, it's here.
Lords, may please
Page
take
60?
Page 69, my lords. No, the judgment begins at page number 30. Is my lord's judgment?
Oh, this one, yes.
My lords, may please take paragraph 15, my lords, of this judgment.
I'm there.
Because paragraph 15 clearly says, in light of the aforementioned judgments, the registration of a crime is rendered unsustainable. While it is correct that in a given case and a given set of facts, both civil and criminal laws could be set into motion, as there would be common ingredients which has flavor of civil law and which has rigor of criminal law. The issue now would be whether this court is in excess of its jurisdiction can entertain the petition under section 482 and obliterate the crime. This is no longer res integra. My lords, the test, my lords, is that the apex court holds that in a petition under section 482, this court is permitted to exercise jurisdiction by reading the complaint between the lines, my lords. As in my humble submission, the facts of this case, my lords, are far more egregious than the present facts, my lords. In this case, my lords, high-level employees of the company had left. They had started their own company, which was competing, my lords. I have not started. I have gone to a competitor company. That is a pure allegation against me. There, my lords, they had filed a civil suit as well. A civil suit was filed. Thereafter, charge sheet was filed, my lord. In that light, my lords have held that the issue being the same one of data theft, what was missing was the element of dishonesty and fraudulent intention, and therefore, my lords, the matter was quashed in this particular case. My lords, in my humble, if my lords may please for a moment take the complaint, my lords, at annexure A, my lords will find it at page 16. 16, my lords. My lords, in the complaint, several facts have been fabricated, my lords, which clearly show that there has been a manufacturing of facts to bring this set of facts into the realm of criminal law, my lords. My lords, may please take paragraph number 2. At page 8.
No offenses under the BNS?
No offenses under the BNS whatsoever, my lords. Merely allegation of data theft, my lords. Lords, they say, my lords, that the laptop was returned on the 9th of July, my lords. They say I had it for a month longer than I really did. In their statement of objection, that paragraph 6, my lords, they clearly admit that my resignation is on the 7th of June. Within 2 days, I hand over my laptop. Friday, I put in my notice. On the 9th of June, I give them my laptop, my lords. In their complaint, they say that has happened.
Which is the company that you have opened?
I have not opened any company, my lords.
You have joined some other
I
company?
have joined another company, my lords.
So you have, this is Motorola.
I have joined Realme, my lords. That is where I am at. My lords, more importantly, my lords, at the time of my exit from the company, there was an inquiry that was conducted by them. My lords, I answered that inquiry. My lords, as a result of that inquiry, my lords, may please take annexure L, my lords. It's my affidavit at page 128, my lords.
One 128.
128, my lords. Because this is an affidavit that I am asked to give by the company. They call me for a meeting on 9th of July. I have a meeting with them. On the 18th of July, my lords, they issue a show cause notice to me. I respond to the show cause notice. We have another meeting thereafter. I'll take my lords through the email trail as well. After that, my lords, they tell me that you can give us a signed affidavit. We will accept it. I give them the affidavit, my lords, where I do not deny the fact that I have copied the data. I have certainly copied the data, my lords. I cannot run away from that. I admit that in my affidavit. Whereas my humble submission is, my lords, that the data was deleted and this is in their knowledge. Via the affidavit, I have informed them. They are fully aware that it has been deleted. They accept my affidavit, my lords, on email. My lords, may please take the email trail.
Where is the electronic mail?
Indeed, my lords. My lords, may please take, my lords, page 61 on, apologies, my lords.
Of the objections?
No, my lords, of my petition, my lords. Page 57 onwards.
No, in the mail trial,
Indeed,
you
my
just take me to that.
Grateful, my lords.
50?
Great. Indeed. My lords, may please take page 70, my lords.
70.
70, my lords. My lord, may please take in the middle of the page, email dated 26th of July, my lord.
Yes.
My lord, the email is written by me, Petitioner Prashant Taneja, to Ms. Rachna. Dear Rachna, I acknowledge the receipt of your email and the notarized affidavit is ready at my end. My lords, may please see the email just above this, my lords, on page 69. And on page 69, Ms. Rachna, on page 69, on 24th of July, Ms. Rachna writes to me, saying, Dear Prashant, we acknowledge the receipt of your email dated 21st July. That is my response to the show cause notice. My lords, at point number 5, at the very bottom of the page, we say, we note your offer to provide a notarized affidavit without prejudice to your rights. We are prepared to consider such an affidavit, provided it includes unqualified declarations that, and they give me what declarations I'm supposed to give, my lord. But thereafter, I tell them that this affidavit is ready on 26th of July. Similarly, on 28th of July, my lords, I write to them, as discussed and mutually agreed between us during the meeting today. I submitted the notarized affidavit. Anshika confirmed that the affidavit is fully satisfactory and meets Lenovo's requirements. As agreed, the matter starts closed between us on the submission of this affidavit. My lords, on 28th July, the very same day, on the very next page, my lords will see they categorically says your notarized affidavit has been received and stands accepted. After taking this on record, my lords, they issue a exit letter to me, a provisional exit letter on the 4th of August and a final exit letter on the 16th of July, on 16th of September, my lords.
Page.
Indeed, my lords. My lords, may please see annexure N, my lords, at page 135. This is my exit letter dated 16/9, my lords. This is at page 135. Lords, absolutely no remarks have been made in this regard, my lords. I'm told please find attached a service letter. On the previous page, my lords will see that the provisional letter is given to me on the 4th of August. Even there, my lords, absolutely nothing is mentioned. There's one last point that I would like to highlight, my lords, from the email trail between the parties. My lords, what I'm categorically told on the 7th of July is that, as you're aware, the employment terms specify that the relieving process is subject to a satisfactory handover and, among other things, compliance with data and security protocols. So once that they have given me the handover, my lords, they have taken the affidavit from me. I am to assume that this matter stands closed with them. At no point in time did they insist that you must.
Have they used that affidavit in the complaint?
But they have not mentioned it, my lords. The affidavit, there is not a whisper of the affidavit. There is not a whisper of the settlement meetings or meetings that were conducted between the parties. In fact, they have fabricated the fact that I sought to buy out my notice period once the inquiry started. From the very beginning, I've been asking, my lord.
No, Your Lordship, he has misled the court with certain facts in the case. Your Lordship, the company policy does not permit the employer to stop any employee from leaving the company. Once he tenders a resignation, we have to relieve him from his services. Now, Your Lordship, what he has done is, the timeline in this matter has to be considered, Your Lordship. On 7th of June, he tenders his resignation. On 3rd and 4th of June, he transfers 898 files to his personal external drive. Now, Your Lordship, he hands over in the complaint. It is a typographical error that it is mentioned as 9 July. But yes, he has in fact in the objections also we have clarified that it is 9 June. Now he has submitted the laptop for internal investigation. Now in the investigation, we find out that such large number of files were transferred. Now there were several discussions that were held, and he was part of all the meetings where we asked him specifically as to why he has transferred such large number of data which are confidential in nature. Now, Your Lordship, in all of these discussions, his replies were evasive. And he has refused to admit also, Your Lordship, even in his affidavit. Now, he claims that he has admitted in the affidavit that he has copied these 898.
But he has deleted it, what you have acknowledged also.
Sorry?
No, the deletion of the data of 898 files or whatever,
Yes.
that you have acknowledged the deletion.
We have not acknowledged any deletion. No, Your Lordship, he has not read half of the mail. He has read the rest half. He has not. I will point out to this court.
All right.
Now, Your Lordship, when we have asked him, his replies were evasive. He has even failed to admit. He blatantly refused that he has not taken any data in this period. And Your Lordship, even if he has taken it for the work, he has to show what mandate was given to him that such large number of files were taken, which again he refused. Then we asked him to give the external device, and then he invokes right to privacy. Now, Your Lordship, thereafter, we issued a show cause notice at page 127, where we issued a show cause notice asking him to deliver these personal devices so that we can conduct an inspection. Now, to that, he replies, Your Lordship, on 21st of July, where he offers to give the notarized affidavit. We have not asked him to. It is his offer. At page number 120,
No, it's not his offer, but anyway, you have asked for it and it's given.
no, we have not asked for it.
Now,
Your Lordship.
what has become of this allegation? Tell me.
No, your Lordship, now he is working for a competitive company as a director. Now from a manager, he has directly been promoted. We are not
So that's the
contesting.
heartburn. That's
Your
the
Lord-
heartburn, is
No,
it?
we are not
Then-
contesting. Now without any evidence, we did not want to take any action against him. Now after the investigation, we have also given it for an external investigation. Now the data, your Lordship, is of confidential nature. Now investigation has to happen. He has to surrender those devices to see what has happened to the data that he has taken, your Lordship. It is not a breach of contract as he is claiming. It is the intention that has to be looked into.
That's why I asked what has become of that files that he took.
Now, your Lordship, if we conduct a detailed investigation, now it is key projects in the Asia Pacific region, where by the end of this year and next year, the projects are concerning. Now, only after, of course, these are confidential information, your Lordship, which cannot be released in public scrutiny. And
Has he done that?
Your Lordship, now,
Has he done that?
if the devices are procured, we will be able to know how he has transferred subsequently, how he has misused.
Just 2 points in reply.
Very affidavit which he has filed. He admits that he used the
He
external.
admits that, yes, it is transferred to the external drive. He admits its deletion as well.
No, he only says for the work, he says, your Lordship, on 3rd and 4th, 898 files are not for work, and he has to explain as to what was the mandate that was given.
No, it's only because he has joined Realme in a higher position.
We were aware of it even when he was he has tendered his resignation. He has informed. In fact, he has threatened us, writing several emails telling us that we cannot stop him from leaving the company, and if he has any laws.
These facts are exactly what I've written in that
Just 2 points.
matter.
My lord.
Exactly the same.
No, your Lordship, we have not
There as
initiated
well.
any civil case in this manner.
That is the problem, my lords. That shows that betrays, if their intention was, my lords, to safeguard the data, an injunctive relief, an Anton Pillar injunction is what they should have sought against me.
No,
They wait till the 15th of December for a matter that they say that I've copied the data in June. My lords, may please take page 28 of the statement of objections, my lords. It will show that on 22nd of July, they have produced an entire list of all the files that were taken. So it's not that they had to wait for the external report to come in, my lords.
Of course,
The internal report itself.
We cannot act on the internal investigation. And your Lordship, what needs to be seen is this happened for the first time. It has never happened in the past that an employee has taken so many files.
Another matter, my lord, another fact that was admitted by them is they knew where I was joining. In their complaint, my lord, in the last paragraph, they say we have recently learned. I have produced screenshots to show.
No, that in the resignation itself you have said.
No, I have told them which company I'm joining. My lords, on 9/6, my lords, I produced screenshots where I tell my senior manager, I've already told him, you please don't disclose the name of the company. From 9th of June, they're aware of whom I'm joining. But in the complaint, they say we have recently learned he has gone to a new company, my lords. These are clearly fabricated facts, my lords.
No, your Lordship,
If this is the case, nobody will be able to move out of any company and work elsewhere.
No, it is not about moving out, your Lordship. Nowhere
That's why
in
I
the
asked,
past this has
what has become of that alleged 898 files?
Your Lordship, if I can just
transferring?
take instructions from the client, and then on Monday the matter may be heard, your Lordship. I can.
What did I do till now?
No, your Lordship, I can find out and inform, because this is confidential information. I may not be able to place it on record.
All right.
If I can just.
Intermodary,
Yes.
We'll list this matter on 17th in the fresh
One
matter.
humble submission, my lords, they say it's. in
Wait,
context.
sir.
Great.
17th in the 17th for admission at the request of the council appearing for the second respondent complainant. Till such time further investigation, further investigation shall remain stayed.
Grateful, my lord.
Yes.
Just one parting submission, my lords, is that they say it's confidential information, but they've produced the KPMG report and the internal
We will
email
not
disclosing the name of the documents. I fail to
not,
see what
disclosed
further has
the
to be sought.
documents.
My lords, all the
documents
names
are
of the
not on
files are
record.
there. I'll take my lords for
The
the record.
contents are not on record.
This
You can't.
prima facie appears to be a heartburn and nothing else.
Grateful.
Number 10.
ಏನ್ ರಾಜೇಶ್
ಸೆಟ್ಲ್ಮೆಂಟ್ ಕೇಳಿದೆ ಆದ್ರೆ ಅವರು ಅಮೌಂಟ್ ಒಪ್ಪಿಲ್ಲ ಸರ್.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್?
ಲಾಯರ್
ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್
ಲಾಯರ್.
ಓ ಎಸ್, ಓ ಇವ್ರದ್ದು ನಿಮ್ದೆ.
ಹೌದು.
ಅದರಲ್ಲಿ 2.5 ಲಕ್ಷ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
2.5 ಲಕ್ಷ?
20 ಲಕ್ಷ ಆಲ್ರೆಡಿ ಬಂದಿದೆ ಬ್ಯಾಂಕಿಂದ. ಅದ್ರಲ್ಲಿ ಏನು ಅಂತಂದ್ರೆ ಅವ್ರು ತಗೊಂಡಿದ್ದಂತ 13 ಲಕ್ಷ ಬ್ಯಾಂಕಿಗೆ ಕಟ್ಟಿದ್ರು ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ದಿಸ್ ಕಂಪ್ಲೇಂಟ್
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬರಿಬೇಕಷ್ಟೇ.
10 lakhs 13 lakhs ಕೊಡ್ಬೇಕು.
13.
ಹೌದು.
ಈಗ ಎಷ್ಟು
ಅಮೌಂಟ್
ಕೊಟ್ಟಿದ್ದಾರೆ?
ಇವ್ರು
ಬ್ಯಾಂಕಿಗೆ
2.5 ಕೊಡ್ತೀನಿ ಅಂತ
ಕಟ್ಟಿರೋದು ಸ್ವಾಮಿ ಅವರು. ಬ್ಯಾಂಕಿಗೆ ಕಟ್ಟಿರೋದು ಅವ್ರು ಯೂಟಿಲೈಸ್ ಮಾಡಿಲ್ಲ, ಅದು ಅವ್ರಿಗೂ ಗೊತ್ತು. ಇವರು ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಅಮೌಂಟ್ ಬ್ಯಾಂಕ್ ಕಟ್ಟಿದ್ರು, ಇದಾಯ್ತು ಅಷ್ಟೇ. ಇನ್ನೇನು ಅವ್ರೇನು
ಬರೀ ಎಕ್ಸಾಮಿಷನ್ ತಾನೇ ಮಾಡಿರೋದು, ಟ್ರಯಲ್ ನಡೀಲಿ ಬಿಡಿ.
ಅಲ್ಲ, ಟ್ರಯಲ್ A2 ಮೇಲೆ ಅಲಿಗೇಷನ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅಲಿಗೇಷನ್ ಇರೋದು A1 ಗಂಡನ್ ಮೇಲೆ ಇರೋದು. ಅವು ಹೆಂಡತಿ ಅವ್ರ
ಅಪಿಯರೆನ್ಸ್ ಎಕ್ಸಾಮ್ ಮಾಡಿದೀನಿ, ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಈಗ ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಳ್ಳಿ, ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬನ್ನಿ.
ದಟ್ ಮೇ ಬಿ ಕಂಟಿನ್ಯೂ.
ಅಷ್ಟೇ. ಡಿಸ್ಚಾರ್ಜ್ ಫಾರ್ಮ್ಯಾಟ್, ದಿ ಅಪಿಯರೆನ್ಸ್ ಆಫ್ ದಿ ಅಕ್ಯೂಸ್ಡ್ number 2, the wife shall stand exempted as she was exempted from appearance during the pendency of the subject petition, unless the concerned court would
till disposal of discharge application.
Till disposal of the discharge application.
ಇಲ್ಲ, ಅದಿರೋದಿನ್ನ ಸೆಪ್ಟೆಂಬರ್.
ಅದು ಗೊತ್ತು. Till disposal of the discharge application, all contentions remain open to be considered in the application seeking discharge. Yes. Yes, sir.
The petitioner and the respondent entered into a partnership deed. They have filed, there is an arbitrator clause in the partnership deed. Now they have filed the petition for appointment of arbitrator also. The meantime, the case of the
138.
138.
What is the ground, sir?
Lord, your Lords may kindly see page 19, my lord. As per the terms of the partnership deed, my lord, books of account has to be maintained and audit has to be conducted. In this case, my lord, the business itself has not commenced. There is no.
Check ಯಾಕೆ ಕೊಟ್ರಿ?
Lord, yes, a security, my lord, the check was given.
That's a matter of evidence.
Check was given as a security. My lord, the
ಎಷ್ಟು
business
amount?
itself was 2,25 crores.
2 crores 25 lakhs.
2 crores
2 lakhs 25 crores. Yes.
2 crores 25 lakhs, my lord. The case of the respondent is that, my lord, 1 crore, my lord, is the profit. But the business itself has not commenced. There is no audit and there is no accounting, maintaining the books of account.
ಅದಕ್ಕೆ ಮುಂಚೆನೆ ಚೆಕ್ ಹಾಕ್ಬಿಟ್ರಾ?
ಇಲ್ಲ ಅವರು he has not paid me single amount of money as profit. He has taken it in terms of the profit amount only towards part of the profit. He issued the check.
All this matter of evidence. ಬೇರೆ ground. If you have any jurisdictional issue, tell me, or sign ಮಾಡಿಲ್ಲ, partner ಅಲ್ಲ.
ಇಲ್ಲ ಅದಿಲ್ಲ. Now they has filed the petition for appointment of arbitrator also.
ಆಯ್ತು. Yes. The petitioner accused is before the court calling in question the entire proceedings in CC 30620 of 2025, registered for offence punishable under section 138 of the Negotiable Instruments Act. The facts in brief, heard so and so facts in brief germane are as follows. The petitioner is the accused, the respondent, the complainant. The two enter into an agreement. In furtherance of an agreement, the petitioner is said to hand it over two checks.
Two checks.
Many
checks. Among this,
several checks to the respondent complainant. The partnership having gone wrong, the checks are presented for its realization. All the checks are presented for its realization, and two of them are said to have been dishonored, which form the subject matter of the proceedings before the concerned court in CC 30620 of 2025. The cognizance being taken on the said offence, the petitioner accused is before the court in the subject petition. The learned counsel for the petitioner would vehemently contend that the checks were given as security. There is no, the business itself has not commenced for any amount to be defaulted by the accused or for the respondent to present the check that was rendered as a security. The learned counsel appearing for the respondent would refute the submissions in contending that not a rupee has been paid to the petitioner, respondent complainant pursuant to the agreement, and all the profit is swindled off by the accused, and therefore the respondent complainant presented the checks for its realization, which have been now dishonored. The learned counsel submits that the checks are admitted, the signature is admitted, and it is for the evidence for the concerned court to draw its inference on the evidence that would be let in before it. I have given my sounds. The aforenarrated facts are not in this, the aforenarrated facts are a matter of record, but they would not require any iteration. The petitioner and the respondent being, petitioner and the respondent enter into a transaction through the agreement, and in furtherance of the agreement issue certain, the petitioner issues several checks, two of which form the subject matter of the present list. The contention of the learned counsel for the petitioner accused is that it was given as a security. Even if the checks are given as a security, it would be a matter of evidence before the concerned court as to, that would be a matter of evidence before the concerned court. Exercising jurisdiction under section 482/528 of the IPC/BNS would not be a remedy that would be available to the petitioner in the teeth of the disputed questions of fact with regard to why the check is rendered by the petitioner in favor of the respondent complainant. Once the check is admitted, signatures are admitted, it becomes a matter of evidence. With the finding no merit, petition stands disposed.
Obliged.
12.
Notice was issued, my lord, to the, notice was directed.
Counsel sir madilva.
Piriyapatnada ಇದೆ ಸ್ವಾಮಿ, ಸ್ಪೀಡ್ ಪೋಸ್ಟಲ್ ಕಳಿಸಿದೀವಿ, ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇಸ್ ಅವೈಟೆಡ್. ಇದರ ಪೋಸ್ಟಲ್ ಇದು
List the matter on next week, same day.
ಫೈಲ್
Yes.
For petitioner, Your Honor. Parties are present and the
Correct.
matter is
Offense,
compounded.
what's the offense?
498.
498A, 323.
Settlement elli, where?
Family court. Both the parties are already divorced.
Compounding application ಇದೆಯಾ? ಜೈ ಮಾಡ್ತಕ್ಕ. ಜೈ affidavit ಇದೆ settlement.
We've received the DD as well.
What's that?
DD is given today. The DD is given.
ಅಲ್ಲಿ last line ಹಾಕಿ. The petitioner husband hands over a demand draft of
5 lakh.
5 lakhs, of 5 lakhs to the wife who's present before the court and acknowledges the receipt of the said amount. Yes.
Order sheet. 14, 15, mid-run, 16.
But on the previous date, your lordships had framed a short question. I have a short reply. But the question.
Entry order ಕೊಟ್ಟಿದ್ದಲ್ಲ?
ಇದೆ. PF
The question.
entry order ಇದೆ.
ಅದೇ ಇದು.
ಬಿಡದಿ.
Oh.
Frame the question. All these frames. Question is not. Would an FIR have been registered without permission from the magistrate on allegations which at the highest attract only non-cognizable offences? Lord, in order to register the FIR, they include section 141. They arrest me on that. They register an FIR. Having registered an FIR, it becomes a
so they delete it later.
They then delete it. The very after arresting me, Lord, I don't come before this court at that stage. Lord, they register the FIR. They arrest me. That was the only provision which was cognizable, non-bailable. All others are non-cognizable. You could not have registered an FIR. So, Lord, at page 25, your lordship will find that miserably vague 4-line complaint in which, Lord, at best allegations of bribery, attempt to bribery are attracted. Admittedly, that offence, Lord, under the IPC BNS is a non-cognizable offence. Therefore, Lord, to include 141 only to register an FIR is nothing but a device. Therefore, an FIR in the first place could not have been registered without having taken permission, Lord. Therefore, Lord, the entire consequential proceedings will have to go.
But who is the complainant is yet to be served, I guess.
Furnishing PF.
I'm sorry, Lord. That we'll just have that done.
Yes.
State, oh, I'm sorry.
First time ಮಾಡಿಲ್ಲ.
I'm sorry.
The needful be done
Yes.
in the next 2 days. List the matter on 17th, interim order subsisting would continue till the next date of hearing.
That's the short point. Lord,
That
which
I've
is-
already recorded that in the order. Yes.
17.
Maintainability.
Lords, relaxation of bail condition, Lords. Application, Lord. Bail
Relaxation
order
of bail
ಕೊಟ್ಟಿಲ್ಲ.
ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು?
ಅಲ್ಲ,
ಶೂರಿಟಿ ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂತ.
Cash surety 1 lakh ಹಾಕಿದ್ದಾರೆ. Lords, at the first instance, Lords, on 25/6/2024, Lords, bail was granted.
What's the offense?
302.
302.
Please.
Bail was granted, my lords, the condition, my lords, the solvent surety ಮತ್ತೆ bond for 50,000. Which subsequently.
Initially surety, only one surety was asked, 50,000 rupees personal bond. Then he files an application, I can't give surety, I'll produce a cash surety. Court has said, pay 1 lakh rupees. If he cannot pay 1 lakh rupees, let him give the surety.
The surety ಕೊಡಕ್ ಆಗ್ಲಿಲ್ಲ ಅಂತಾನೆ
ಅದು ಕ್ಯಾಶ್ ಕೊಡಿ.
Lords, he is
302 lakhs ಏನು ಕೊಡಂಗಿಲ್ಲ ಅಂದ್ರೆ.
He is not able to, lords, indigent person.
No, he's.
From last 2 years, my lord, Krishandom, lords, has got bail, lords.
ಶೂರಿಟಿನೇ ತಗೊಂಡು ಕೊಡಂಗಿಲ್ಲ ಕೇಳಂಗಿಲ್ಲ.
Killed his, 302 killed his wife.
Seriously?
Killed his wife.
Bail ಕೊಟ್ಟಿದಾರಾ?
She caught red-handedly with some other person on bail.
Caught red-handed with?
Some other person in the.
So you killed her?
Hangant allegation.
That is why bail has been given.
How did bail come about? ಅಲ್ಲ ಏರಿ ಒಂದ್ ಸ್ವಲ್ಪ ದಿನ ನೋಡೋಣ.
Bail was granted, not Sunday.
ಅದೇ how is it granted ಅಂತಾನೆ.
That's because sudden provocation ಅಂತ ಏನ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ.
List on list on 11th. We'll see. Yes.
Maintainability, lords, ಅಲ್ಲಿ 439.
Office objection square maintainability stands overruled.
Please.
List the matter on 11th in admission. Next.
Please.
Nishit.
Accused number 4 is stayed. Petitioner is accused number 60.
Maintainability ಏನು? ಅಲ್ಲ office note, sorry. Yes. Tag same order.
Gang war. Gang war.
Oh.
19.
My lord, offense under the provision SCS Act.
Atrocity ಒಂದೇನಾ?
Atrocity ಮತ್ತೆ IPC ಅಂತ ಹೇಳಿದ್ದಾರೆ. It is also because prisoner number 1 here lodge filed a appeal before the assistant committee regarding grant of land in favor of the grandfather of respondent number 2.
74 ಎಲ್ಲ ಇದೆ.
ಮತ್ತೆ suits ಉಂಟು OS pending.
ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಏನು?
ಅಲ್ಲ ಅದಕ್ಕೆ ಆಸ್ ಎ ಕೌಂಟರ್ ಪ್ರೈವೇಟ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಇದಾಗಿದೆ. ಅದು ಈಗ ಅವರ ಗ್ರಾಂಟ್ ಲ್ಯಾಂಡ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ. ಎಸಿ ಅವರು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್.
No, you forget atrocity, there are other offenses.
ಅದರ್ offenses ಇದಕ್ಕಾಗಿ ಅದನ್ನ ಆಡ್ ಮಾಡಿದ್ದಾರೆ. ಆಕ್ಚುಲಿ ಬೆಳಿಗ್ಗೆ ಯಾವ್ದು ಆಗಿಲ್ಲ.
Come to page 27.
ಅಲ್ಲಿ ತಾವು ಇದೆಲ್ಲ ನೋಡಿ ಯಾವ್ದು 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಪೇಜ್ ನಂಬರ್ 42.
ನೀವು ಸ್ಟೇಟ್ಮೆಂಟ್ ಬಿಡಿ ಸರ್.
ಅಲ್ಲ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಮಂಡೆ 164.
ಎಸ್ ಜಗದೀಶ್.
ಪೇಜ್ ನಂಬರ್ 42.
ಸರ್ಟಿಫಿಕೇಟ್ ಎಲ್ಲ ಇದೆ. ಒಂದು ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ.
42 ಮತ್ತು 44 ಪೇಜ್ ಅಲ್ಲಿ.
ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಂಡ್ಬಿಡಿ.
ಅಲ್ಲ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಲ್ಲ.
ಮಾಡಲ್ಲ ಅಲ್ಲ?
ಅಯ್ಯೋ ಮಾಡಲ್ಲ.
ಇಲ್ಲಿ ನಾನು ಕಾಸ್ಟ್ ಮಾಡಲ್ಲ.
ಅಲ್ಲ ಸ್ಟೇ ಕೊಟ್ಟು ಮತ್ತೆ
ಏನು ಕೊಡಲ್ಲ.
ಅಲ್ಲಿ SC/ST ಪ್ರೊವಿಷನ್ ಅಪ್ಲಿಕೇಬಲ್ ಆಗಲ್ಲ. ಯಾಕಂದ್ರೆ ಆಸ್ ಎ ಕೌಂಟರ್ ಬ್ಲಾಸ್ಟ್ ರಿವೆಂಜ್ ಆಗಿ ಸಿವಿಲ್
ಪಬ್ಲಿಕ್ ಪ್ಲೇಸ್ ಅಲ್ಲಿ
1 HCGP additional SPP 2 emergent note. Next.
ಅಲ್ಲ ಇಲ್ಲಿ ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಉಂಟು.
No.
ಅಲ್ಲ
civil dispute is not a license to assault. ಹೇಳಿಲ್ಲ.
SC/ST ಇದು ಪಬ್ಲಿಕ್ ಇಲ್ಲ ಪ್ರೈವೇಟ್ ಪ್ಲೇಸ್. ಯು ಆರ್ ಲಾಸ್ಟ್ ಕೈಂಡ್ಲಿ ಬೆಳಿಗ್ಗೆ
ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ.
ಅಲ್ಲ 7 o'clock ಬೆಳಿಗ್ಗೆ.
ಈಗ ಎಲ್ಲಾ ಕಡೆ ಜನ ಇರ್ತಾರೆ.
ಅಲ್ಲ ಬೆಳಿಗ್ಗೆ ಇಲ್ಲಿ 7 o'clock.
ಯಾಕೆ ಬೆಳಗ್ಗೆ ಇರಲ್ವಾ?
7 o'clock. Even government has cancelled the grant also.
No. Yes. ಬರ್ಲಿ ಅವ್ರು ನೋಡೋಣ. Next.
20.
ಏನ್ ರಿವ್ಯೂ?
Please. Lords, compromise petition entered by me, my lord, in the 2006 suit came to be challenged by the respondent number 1 herein. Lords gave liberty, my lord, to go back to the same court under order 23 rule 2.
Correct. It is not
this, my lord,
ಲೋಕ ಅದಾಲತ್ ಇದು.
Please, my lord. So writ petition is maintainable.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು? ಸರ್ವ್ ಆಗಿಲ್ವಾ ಅವಾಗ?
Served, my lord, advocate Shanti.
ಈಗಲೂ ಸರ್ವ್ಡ್? ಅಲ್ಲ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರು ಅವಾಗ?
Advocate Shanti Bhushan.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ?
Respondent number 1.
Then serve ಮಾಡಿ ಅವರಿಗೆ.
Have served a copy.
ಬರ್ಲಿ. We'll take it on Tuesday.
Great.
Yes. List on Tuesday, fresh matters.
Great.
We'll restore it and send it. Let him come.
Please.
21.
After the registration of the PML Act.
Nande order back first.
Please. And the
grounds in the grounds of arrest and reasons in the reasons to believe.
No, this is that cognizance, while taking cognizance, accused has not been heard.
Pre-cognizance hearing opportunity kottilla anta.
The latest judgment is also.
And we have to send it back.
my lords, may I request for a pass?
Even for
Says-
PMLA, it is
Yes,
applicable.
applicable.
No, an order has been passed, my lords. This was before the BNS was even,
That is exactly
before
what
it
is
came into
covered by
effect.
this latest.
Page number.
There are three, and what? And on page, on para 8. Specifically, same contention, much prior to the commencement of the BNSS.
Covered by this.
May I request for a pass, my lords? He's on his legs.
ಎಲ್ಲದರಲ್ಲೂ ಪಾಸ್ ಓವರ್ ಕೇಳಿದ್ರೆ. Tomorrow fresh matters. Tomorrow ಇಲ್ಲ. Tuesday fresh matters. If you don't come, I'm going to finish it. And no Passover. Yes.
22.
For the petitioner, my lord. My lord, FIR is stayed. Based on that stayed FIR, my lord, the ED has conducted investigation and now they have initiated attachment order that has been stayed by this honorable court, my lord.
Predicate offense also is here.
Yes, my lord.
All right. Heli.
Predicate offense is not listed today, my lord.
Which is that? Number.
That 81 criminal petition 8186 of 2023.
Tag this petition along with criminal.
There are other petitions, my lord. In
ಕೊಡಿ,
that
ಎಲ್ಲ
there are
ಕೊಡಿ,
7
list
petitions.
ಕೊಡಿ.
There are all
Predicate
7.
offenses ಯಾವ್ಯಾವ ಎಲ್ಲ ಕೊಡಿ.
No, in this case, only the predicate offense is that 8186, my lord, petition number.
ಬರ್ಕೊಡಿ.
But against this person, there are several FIRs and all the FIRs have been stayed, my lord.
ಸ್ಟೇಟ್ ತಾನೆ. ನಂಬರ್ಸ್ ಇದೆಯಲ್ಲ.
Yes, my lord.
ಎಲ್ಲ ಕೊಡಿ. Tag along with so and so. Then what is the allegation against you?
So 420, my lord, cheating and 420. I was a promoter with a builder and the first accused has cheated everybody,
Buds
including
Act
me.
ಇದೆಯಾ?
Sorry, my lord?
Buds Act ಇದೆಯಾ predicate offense ಅಲ್ಲಿ?
No, my lord. It's only 420.
All right. List
And
on,
I have already, there is an agreement between me and first accused.
list on 10th.
My lord's prosecution complaint is filed.
ಅದ್ ನೀವು ಹಾಕ್ತೀರಾ ಬಿಡಿ. ಇಲ್ಲಿ objection ಹಾಕ್ತಂಗೆ ಜಲ್ದಿ ಹಾಕಿರ್ತೀರಾ ಅಲ್ಲಿ. You would have filed it very fast. Yes.
23.
So in one, I have not filed it yet.
Then file it by the next date.
23.
I appear for the petitioner. Lord's offense and Lord's PMLM Lord's offense. Lord's 5 kg Lord's gold was smuggled Lord's from Dubai to India. Lord's I was caught Lord's in the airport itself. Lord's the allegation is that Lord's there are 11 lakh Lord's in the loan account. That Lord's I've closed it by selling my car Lord's and I've closed it. The amount that is closed Lord's used for closing of account. Lord's they're now treating that as proceeds of crime and PML has been Lord's invoked. Lord's even Lord's in the prosecution complaint. Lord's they say that Lord's the amount that is used Lord's I've disposed of the vehicle and Lord's 11 lakh amount is only Lord's the proceeds of crime is the allegation. Lord's 1 year ago Lord's I have disposed of the car. I have Lord's repaid the loan. Savings account Lord's cash in account is there. These Lord's amount is now classified as Lord's proceeds of crime and PMLA is invoked.
My lord's prosecution complaint has been filed.
No problem.
He has been appearing before the.
No worries.
Please, my lord.
Anything else?
My lords, we have filed a detailed objections. He was found with 6,000 grams of gold, my lords.
5,000.
6,000.
5,559
6 kg. Yes.
Grams of gold. So we have filed a
Now
detailed.
what happened there?
Please, my lords, before the court below, my lords, charges are framed, my lords.
Charges are not framed.
In the predicate offense.
In the predicate of.
No, my lord. It is
No,
still.
no, before this only, my lords, we have filed
Custom Act, my
prosecution
lord.
complaint.
Custom Act, my lords, the proceedings are going on, hearing before charge is there. Even, my lords, in the special case, my lords, it is now posted for hearing before charge. Charge is not taken place. Lords, the allegation is of, my lords, only 6 lakh. I'm just a carrier. Lords, I've stated that 2 other persons have given me the gold. Lords, they are not included in the complaint, but only the carrier is now, Lords, proceeded on the count of 11 lakh rupees that is in my account.
He might as well appear before the court and make all these submissions what he is making here, my lord.
The proceedings pending ಇದೆಯಲ್ಲ ಅಲ್ಲಿ.
Lords, proceedings pending.
Then 2013 proceeding.
Lords, 2013 proceeding. 23, 24 they filed this Lords,
Complaint.
Complaint. 24 Lords they initiate the complaint before the special court. Now, my lords, 25 the cognizance is taken.
Now on what ground are you here?
Lords, I am on the ground, my lords, that proceeds of crime. Lords, that was 1 year prior, my lords, that is in my account. Lords, the only allegation is that undisclosed cash asset of 11 lakh is my account.
Where do I get that?
My lords, the page 36, my lords, of the petition.
Chocolate box ಅಲ್ಲಿ you are bringing
I
6.
have brought, my lords, that is the allegation, my lords, that is there. My lords, the allegation of, my lords, 11 lakh is in page number 42, my lords, the analysis. Lords, the three tables, my lords, that is there. From page 41, my lords, the total amount into 11 lakh 443 rupees. Lords, the smuggling that takes place, my lords, is on 16/12/2013. Lords, the cash deposits, my lords, are in 10/8/2012, 16/8/2012, 23/8/2012. And my lords, the last transaction of 24/1/2013. That is, my lords, I have sold my Travera car and my lords closed the loan account. Lords, when there is, my lords, no proceeds of crime also. Lords, there is no allegation that there are any other smuggling that has taken place. Lords, the invocation of, my lords, the PML itself is, my lords, incorrect. And there is, my lords, only the allegation of carriers, my lords, against me.
Yes, madam.
My lords, so far as proceeds of crime is concerned, my lords, we.
No, you get jurisdiction if it is proceeds of crime.
Please, my lords.
Where is the proceeds of crime?
My lords, proceeds of crime is, we have found out that it
Wait,
is
what have you
mentioned, my
found
lords,
out?
in the prosecution
What have you
complaint.
found out?
We have found out, my lords, that he was a carrier carrying that much of money.
That is, he is caught and everything is over there only.
My lords, pursuant to that, we have proceeded and we have found out that.
And you 6 kgs gold ge 11 laksha ಏನಿರಲ್ಲ account ಅಲ್ಲಿ.
My lords,
Proceeds ಇದ್ದಿದ್ರೆ it would have been much higher.
my lords, this is part of the proceeds.
Where?
My
You
lords,
can't imagine anything and everything
but
and then
I
register.
did not imagine, my lords. It is mentioned in the complaint
In what?
itself categorically, my lords.
In what?
In the complaint itself, my lords. Let him meet all this before the court. The
No,
court
if there
has
is no
seized.
proceeds of crime itself, why should we undergo the rigmarole?
My lords, he can appear before the court and make a necessary submission. The court below is equipped enough to understand what is the proceeds of crime, my lords.
Oh, that is doubtful, man.
My lords, in that case, my lords may have it tomorrow. I will demonstrate
You will
where is
get
the
ASG
proceeds
and
of.
come.
My lords, I'll demonstrate from the complaint. Please, sir. My lords, because the matter has been already seized by the court and
That doesn't mean that my hands are tied.
not at all, my lords.
Then-
My lords can look into it, but that was not what the ground on which the petition has been filed.
That is the exact ground, my lords, the petition is filed. My lords may see the grounds also. They have, my lords, filed detailed objections, my lords, against this also. Even before notice issued, my lords, they file objection. Now they say,
Correct.
my lords,
That's because you serve a copy. Alla.
Yes.
now they say, my lords, that proceeds of crime ground is itself is not
My
there.
lords, all these things they can argue before the court below. We have filed a detailed complaint. He has been appearing from 2024 before the court.
So we will decide it because interim order ಕೊಟ್ಟರೆ next step apex court ಹೋಗ್ತಾರೆ.
Lords, because tomorrow, my lords, I have already taken 4 times, my lords, now for charge. Lords, 6/6, my lords, date is given
And for framing of charge.
for framing of charge.
Right. We'll take it on 11th. The concerned court shall defer its act of framing of charges till the next date.
My lords, the court is deferring it because of this ground
Lords,
anyway.
if I have once filed memo, my lord, stating writ petition is
They are
pending.
not hearing.
Please, grateful.
Yes.
24.
Disproportionate asset.
13.
My lord, disproportionate asset case, Satish Babu's case, which coordinate bench
ಅದೇ,
has
this
decided.
Krishna Kumar
Could I
ಅವರು.
just take
ನಿನ್ನೆ
about
madam ಅದು ಕೊಟ್ಟಲ್ಲ.
ಒಂದು 5-10 minutes? I'll just explain what has happened so that my lords.
On submission, statement of objections are ready. Today I will file it to the court.
Not on the merits of the matter, on the coordinate bench's ruling, so it's.
Yes, Chowta sir.
My lords, that is in the case of Satish Babu, my lords. Please notice, my lords, the two contentions that we took, which we said were still open for us to take. The contention we took was, if the source report is inadequate, sketchy, and does not contain all the details necessary, the desirability of having P. This was one contention we had taken. Second contention is, my lords, the second proviso of 17 requires application of mind on the part of the SP to permit investigation. These two contentions, my lords, may now kindly notice paragraph 6, my lords, at page 5. My lords would notice the contention.
Yes.
First contention, desirability of PE. Second is application of mind. Then, my lords, 6.1 at page 6, we pointed out what is the flaw in this source report, how it is inadequate, 6.1. And the judgments we relied on, my lords would notice, Gangadharaya, Sudhakar Reddy.
Gangadharaya reverse agilva.
How that it came back. It has come back, my lords. After it has come back, we pointed out on what circumstance it was reversed back. So, my lords, I relied on Gangadharaya, Sudhakar Reddy, Channakeshava Reddy, Vijay Lakshmi, Nirankar Nath Pandey, my lords would notice at page 7, and Ashish Dave, my lords, where even in IPC offences, where the desirability of having PE was held. Per contra, my lords, please notice paragraph 7, my lords, the contention taken by Lokayukta. They said when it was remanded back, they can't take all these contentions, which according to them had already been decided by the Supreme Court. This was a specific contention.
It was not decided.
So that became a point for consideration, my lords. Paragraph 7, they took that contention.
Para 10. Yes.
Paragraph 8, by way of reply, my lords, he said the 2 points are left open. Paragraph 8. Now, my lords, paragraph 10, 4 points for consideration. Page 11, whether the order of the Supreme Court would come in the way of considering these two contentions. 10.1. Then, my lords, desirability of PE is point number 2. Whether impugned FIR is valid, sustainable 3. And 4 is on the second proviso of 17. My lords, from page 12, paragraph 11 till 11.10. So page 12 to page 82, my lords, is all on point number 1. Where, my lords, the court went into each of the judgments, my lords. If my lords would kindly notice.
I saw that.
Yes, my lords. Each judgment, the extraction thereof we get.
Extensively considered.
Very extensively, my lords. And then the answer. My lords, 11.2 may be noticed once at page 28, my lords. 11.2. In pursuance of the aforesaid judgment of the apex court, the present petition has been remitted back to this court for consideration afresh in accordance with law. A perusal of the aforesaid judgment passed by the apex court will indicate that 2 primary grounds laying challenge to the registration of FIR, that is non-conducting of preliminary inquiry in accordance with 9 of Lokayukta Act and direction given by DYSP for investigation, were taken note of by the apex court in Sudhakar Reddy's case. Then Sudhakar Reddy's case, my lords, is extracted. Channakeshava's is extracted. And then, my lords, please notice page 31, second line, my lords. However, this court did not record any finding that conducting of preliminary inquiry was desirable, not desirable, or warranted, not warranted. And the said issue was not considered by the apex court in its remand order and accordingly remitted back to this court for consideration afresh on all grounds, including the said issues. This is a specific finding, my lords. And on that paragraph, whole thing is considered. Then, my lords, 11.4 at page 32, Vijay Lakshmi's case, Sudhakar Reddy's case, Channakeshava's case. 11.4,
Yes.
page 32.
Yes.
Thereafter, my lords, after considering these 3 case laws, straight away, my lords, I will point out
11.7.
11.7, page 79, my lords.
Yes.
As can be seen, could I read this one portion, my lords? As can be seen from the aforesaid judgments, the apex court has categorically reiterated that whilst conducting holding of preliminary inquiry cannot be said to be mandatory requirement without which a case cannot be registered against the accused, whether a preliminary inquiry is required or not will depend on the facts and circumstances of each case. The apex court has not laid down any absolute principle of universal application to the effect that preliminary inquiry is not desirable, required in corruption cases, and the aforesaid judgments of the apex court cannot be construed, treated, understood as having laid down any such absolute universal proposition as sought to be contended by the learned counsel for the respondent, and consequently the contention urged by the learned counsel for the respondent Lokayukta cannot be accepted. Then they say if there's no foundational facts, my lords, desirability to have a PE is required. So 11.8, my lords, 9, page 81, my lords, first line in page 81. It is therefore clear that the issue question relating to necessity and justification for dispensing with preliminary inquiry, particularly in the absence of credible foundational material, remains open for consideration and adjudication by this court in the present petition, and as such it cannot be said that the petitioner is precluded from contending that preliminary inquiry was desirable, required, warranted in the facts and circumstances of the instant case, and various contentions urged by the learned counsel for the respondent Lokayukta cannot be accepted. Then my lords, Gangadhar Ayya's case, my lords would get it 11.10 at page 81.
Yes.
Thereafter, my lords, point number 1 in page 82. Point number 1 is accordingly answered in favor of the petitioner and against the respondents by holding that the petitioner is not precluded from contending that conducting of preliminary inquiry was required, desirable, warranted. Then the court took up the source report, my lords, in point number 2, whether that source report was complete for the registration of FIR. All the flaws were pointed out, my lords, which is extracted, and then the court would hold, no, this is an incomplete sketchy report. If it is incomplete sketchy report, you ought to have a P. Don't hurry it up. And then, my lords, the relevant portion. Circular is very important, my lords. Look at
That
this.
was what was relied on Channakesh.
Yes, my lords. Please notice page 83, my lords. Lokayukta circular is extracted 11/5/2023. Their own circular says how they should go about it, and what they're doing is contrary to their
And they seldom follow it.
They seldom follow it. And that, my lords, after extracting it, court notes that, my lords, the manner in which you yourself know how you should do it, you're not following the same. And then, my lords, the court would go on to quash the FIR, my lords, and consequently even that order under 17 is quashed, remitting it back to the stage of source report for them to conduct P.
Preliminary inquiry.
This is what has happened.
Same thing we'll do.
Same thing. Even in our case, I'll be able to demonstrate, my lords.
Tomorrow, my lord. I have to file my
I'll
objections.
grant you time, file your objections.
Okay.
Heard the learned senior counsel Sandesh Chowta appearing for the petitioner. The learned senior counsel takes this court to the judgment of the coordinate bench threadbare to explain that the case at hand or cases at hand of the kind that is projected before this court would stand completely covered by what the coordinate bench has held. The learned counsel B.B. Patil 6.
No, my lord. Venkatesh Arbatti, my lord. Venkatesh Arbatti.
Venkatesh Arbatti 6, a week's time to file statement of objections or make his submissions as the case would be.
Could we request for a stay, my lords, because only
Yeah,
service
agilva,
condition, like investigation is still going
This
on
condition
despite this.
ಇದೆಯಲ್ಲ, wait, we'll finish it off.
My only
Yes.
problem is they complete the investigation, my lord.
They will
That
not, don't
becomes-
file charge sheet and all.
No, my lord.
The filing of the final report without the leave.
They are not cooperating with the investigation, my lord.
we
They are-
say
We have
that,
given
my lords?
notice also. They have not cooperated, my lord.
My lords,
We
I
have
will
given a
point out.
twice-
ನೀವು ಅದಕ್ಕೆ ಇದೆಲ್ಲ ಏನ್ ಗೊತ್ತಾ, ಪ್ರಿಲಿಮಿನರಿ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಬಿಟ್ರೆ ಏನೂ ಬೇಕಾಗದೇ ಇಲ್ಲ.
They are not cooperating with the.
I will see, list on 10th, I've already protected you.
Here, my lords, virtually my father's 12 properties out of 14, my lord, stands in the name of my father, my mother, and my wife.
When were they purchased?
And purchased at an undisputed point of time, my lord. Check period they keep for about 25 years. Property standing in my father's name, who was a public servant, retired public servant. My wife working in SBI, my lords. She had a declared income of 3 crores. Now they take it as 1.3 crores. I'll be able to demonstrate each item, how it is.
10th ಅಲ್ಲ ರಾಷ್ಟ್ರದಾಗ ಹಾಕಿ.
My lords, let them not precipitate it, my
They
lords,
will not,
unnecessarily.
ನೀವೇ ಕೋಆಪರೇಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ.
We have given
Cooperate
twice,
is-
we have
my lords,
given the
ಇದು
notice, my lord. They
he
have not
matter
cooperated.
ಹೀಗೆ pending ಇರುವಾಗ, my lords,
Don't file the charge sheet.
Yes, my lord. We will.
Please, my lord.
ಒಂದು ವಾರದಲ್ಲಿ ಏನ್ ಹಾಕಲ್ಲ ಅವ್ರು.
Deeply obliged, my lords. My lords, there are other matters also.
ಅದೇ
as
ಲಿಸ್ಟ್
in-
ಕೊಡಿ ಅಂದ.
ನಾನು ಹೇಳಿದೆ.
ಲಿಸ್ಟ್ ಕೊಟ್ರೆ
Hold them, my lords. Please.
ನೀವು ಅಪಿಯರ್ ಆಗೋದು ಕೊಡಿ, ಮೆಕ್ಕಿದ್ದು
Yes.
ಮೇಡಮ್ will do it.
Yes. Because some of it were reserved, my lords. They have to, for being spoken to, we may have to mention it, my lords.
Let me see.
Please.
25.
Appearing for respondent number 2, my lords. Lords, we have filed the wakalat, my lords. The name is.
Clearly,
This
charge
ma-
sheet has been filed.
This matter, Lords, my lord, it was listed on day before yesterday. 175(3) was not compliant. So Lords, you wanted to remand it. It's private complaint, my lord.
78, 79.
Well, the charge sheet has been filed. Unfortunately, my lord, trial court, instead of 175, used 223.
223.
But anyway, charge sheet is filed, my lord. I've been told.
And
That is challenge ಮಾಡಿ ಅಷ್ಟೇ.
Lords, even in
Him
this
challenge
case of defamation, my lord, 356 is also involved.
No, what is the, oh, ಇದಾ?
ಅದಕ್ಕೆ ಡಿಫಾರ್ಮೇಶನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ ಅವರು
ಇದಕ್ಕೆ IT Act ಅಲ್ಲಿ ಫೇಕ್
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿ ಈಗ ನೋಡೋಣ. ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
Charge sheet has been filed.
ಚಾರ್ಜ್ ಶೀಟ್ ಫಾರ್ಮ್ಯಾಟ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಮೂವ್ ಇಟ್.
Please.
ನೆಕ್ಸ್ಟ್. ಹರ್ಡ್ ಸೊ ಅಂಡ್ ಸೊ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಲ್ಲ ಹಾಕಿ.
Please, my lords. Most great. Please. Already Jagadish sir.
ಅಜಯ್
26.
ಅಲ್ಲ ಸಾರಿ ಮೋಹನ್ ಕುಮಾರ್.
Atrocities Act, my lord. Present petitioners are accused number 2 to 5, my lord. Complaint ಅಲ್ಲಿ ನಮ್ಮ ಮೇಲೆ ಏನೋ ಅಲಿಗೇಷನ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ವೈದ್ಯರಾದಾಗ್ಲಿ ಏನೋ ಇಲ್ಲ ಸ್ವಾಮಿ. Complaint is page number 26, man.
Complaint is by?
Page number 26, man. 26 ಅಲ್ಲಿ is against accused number 1, man.
This Jagdish.
What is the line? Secure the records, my lord.
ಅಲ್ಲ ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಏನಿಲ್ಲ ಇಲ್ಲಿ.
We will.
ಆದ್ರೂ ತರಿಸಿ. ಎಸ್ 10 ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
Meanwhile, stay, man.
ಅವತ್ತು ತಗೊಂಡು. ಎಸ್.
ಅಡಿಲ್ಲ ಪರ್ಸಿಪಿಟಿ ಆಕ್ಷನ್
ಏನಿಲ್ಲ.
ಬೇಲ್ಗೆ ಹಾಕಿದೀವಿ ಅದು ಇದು ಹೋಗಿದೆ ಅಬ್ಜೆಕ್ಷನ್
Will not array, will not record, my lord.
The learned additional SPP submits that no precipitative action will be taken against.
No coercive action.
No coercive steps will be taken against the petitioners. ಅಷ್ಟೇ ಸಾಕು.
As item 27, my lords, I beg to appear for the petitioner. As only
My
one
lordship, on this matter, I've been instructed to appear on behalf of the second respondent.
Moment, sir. What's
1996, I am one of the partners of the firm. I have been conducting, my lords, business since 1996. My brother, my lords, who's only a name lender to the firm, files a complaint in 2026 that, my lords, I have committed an offense since 1996, stealing, my lords, goods in my own firm, and, my lords, I have committed trespass in my own shop.
File your objection, sir. The learned counsel, Pratik.
Lordship, the 72, FR number 72 is what they have also identical facts and circumstances, and FIR is registered against us.
Which is
And that is an FIR number 72. my lord.
You get ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿ ಐ ಕ್ವಾಶ್ ಬೋತ್. ಇದೇ ಕೆಲಸ.
ಇನ್ನೂ ಇದೆ ಇವರ ಮೇಲೆ ತುಂಬಾ.
ಇದೆ ಆರ್ಬಿಟ್ರೇಷನ್ ನಡೀತಾ ಇದೆ.
There are multiple cases between them.
Your lordship already.
All cases we should close.
Arbitration
Misuse of criminal justice system.
Your lordship has already quashed the civil proceedings on the previous occasion because they had misrepresented and approached the trial court. I'll produce all the documents. Lord. Request for a date next week.
Civil proceedings quashed.
ಯಾವ್ದಿದು GMCPC ಇಲ್ಲ.
My lords, I would go before the civil court. An ex parte order of injunction, my lords, was granted in my favor. That order was challenged before this honorable court. And we made a submission. My lords, I'm sorry how my learned friend is saying it. Civil proceedings were quashed. We made a submission that there is a arbitration clause in the partnership deed.
That is at page 73.
Please, my lords, I have produced it. That, my lords, I am demonstrating my bona fides. I'm in fact submitting arbitration cases going on. My lords, I must bring one more important fact.
ಬೇರೆ ಏನೇನು ಕೇಸಸ್ ಇದೆ ನಿಮ್ಮ ಮಧ್ಯೆ ಕೊಡಿ ಇಲ್ಲಿ.
I'll prepare a list and provide my objections.
List the matter. Learned counsel Pratik Chandramouli accepts notice for the respondent complaint registry to print the name of so and so. List on 17th.
My lords, I have sought for stay.
I'll that list on 17th. List of matters pending between the parties, i.e. the members of the same family. Brothers, huh? Brothers. ಕೊಡಿ tag ಎಲ್ಲ petitions pending ಇದೆಯಾ?
No, my lords, I am not aware if they have filed.
Now, my lords, there shall be an interim order of stay of investigation quay the petitioners to the next date of hearing.
I'm so deeply obliged. Lords, here the
ನಿಮ್ದು ಹಾಕಿ ನಿಮಗೂ ಕೊಡ್ತೇನೆ.
Ali investigating officer, my lords, would say, I want to appoint an independent private valuer. I'm going to open the shop now on.
What shop is this?
Hello,
My learned friend is sorry, my learned friend has not been instructed that we are not a sleeping partner. We are also 50% partner as per the partnership deed. We've been running the shop together.
You resolve all your disputes in the arbitration. Don't use criminal machinery for that. Yes.
I'm sorry.
28.
28, we have sought a permission, my lord. Your lordship is permitted to conduct investigation. Now, investigation has been completed. Charge sheet is ready to be filed.
There is
Then challenge the charge sheet, my lord. We'll file a charge sheet.
ಏನಿದು?
There is a direction.
76.
There is a direction not to file charge sheet.
Correct, we have not filed it.
It's a matter where, my lord, it's a clear case of abuse of process of law, my lord.
Place the entire
The-
charge sheet
Please,
material.
material ಕೊಡಿ.
But second respondent, my lord, files a complaint, my lord. After the person who claims to be her husband files a SC/ST atrocity case, which ended up in B report. My lord, there are series of cases, my lord, improvement has been made in the entire case. But initially, it was a case of, my lord, 354. And when her husband files the first atrocity case, there is no allegation of sexual harassment or anything. But subsequently, my lord, she has given statement, my lord, and changed her stand from time to time. After lapse of 1.5 months, my lord, she gives, my lord, this narrative and makes, my lord, it a case of 376. In the meantime, my lord, the first complaint was lodged by the petitioner regarding, my lord, the blackmail done by the second respondent and her alleged husband. But now the charge sheet has been filed in that also. Now the cognizance has been taken, summons has been issued. It's a clear case of abuse of process law. As, my lord, counterblast and afterthought, case has been filed against the petitioner. But the first complaint was made by the petitioner, my lord, on 28/3/24. But the husband files complaint against the petitioner, my lord, on alleging atrocity.
ಅದೆಲ್ಲ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೀನಿ ನಾನು ಎಂಟ್ರಿ ಮಾಡಲ್ಲ while granting some order.
This matter requires to be, my lord.
Matter requires to be dismissed right away.
No, my lord. It is a
Yes.
case of classic case of abuse of process of law.
Charge sheet challenge ಮಾಡಿ ಹಾಕದ್ಮೇಲೆ.
My lord, now here is a case where, my lord, prima facie, my lord, it is abuse of
ಈಗ
process of law.
376, 354.
That has been added later after lapse of 1 month.
No problem.
My lord, subsequent
No
to, my lord,
bar.
happening so many political developments. It's a clear
Political
case.
developments.
Yes.
ಅದಕ್ಕೂ ಇದಕ್ಕೆ-
Petitioner was a practicing advocate. He also filed, my lord, certain cases against some political parties or leaders, my lord, challenging their election. In that context, my lord, the political rivalry started and they set up this case against him.
No, we don't know, but the offenses are horrible.
But that has been added subsequently, even assuming, my lord, the
No, in a
first-
376, 354A,
354 also, my lord,
354C,
there is a delay of 3
354B.
months, my lord. 3 months delay in alleging 364, 354. And in the husband's complaint, it is not at all mentioned. My lord, it's only as a counterblast after lodging my complaint, my lord, for blackmailing and even he
ಈಗ
is
ಹೆಂಗೋ
not,
charge sheet ready ಇದೆ.
my lord, he is not even husband. That they will
Charge sheet
prepare.
challenge ಮಾಡಿ.
My lord, my lord, he is.
Proceedings ಹಾಕಿರೋದು ಯಾರು?
No, we have filed because we wanted to.
But now the person who claims to be her husband is not husband at all. But she has taken divorce from some other person subsequent to this. But they made all false, my lord, contentions before
No,
various
this-
authorities.
these
The very
offenses-
case itself is false.
No, these offenses, 354, 370, they do not concern husband or wife.
But
If
the
you have
narrative,
outraged the
as
modesty
her
of
own
a woman,
statement,
so
in her own statement, she says so and so is her husband. But as a matter of fact, somebody else is her husband.
What-
And that
ಎಲ್ಲ matter
person
of
so and
evidence.
so files one more atrocity case against me. That has been ended up in B report. But it's not a simple case of, my lord, some person or making a case of 376.
So, offenses
Lord,
are grave.
Stage by stage, it has been improved.
No, offenses
Kindly
are-
see, my lord.
offenses
Offense
are
is, my lord,
grave, sir.
376. Now they have added. But in the initial complaint itself, my lord, the 354 is the allegation that has been made after 3 months, my lord, according to the
That we
complaint.
don't know. Now that the charge sheet is ready to be filed,
Charge sheet is ready, my lord.
let them file the charge sheet, you challenge the charge sheet.
But now kindly see, my lord, the
Charge sheet laying offense same,
yes, we tried to, my lord, move it, my lord, earlier. It was not listed. Now, my lord, they brought this charge sheet, my lord, to frustrate this litigation. And now,
No,
even
not just statement, my lord, there are also audio conversations and other things which many other circumstances which discloses that offense has been committed. Lay and all those things, let them challenge the charge sheet and come before the
because charge sheet is not filed because of my order.
No, but
I will permit filing of the charge sheet and permit you to challenge the charge sheet. Offenses are there.
no, but my lord, kindly see, my lord, at the initial stage itself, we, my lord,
164
came before this
164
honorable court
statement
and
nodi.
we made, my lord, this submissions, my lord. And
Statement, sir.
after considering that only, my lord, the interim order was granted.
ಏನು 164 ನೋಡಿ.
Lord, everything was placed before your lordship, my lord. 164 was recorded, my lord, after lapse of 4 months
That
from the
we'll see,
incident.
yes.
And my lord, stage by stage, they have
ಇಲ್ಲ
improved
charge
the
sheet
case.
challenge ಮಾಡಿ will permit all the contentions to be urged there.
And I may permit it to, my
Yes.
lord,
Heard the learned senior counsel, Shri Arun Sham appearing for the petitioner. This court on 22/10/2024 had passed the following order. The final report was directed not to be filed without the leave of the court. Therefore, the learned additional SPP submits, though the final report was ready to be filed, it is not because of the interim order. They have preferred an application seeking vacation of the interim order. The learned senior counsel would submit that he will be reserved liberty to challenge the charge sheet so to be filed before the concerned court. In the light of the said submission, I deem it appropriate to dispose the subject petition, reserving liberty to the petitioner to knock at the doors of this court, raising a challenge to the charge sheet, and also grant permission to the state to file the final report before the concerned court without broking any further delay.
beg to appear for the petitioner in this matter. Challenge proceedings before the magistrate, my lord. The offences alleged against me are, my lord, for cheating, breach of trust and forgery. The lordship were to take this honorable court order on 12/12/2024. An exhaustive interim order comes to be passed, my lord.
12/12?
2024. There are two prior civil litigations, my lord. Interestingly, my lord, the accused number 2, who's my wife, is neither party to the transaction, nor has she participated in any offense, nor there is any a single allegation against her, my lord. However, the learned magistrate, my lord, takes cognizance against her as well. And an important aspect is this, my lord, I have not been heard before cognizance is being taken. And I've also produced, my lord, the main allegation is that one document, my lord, which is said, running page number.
What's the offense alleged here?
Cheating, breach of trust and forgery.
False evidence, 191, 192, 193 as well. Using the forged document, not the basis that they file a suit. If I may place the facts in nutshell, the case of the petitioners is that they invest certain money in a sale deed which I executed. In the sale deed, it's I alone who has paid the entire sale considered, not a whisper about any of their contribution. They sign as a witness to the said sale deed. But subsequently, immediately the next day, fabricated document is got up, styling it as agreement of sale, in which the petitioner and other respondent whom I filed a case against, all of them see that they have invested a certain portion of money. My signature is forced. Based on that, they file a civil suit saying for partition. It's actually in the garb of they had to actually file specific performance. They file for partition, saying that based on this agreement we had invested certain money we have not got. I may not obtain a certified copy. I come to know that my signature is forced. Then go to police. They've not taken up. Then
private complaint, do not for cognizance.
Yes. So the right of them being heard does not arise.
Oh, there, of course, yes.
I mean, that's his contention. Then the learned magistrate take cognizance. Now, the main crux, even if your lordship were to see, you have held that the civil suit. He mentions about two civil suits. One filed by him, saying partition. So vis-a-vis the investment allegedly he has made in my purchase. Sale deed. In the sale deed, not a whisper about the contribution made by him. The second suit is filed by me for recovery in a totally disconnected issue. I have filed based on in a project called Honenahalli.
So on this issue, there is no suit pending.
There is no on this issue based on this agreement, which is now subject matter. He files a suit for partition. In that suit, he does not pay stamp duty. It drags on the suit. Stamp duty notices are issued. He's got a stay. In fact, that matter is today also being heard at 2:30. That he ought to pay stamp duty. Doesn't proceed with that suit. And lots of me kindly see the premise in which the B report comes to be filed. B report, the only reason is the document in the question, which is forged, alleged to be forged, original is not available, hence B report. There is no notices issued to the accused before even getting the notice from the accused and before even examining the complainant and the notice sought. And yet another important fact is the petitioner files a case along with yet one other person as plaintiff number 2 in the suit. That person withdraws himself, pays up me money. Once he comes to know that this man has committed forgery, he withdraws from the suit. Therefore, that prima facie is not a. And basis that they go to a court based on that.
It's 204.
The series of events has not been narrated.
Your lordship judgments.
File a synopsis.
Very well.
Detailed synopsis.
Swami, first suit one is OS 477 of 17, which I filed. In that suit, my lord, they filed the written statement. They do not make a whisper about this agreement of sale. Thereafter, they file a suit, my lord. In that suit also, they do not whisper about this agreement of sale, which is challenger. That signature I've sent it before the Truth Labs. In Truth Labs, it's come out that is the very same person who has signed the.
He sends.
Truth Labs
He sends.
No, I have gone myself, my lord, because.
Yes.
I've made a comparison.
Anyway, my lord, I filed my synopsis.
On the synopsis, list of authorities.
My objections has synopsis list of dates. Yes, I have filed my objections.
We'll take it on. We'll declare it on 17th. If you file beforehand, munchane hakiri. Interim order subsisting will continue to the next date of hearing, 17th. Yes.
Lots under fresh matters.
Same stage.
Please.
Yes. Interlocutory.
Lots one other submission. Your lordships have granted interim order vis-a-vis only the petitioners, who are 2 of them of the 7 accused. But the trial court is not going ahead with the proceedings so far as other 5 accused are concerned. If that could be clarified, no, he doesn't have to say.
The interim order, interim order stands extended with the following clarification. The interim order is applicable only to the petitioners before this court and not to any other accused. The concerned court should not defer its proceedings on the score of pendency of pendency of this petition, which concerns only two petitioners.
That is the tenor of your lordship's order.
Whatever.
But still, my
One
lordship,
submission, my lord, can it be taken up on 22nd?
All right.
70th is good enough. my
No
lordship.
problem.
17th or some.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ. By then. yeah,
I'll file
yes.
it.
Great.
Hmm.
30.
For the petitioner, my lord, complaint, my lord, Atrocities Act, employee, my lord, files a complaint saying, my lord, that he was called by his caste name and he was abused. That is the allegation. My lord, kindly permit me to file a short list of dates and synopsis. Lord, he is a supervisor in my complainant is a supervisor in my factory, my lord, and he has worked with me for 18 years. On two occasions, my lord, there were problems in the sense, my lord, he caused loss because he did not do his work that was assigned to him, which led to loss. And there were show cause notices that were issued to him saying that he has to give a reply, and if it is not satisfactory, proceedings will be initiated. But the show cause notice issued is on 13/12/2024, which he files a reply, and I issue him a notice on 15/1/2025, scheduling, my lord, an inquiry to be commenced. He challenges that before, my lord, under ID Act. He files ID 2 of 2025 and asks for stay of those proceedings on 25/1/2025. Lord, the trial court, my lord, does not grant that order. Tribunal does not grant that order of stay. And pursuant to that, my lord, he files a complaint on 19/2/2025, saying, my lord, that he was called, they called him to the, my lord, in the middle of 2 or 3 officials, and he was abused, and also makes a statement, my lord, that thereafter he was made to sit in, my lord, when he comes to attend work, he was made to sit in the, my lord, watchman's room, and he calls that as illegal confinement and makes certain allegations. And this complaint is filed by saying that, my lord, this incident took place some 6 months prior to that. And there is no, my lord, averment also in the entire complaint and the FIR that any such statement, if even if, my lord, such statement was made, it was made in public view. And, my lord, there is no other allegation apart from saying, my lord, that he was abused by the name, by name of his caste. There is inordinate delay, my lord, 6 months delay in filing this complaint.
Where is the FIR?
FIR is at Annexure E, page 47. It's at, starts at 44, my lord. Content is at page 46.
Yes, sir.
My lord, continuously 3 days, my lord, complainant has forcibly confined in the dark room, my lord. In this regard.
Dark room, why?
It stated, senior has stated as it is a watchman shed, my lord.
A dark room, you keep watchman and dark room ಅಲ್ಲಿ ಇಡ್ತೀರಾ?
In this regard, my lord, there is a serious allegation against abuse of naming his caste, and other allegation also is there, my lord.
ನೀವು ಈ ಕಡೆ ನಿಂತ್ಕೊಂಡ್ಬಿಟ್ಟು ಹೇಳ್ಬಿಡಿ ಇದೆ ಅಂತ. Abuse, misuse.
And first count, my lord, first accused, my lord, is a cancer patient. And
Entry model ಇಲ್ವಾ? Entry model ಇಲ್ವಾ?
ಇದೆ. He was not even attending, my lord, at that point in time. Ultimately, to avoid inquiry, my lord,
not be a misuse like this. ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್. ಆಯ್ತು, ನಿಮ್ಗೆ ಅಷ್ಟೊಂದು ಬೈದಾಗ ಅವಮಾನ ಆಗಿದೆ, 6 ತಿಂಗಳು ಬೇಕಾಗಿತ್ತಾ ರಿಯಲೈಸ್ ಆಗಕ್ಕೆ?
After issuing the notice from the employer, my lord.
ಯುವರ್ ಎಂಪ್ಲಾಯಿ ಡಿಸ್ಪ್ಯೂಟ್ ಏನೋ ಬೇರೆ ಏನೋ ಮಾಡ್ಬಿಟ್ಟು ಇದನ್ನೆಲ್ಲ ಮಾಡೋದು ಮಿಸ್ಯೂಸ್. ಎಸ್, ಅಲೋಡ್ ಕೋಸ್ಟ್. ಈಗ ಡಿಕ್ಟೇಟ್ ಮಾಡಕ್ ಟೈಮ್ ಇಲ್ಲ, ಆಮೇಲೆ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಬಿಡಿ.
ಇಲ್ಲ. There's one more matter, my lord, of Dharwad bench, my lord has
No, that service matter alva?
Service matter. There are a lot of developments which have taken place. I will place it, my lord.
Place it.
Yes. Because
That deputation tane?
Yes, deputation. That person, my lord, has been now been posted elsewhere. My finance director, my lord, he's been relieved and somebody else has been posted there. But all actions by the government only.
Aitu, alright.
I will place it, my lord. It's posted.
If this has become infectious, then that become infectious, we'll close it.
Yes.
ನಾಳೆ ಹಾಕಿಸ್ತೀನಿ.
ಅದು 5th ಏನೋ ಇದೆ, ಡೇಟ್ ಇದೆ.
ನಾಳೆ 5th is day after tomorrow it will come.
Yes.
Hey, tomorrow is 5th, sorry. Yes, ನಾಳೆ ಬರುತ್ತೆ.
But I will place the material.
This is allowed cost. 2 ಇದೆ.
31, my lord. I pay for the respondent. Objection is ready. It is, my lord, the 7A. However, my lord, the petition is for release of amount. Trial court has rejected their application.
That can't be anyway. Objections be filed by the next date of hearing. No representation be of the petitioner. List on 17th.
Please.
Yes. Admission. Same stage, sir.
Instead of 17, 18.
18th, same stage. Yes.
52.
Petitioner counsel prays for 2 weeks accommodation. Is not feeling well. Has not come to the court.
Ticketing stay, sir.
Allah, he has not come to the court. Is not feeling well. He is
They have
bedridden,
not
madam.
accepted our objection copy. You have sent it by post. It has come back unclaimed.
Well,
Therefore,
Back.
there is no phone number, there is no email ID of the petitioner advocate.
Right, he was under treatment, my lord. He had some heart problem. And now, my lord,
The learned counsel for the petitioner submits that the arguing counsel has undergone surgery and is in the post-operative stage.
It may kindly be given, your lordship, because it is not getting listed only for last
It I will give date.
after
Yes.
2 weeks, my lord, any date may be.
List the matter on 30th June. Yes.
Great.
In the same stage.
33.
Petition this case. Offense is section 118, my lord.
Section
118 of BNS.
118.
There's a dispute between owner and tenant, my lord. The complainant filed a suit for eviction against me.
Vacating stay ನೀವು ಹಾಕಿದ್ದೀರಾ?
There is CCTV image of entire incident. Court amines have gone there to execute this thing. They have been attacked. Look at the photograph.
They are new tenant, huh?
ಹೌದು. I am for tenant.
This is the lady.
Yes, she is the lady. She
Multiple
tried to,
photographs.
this honorable high court in commercial appeal issued hand summons, my lord. So I tried to serve that hand summons for
ಈ
the,
ತರ ಸರ್ವಿಸ್ ಚಾಕು ಇಟ್ಕೊಂಡು
ಇಲ್ಲ, it is not a charcoal ಅಲ್ಲ ಅದು.
ಮತ್ತೆ ಏನದು?
Souter.
ಸೌಟ? ಓ, ಡೇಂಜರಸ್ ವೆಪನ್.
Actually, what has happened means, my lord, earlier before this attachment also,
ಇವತ್ತು ಅದು ಏನಾದ್ರೂ ಇರ್ಲಿ, ಇದನ್ನ ನೋಡಿ ನಾವು ಸ್ಟೇ ಕೊಡಕ್ಕಾಗತ್ತೆ.
stay is already granted, my lord.
ಅದಕ್ಕೆ ವೆಕೆಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ.
But, ಅಲ್ಲ,
ಏನಿದು?
just 5 minutes, my lord.
ಇದು ಸೌಟ ಅನ್ನೋದೇ ಡೌಟ್ ಬರ್ತಾ ಇದೆ.
She has even given that appliance also to the police station. She has given that.
ಹಿಂಗೆ ಈ ತರ ಕಾಪಿ ಸರ್ವ್ ಮಾಡದ ನೀವು?
ಅದು ನಮ್ಮ ಪೇಪರ್.
I have not served that copy.
ಈ ಕಾಪಿ ಅಲ್ಲ ಸರ್. ನೀವು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಕ್ ಹೋದ್ರು ಅಂದ್ರಲ್ಲ?
ಇಲ್ಲ, ಕಾಪಿ ಸರ್ವ್ ಮಾಡಕ್ ಹೋದಾಗ, my lord, they
ಹೌದು.
were trying to move the items which are not in the.
Anything else?
Yes, my lord. Just 2 things, my lord. When the attachment was going on, my lord,
You
they were
continue.
trying to.
Come at 2:30, we'll continue.
If I may make a mention, my lords. Well, I am to move a memo. The matter was listed before coordinate bench of this High Court. However, due to disability, the judge.
Lookout circular?
No, my lords,
Then?
it is a Karnataka Societies Registration Act matter, my lords. Elections are to be conducted on 7th, AGM is to be held on
Election
5th,
ಇಲ್ಲ.
my lords.
ಯಾವ್ದು madam ಅದು ಕೊಡಿ.
My lords, it was placed before the appropriate bench. However,
When do you want it?
there is disability. Today, end of list, my lords,
Today,
kindly. My lords, tomorrow is the AGM, my lords.
ಆಯ್ತು, we'll see. ತೊಗೊಳ್ಳಿ.
Grateful, my lords.
ಕಾಪಿ ಗವರ್ಮೆಂಟ್ ಎಜುಕೇಟ್ ಯಾರಾದ್ರೂ ಸರ್ವ್ ಮಾಡಿರಿ ಮುಂಚೆ.
Please.
It's a small mention, Malas. Serial number 35, Malas. I misplaced the IA copy, Malas. Seeking 2 weeks time to file objections.
It's vacating stay, madam.
Vacating stay,
Vacating-
so their own certificate is there.
Malas,
No adjournment in vacating stay at all.
Malas, we'll file objections for that
No.
same, Malas.
My lords,
No.
list 3, my lords, item 1. My lords, there's
List 3, yeah.
List
How's
3,
madam?
my lords, there's a change in council there, my lords. Anytime next week, Monday
minute.
also, my lords, just 2 days.
No, 2:30 there is that parted matter yesterday's, which will go on for some time. ರಾಜೇಶ್ವರ ಬರ್ತಾರಲ್ಲ? 2:30 sharp, I'll take it.
I'll tell you.
Yes. Then, yeah, list 3, ಯಾವ್ದು ಗೊತ್ತು?
My lords, in the connected matter, there's a change in council.
List 3 serial number?
1, my lords. Pavitra Ram.
Oh, ನಿಮ್ದೆ? ಹಾ.
ಲಾಸ್ಟ್ ಟೈಮ್
Short accommodation.
not to take any coercive action ಅಂತ ಹೇಳಿದ್ರೆ
ಹ್ಮ್.
not to take any coercive steps ಅಂತ they filed one more petition and they interpreted that to say that it is stay on the one-side proceedings and obtained stay in the vacation bench.
No, my lords, there was a provisional attachment.
ಅದು ಬೇರೆ.
There was a provisional
That is the
attachment,
issue,
my
my
lords.
lords. That's
Because the
misrepresentation.
ಹಾಗಾದ್ರೆ ಇರಿ. Wait.
Just Monday, my lords. Only 2 days I'm requesting, my lords.
ಆಯ್ತು. Tuesday, not Monday.
Very well.
Please.
Tuesday in orders.
10th.
ಆಯ್ತು, 10th in orders.
Fine, when it was getting disposed of, that results further investigation will be ordered, but results at final order ಏನಾಗಿದೆ remand ಆಗೋಗಿ. Results had told us not to other the petition and direct further investigation in that matter.
Let me see, wait.
The interim order to continue.
That will continue, sir.
107, can I make a request?
These 7A and 13 matters I will not take now.
Your lordship said indeed she is a retired husband. has
No,
died.
today I will not. I will post it next Thursday.
There was some.
Because there is some parted
Yes.
matter.
Very good.
34, it's a 7A matter, but I have sought for an IA for direction to produce the CCTV footage. Because the allegation is that there is a trap.
ಅಲ್ಲ, ಬೇಕು ಅಂದ್ರೆ ಇರಿ.
I'll ಇರ್ತೀನಿ. I'll wait.
ಇದ್ರೆ 3 ಗಂಟೆ 4 ಗಂಟೆ ಆಗ್ಬೋದು, 4:15 ಆಗ್ಬೋದು.
I'll wait.
Lordship, serial number 40, that
Submit.
medical negligence matter, that filed at IA. If a lordship has a heavy board today, could a lordships accommodate me tomorrow on some other day, Monday?
No, next week we'll take it.
Please, next week is, please.
Next week, ಇವತ್ತು ಏನ್ ರೀಚ್ ಆಗಿಲ್ಲ.
Please.
We'll try to take it next Thursday.
Please, could your lordships in that event say that it may come up in the fresh matters?
No fresh. Let it come on the stage where it is.
Please.
Because fresh matters get clogged then.
Please.
Serial number 48, my lords, any next week for the petitioner.
ಅದು ಯಾವ್ದು ಬೇಕು ಅದು adjournment ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್.
Yes, my lord,
Where?
interim order is there.
Interim orders wherever is there will continue. Yes.
Lordship, serial number 37, your lordship. 37, list 2, your lordship.
27.
37, your lordship.
Vacating stay.
No, your lordship, there's no.
Vacating stay, madam.
ಅಪ್ಡೇಟ್ ಇಲ್ಲ ಅಪ್ಡೇಟ್ ಇರ್ಲಿಲ್ಲ ಅದ್ರಲ್ಲಿ. ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿತ್ತಾನೆ.
Action.
Connecting to desktop LV514 kg. Desktop
Sorry, sir.
LV514 kg. Connected.
I'm sorry, my lords, I never realized that my lords had come, my lords. I was preparing the matter. Anyway, my lords. May I begin, my lords? I can't hear my lords.
Just one moment, Raj sir.
Yes.
Child marriage.
Yes, now I can hear my lords.
Yeah, just a moment, sir.
Yes.
Child marriage act ಇದೆ.
ಪೇರೆಂಟ್ಸ್ ಇದಾರಾ ಇಲ್ಲಿ? ಪೇರೆಂಟ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್.
ಅವ್ರ ಮದರ್ ಇದಾರಂತ.
ಅಲ್ಲ, ಅಕ್ಯೂಸ್ ಪೇರೆಂಟ್ಸ್ ಇದಾರಾ?
ಪೇರೆಂಟ್ ಆಫ್ ದಿ ಗರ್ಲ್.
ಅಕ್ಯೂಸ್ಡ್ ಇದಾರ? ಅಕ್ಯೂಸ್ಡ್ ಅವರು?
ಒಂದು ನಿಮಿಷ ಸರ್.
ಅಕ್ಯೂಸ್ಡ್ ಇಸ್ ಪ್ರೆಸೆಂಟ್.
ಸುಮ್ಮನೆ ರೀ ಒಂದು ನಿಮಿಷ. ಇಲ್ವಾ? ಆಯ್ತು, ಈಗ ಕ್ಲೋಸ್ ಇಟ್ ಆನ್ ದಟ್ ಅಷ್ಟೇ. ಎಸ್ ಜಗದೀಶ್ ಸರ್. What is the age of the girl at the time of the incident?
17 years.
17 years, 11 months.
17 years, 11 months, 7 days.
10 days.
10 days. Perfect. Good. Yes.
Registration of marriage.
Marriage register ಆಗಿಲ್ಲ. ಎಲ್ಲಿದೆ? Photo ಆಗಲ್ಲ. You should get the marriage registered and come. No photo.
In the meantime, it may be stayed, my lord.
I will stay it and give you 4 weeks time.
Please.
And don't ask the lady to come here. She's pregnant.
Please.
Let her get.
Affidavit is ready.
Adella irli. I will stay it.
Please.
I will post it on 10th July.
Please.
Adra ಅಷ್ಟರಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಕೊಂಡು you get the registration certificate.
Please.
List the matter on July the 10th. Further proceedings where the petitioner shall remain state till the next date.
Right. Yes.
The pronouncement ಮುಗಿಸ್ಕೊಂಡು ಕೊಡಿ. ನನ್ನ ಹತ್ರ ಇದೆ. Dismissed.
Number 2.
Criminal petition is allowed. The proceedings before so and so stand quashed. It is made clear, however, the observations made or made herein shall not impede or prejudice the DGCA in any manner whatsoever. The DGCA shall remain at liberty to independently examine the complaint, scrutinize the records, assess the technical material, and arrive at its own conclusion in accordance with law, uninfluenced by the observations made in the present proceedings.
Till number 3. 13%.
Criminal petition is allowed in part. The impugned proceedings in special case so and so stands insofar as the offences under the Act is concerned stand quashed. The offences under the IPC and the Dowry Prohibition Act stand sustained. The trial be conducted by the regular court in the light of the quashment of the proceedings under the Act. Criminal petition is allowed in the light of the observations made in the course of the order. The petition shall be released from the prison forthwith released within 4 days from the receipt of the copy of this order.
Fine.
Applying for the petition.
Writ petition 18828 of 2025 filed by the husband stands dismissed. Writ petition 31907 of 2025 is allowed in part. The petition insofar as accused number 1 to 4 stands dismissed, leaving open the leaving open the said accused to avail of such remedy as is available in law, and if availed of, the concerned court would not be influenced or bound by the observations made in the course of the order. The impugned proceedings qua accused number 5 and 6 stand quashed. Yes. Dowry death. Although 5 and 6 are distant relatives, not even concerned. Yes. 2:30 matter.
Hearing on IA, 2:30 PM, 115.
Yes, sir.
May I start, my lords?
Yes, sir. Yes, sir.
But this is a classic case where one FIR is filed, maybe in collusion, maybe not in collusion, where the informant says that I have been duped of 3 crores of rupees. And the police file a closure report. Much is said about the closure report, so much of hype about the closure report. I can understand if the closure report says no offense made out. In the present case, the closure report doesn't say no offense made out. Closure report says that the matter has been settled by mutual agreement. That my lords will find at page 35 of the compilation. So it is settled. So there is no finding either in the investigation or by that the predicate offense has not taken place. It is because of settlement. This is not a case where of a single individual who has been duped. This is a case of 33,000 persons who have complained that they have rigged the gaming application and there are glitches in the gaming application and large number of persons have been swindled. The amount of fraud is 1154 crores and we are counting more than 1154. At present it is 1154. It will go to a staggering.
This is not a figure that occurs anywhere in the pleadings, anywhere in the proceedings, not in the grounds of arrest, not in the reasons to believe. A figure that suddenly come out at the stage of
I am just giving the background. I am giving the background. I'm sorry. I will give the papers. I'll give, and this I am giving the background. There are some.
Copy of the idre you have to hand over. No, if the learned is yes, all right. Yes, sir.
My chain of thought has been broken, but let me just gather it again. So,
yes, sir.
So what I said is 1154 and counting. That
yes,
is one.
Sir.
There are a large number of persons whose life savings has gone, and many have said that they're going to commit suicide. Kindly have a look at page 108 of their compilation. Large number of people say we are so frustrated, our life savings have gone. We are contemplating committing suicide. And my instructions are 2 have committed suicide in Telangana and 6 in Tamil Nadu. 8 persons have committed suicide because of this scam. This is the nature of the scam, and it is sought to be closed on the basis of one FIR, which is closed not on merit that no offense has taken place, but that there is a settlement. Kindly have a look at page 35. My lord, it is Kannada, but in my compilation at page 51, it is in English. It is because of mutual settlement that there is a closure report.
Or objections? Objections? Or objections ಹಾಕಿದ್ದಾರೆ. Yes, yes, sir.
Well, that Kannada is there at page 35, but I've got an English translation which says this is part of the closure report, which says that it is due to mutual agreement. That there's an issue, my lord, I will get that judgment.
Yes.
Whether the police can compound an offense. The powers are with the court. It's a 420, no doubt it's a compoundable offense. But the police can't say that because the parties have compounded, we close the offence. That they cannot say. My lords may kindly have a look. I am only pointing
Correct.
out the flaw.
The police have closed it, or a closure report is filed on the score that there has been a settlement, which power the police obviously do not have.
Not have.
We
And then
report,
Justice
wrong,
Ahmad
we
said that
report on the basis of a settlement.
yes, it can't. Therefore, that is Justice Ahmad's judgment as the lordship was
Thing.
then in the
The
Gujarat High Court.
complainant says, I have now been explained what it is and I do not wish to pursue.
Well,
It's not a
I
settlement.
am,
Even
I will
then,
not
that
argue
cannot
with
result in a
that.
B report.
No, no, but
I,
it's
my
not a
learned friend
settlement.
must be
And they've not challenged
conscious.
it.
All right.
They've not challenged the B report.
My learned friend should not interfere. But otherwise, let him argue, Marad. If he has
No, no, sir.
yes.
It's my questions. Yes.
There is a judgment directly on this point, my lord. Randir Singh Deep Singh Parmar versus State of Gujarat. That is Special Criminal Application 918 of 2007. I'll send it to my lords. But Justice M.R. Shah then was in the Gujarat High Court. He said, "You police have no power. They settled it. The complainant and the accused cannot settle, even if it's a compounded offense between the police." That I will send it to my lords. But I'll send it to my lords as far as the
Yes,
judgment
yes,
is concerned.
yes, yes.
Now, my lords, may kindly have a look at page 108, my lords, of the petition.
Yes.
Now, 108, my lords are having. These are statements given by large number of persons. Please disable the account address to them, my lord. Please, sir, otherwise I will commit suicide. Large number of persons have said I will commit suicide, address to them and address to the NCA. Therefore, there are large number of persons, not one. 33,000 have been duped. Large number of persons say we will commit suicide. 8 have committed suicide. It is all documented. Now, what is done? One complaint, one FIR filed and settled. The person has filed the FIR for 3 crores. He settled for 30 lakhs. That, my lords, will find in my document compilation. The statement of the person, the informant who settled the matter, my lord, which is recorded under section 50, my lords. Kindly have a look at page 59 of my document compilation.
Yes.
59, na? Yes. 59, question number 14. Please provide present status of FIR number 722 of 24, which was filed by you. I state that police have filed B report in the said FIR. Further, I also state that I preferred out-of-court settlement in the FIR, not in the court. I was approached by one Gulshan Yadav, mobile number, so they told me they'd come to know about the FIR, suggested me to do out-of-court settlement as he knew I was overburdened with debts. He also told me that it will take years to get the matter resolved through court. It would be better for me to accept the offer of GTPL and settle the matter. Thereafter, I agreed to the same. I, along with Gulshan, went to the office of Gamescraft in Bangalore and met Nitesh Salvi, mobile, and other person whose name I do not. Further, another person joined the said meeting through Google Meet. I do not remember his name. After deliberation and negotiation, it was decided that they give me an amount of 30 lakhs for withdrawing my complaint given to the police. This is how the B summary has been obtained. I can understand if B summary has been obtained on merits. There is no decision of the police, no investigation on the merits that no offense is made out. My lords may just keep it on the side. This is only I'm just my background, what I'm. Now, my lords may kindly have a look. One FIR filed by one person, closed because of settlement, paltry amount of 30 lakhs paid, and a fraud of 1154 crores as on date, which may go to even 2,000, which may go even to 3,000, is hushed up. So that then they say, oh, second ECR, there can't be a complaint. TT Anthony will apply if there's a second FIR. This is not the cases where TT Anthony, each person who has been duped constitutes a separate offense. There is nothing like same part of the same transaction. Each person has been duped is a separate offense. The overall conspiracy of duping large 33,000 people is a different offense. That offense has not been quashed. There is no base summary in that offense, which my lords may just note before I make further submissions. Now, my lords may kindly have a look. The stay order which has been passed by my lords, my lord, which is at page
Yes.
42. Kindly look at that stay order. The second complaint is permissible. Nobody has challenged the second complaint, third complaint saying it is not permissible. It has to be quashed because there can't be more than one FIR. That is nobody's case. That case is not before my lords. FIRs, large number of other FIRs, which are subject matter of the second ECR, there is no quashing of those FIRs. Those FIRs are in existence. Nobody has gone to any court. They could not have gone saying that it is the same offense. TT Anthony principle applies. They have not gone. My lords may kindly note that. Now kindly have a look at the stay order. What would be the effect of the stay order? Kindly come to page 42. What is the nature of the stay order? Page 42. Page 42, my lords. Of the petition.
Yes.
Learned senior counsel for the petitioners takes this court through the documents appended to the petition to demonstrate that crime number 722 of 24 has been registered for several offences. The said crime was investigated into and B report was filed before the concerned court by the jurisdictional police. The concerned court accepts the B report and closes the proceedings or makes FIR defunct by its order dated 5/7/25. The closure of B report is said to have become final. A suppression of the fact that it is because of settlement that the FIR was closed, that there is suppression. See, Arvind Kamath, learned additional submits that the enforcement director is entitled to update the CCR for any crime that is pending preceding the subject crime. So it is brought to the notice of the court that there are other FIRs and we can update the ECIR. Obviously, preceding the ECIR, if it is subsequent also, it's preceding the date of the order also subsequent, whether we can subsume it or whether we can register an FIR, a separate ECR, I'll come to that a little later. Now, this is the submission. Therefore, the court is made aware that there is going to be more than one FIR. The court is aware at that point of time that 722 is not the only FIR. There are other FIRs which the ED proposes to subsume. That has been made apparent to the court, my lords.
But as on the date of grant of the interim order, there was no FIR except 29 of 2020, which was also registered on 23/2/25, 26.
Probably Lucknow one, I'm not sure, my lord. Lucknow one was there.
That is Lucknow FIR.
Lucknow one came later. But it was brought to the notice.
66D.
Very well, Lucknow one was not there. So let us assume that there was only one FIR, but it was brought to the notice of the court. There are other FIRs which may be subsumed.
Correct.
So court was aware that there are other FIRs. And in this background, what is the type of the order that has been passed, my lords? Kindly look at the order. In the light of the order of the concerned court dated 5/7/25 and crime center, the foundation subject ECR, which is the predicate offense, is now closed, has vanished. In that light, ECR insofar as pertains to crime 722 of 24. So my lord said, insofar it pertains to 722 of 24.
Correct. Only insofar as that.
So if it is with respect to other FIRs, if one ECR contains more than one FIR, and if there are other FIRs, there is no stay. My lords may kindly appreciate. The stay is only limited to the aspect of 722 of 24. Other FIRs, if they are there, either in that ECR or subsequently subsumed in that ECR, there is no stay. The stay is confined to only the facts of 722. It's a limited stay. It is not an omnibus stay as far as the ECIR is concerned. Further proceedings limited to the averments contained in 722. Outside 722, there is no stay. This is a limited thing. Number two, my lords. So my lords have said, interim order stay further proceedings in the subject arising out of crime number 722. So 722, to the extent of 722, it is stayed. But the fact is that the ECR has not vanished. ECR is not erased. ECR still subsists. If ECR subsists, the evidence also subsists. Evidence is even if it is washed off, the evidence subsists is going to be my submission. But in this case, I'm on a better footing because the ECR has not been quashed. ECR is live. It has been temporarily, further proceedings are stayed. But the evidence which is collected still subsists. That evidence is in existence. Now, in such a case, kindly I want to get two judgments for us. One is Chamundi Waters, and second is
That's para 10.
Yes.
Effect of an interim order.
Yes.
Yes.
Effect.
Para 10 and 15. Yes.
My lord is absolutely right.
Hmm.
Volume 3. Page
1992.
Yes. Page 88. Three-judge bench of the Supreme Court.
Yes, sir.
I'm skipping about 10, 12 lines, my lord. Page 88 of my compilation, my lords. While considering, the line starts like this, while considering the effect of an interim order, staying the operation of the order under challenge, a distinction has to be made between quashing of an order and stay of operation of an order. I'm
Yes.
sorry. I'm sorry.
Yes, sir. No problem, sir. You read. Yes.
While considering the effect of an interim order, staying the quashing of an order and stay of operation of an order, quashing of an order results in the restoration of position as it stood on the date of passing the order which has been quashed. The stay of operation of the order does not, however, lead to such a result. It only means that the order which has been stayed would not be operative from the date of passing the stay order. It does not mean that the said order has been wiped out of existence.
Correct. It only gets eclipsed and not extinguished.
So it is there. So evidence is there. Whatever is collected is there. Unlike even in a case where it is quashed, if you collected evidence, that evidence, what is quashed is the ECR, not the evidence which has been collected. I'll make my submission when I come to that, my lords. Therefore, my submission is that the ECR has not been quashed. The evidence which has been collected in that ECR has not been quashed. This is one of my submissions. There are going to be 3 or 4 dimensions to my submission. This dimension is the evidence has not been quashed. The evidence has not been touched. So evidence is in existence. There can be evidence, overlapping evidence, 1 FIR, 2 FIRs, 2 cases. There can be common evidence. I'll come to the Supreme Court judgments on that point a little later. So this is the first point. Then my lords may come to Tuteja's case, volume 2, my lords. Para 64, 109 and 114, 111. Page 424. Page 424, my lords.
Page 415.
Page 424, my lords. It starts at 396. The division bench of the Chhattisgarh High Court, later taken to the Supreme Court, right? Yes. And Supreme Court did not interfere.
This is Chhattisgarh.
Yes. But taken to the Supreme Court did not interfere.
Yes.
Para 64, the contention, my lords.
Yes.
Petitioner contended that since the prosecution complaint filed by the ED and ECIR wherein so and so is quashed by the Supreme Court. This was on facts, my case is better. This was a case where it was quashed. The complaint was quashed. ED complaint was quashed by Supreme Court in its order dated 8/4/24. All the materials relating to ECR are illegal. So all the materials are illegal. You can't look at it. That was the contention which was raised. Now kindly come to page 109, para 109, my lords, which is page 444. The Supreme Court has repeatedly held, para 109 at page 444, my lords have got it?
Yeah, I'm there. Yes.
Supreme Court has repeatedly held that the evidence collected, even assuming it to be an illegal search and seizure, would be valid and admissible. That is the position prevailing in India as well as in English law. We rely on R.M. Malkani, so and so, so and so, so and so. Reliance is placed on conclusion paras and Vijay Madan Lal, which read as under. In light of the above, we now proceed to summarize our conclusions on seminal points in issue in the following terms. In view of the special mechanism envisaged in 2002 Act, ECR cannot be equated with an FIR under the 1973 Code. ECR is an internal document of the ED, and the fact that the FIR in respect to the scheduled offence has not been recorded does not come in the way of the authorities referred to in the 48 to commence inquiry investigation for initiating civil action of provisional attachment property being proceeds of crime. So it's Vijay Madan Lal says even FIR is not required for proceeding as far as ED is concerned. Now kindly come to para 111. Hence, when the state is doing inquiry under section 50 read with paragraph so and so of Vijay Madan Lal, the state does not need an FIR or scheduled offence. The state can collect materials and can inquire into allegations. Section 50 PMLA gives ample power to call any person to give evidence of material which is in possession. Earlier, IO in ECR number so and so was in possession of relevant material. He was called under section 50 of the PMLA. He was bound to produce those materials which have been taken on record and collected while investigating the 2024 ECR. Section 50 subsection 2 of PMLA gives the power to the director, additional director, so and so to summon any person whose attendance he considers necessary, whether to give evidence or to produce any record through the course of any investigation or proceeding under the PMLA. It is not restricted to only accused. It is any person whether to give evidence or give any other information document. Great emphasis has been laid down by the petitioners on 18/7/23 order of Supreme Court, by which stay was granted. The letter of ED to Chhattisgarh was prior in time on 11/7/23. Therefore, the judgment says that even if it is recorded in another case, the IO can be called, you can take that on record. This is what precisely has been done in this case. The IO is the same, but he has taken on record the evidence collected in the other ECIR, which is permissible. Very next.
Yes.
Page 463. Kindly have a look at page 463. This matter was carried to the Supreme Court, my lords. Okay, para 6 at page 467. 6, 7, and 8. On the contention raised pertaining to other special leave petitions, we find no merit for consideration. Power under section 66(2) of the PMLA is distinct and separate. Excising said power has got nothing to do with the proceeding pending at the relevant point of time with the interim order, and so also final order passed. In fact, on paragraph 66 of the PMLA, we find that it is mandatory duty of the investigating officer to share the materials collected with the other concerned agencies. The investigation followed by registration of FIR and filing of the charge sheet travel on separate channels. To put it differently, materials may be common, but the conclusion based upon further material would be different. In such view of the matter, all contentions raised, irrespective of information given on an earlier subsequent, would be irrelevant. So common material. Supreme Court recognizes that in two ECRs there can be common material, but conclusions may be different. That doesn't mean that that earlier material cannot be taken into consideration. There is an overlap which is recognized by the Supreme Court. Then para 8. Similarly, contention raised on the two FIRs do not hold water as they have been initiated based on collection of further materials found within the respective states. As rightly submitted by the learned senior counsel of the respondent state, materials found and collected are different and also the witnesses. These offences are state specific. In such view of the matter, we find no reason to accept the contention raised on behalf of petitioners pertaining to two FIRs as well. That's it. Now kindly have a look at Puran Mal, it says evidence which is illegally collected. This is not a case where evidence is illegally collected, my lords, may kindly have a look. This is a case where evidence has been legally collected in the first ECIR. At the time when it was collected, the predicate offense was there. Even if it is supposing evidence is collected in a illegal manner, but if there is evidence which is relevant for the case, it can be looked at. But that is the law as far as Puranmal is concerned and Malkan is concerned. But that, my lords, will find. Page 363. Page 363. Para 24, my lords.
ಯಾವ page, Madhu?
Volume 2. Volume 2, my lords. 24. 23 is a longish paragraph. Para 23 is a longish paragraph. I can read that also, but I don't want to take too much of time. Now, I'll read para 23, my lord. It's also important. As to the argument based on the spirit of our constitution.
Yes.
My lord, if my lord's pausing here for a moment, my lord, if my lord recollect, the argument made by the other side was the letter is met with and spirit is not met with. If the letter is met with, what survives? The petition has to be thrown out on this argument itself. Supreme Court, they have accepted the fact that in letter it is correct, but in spirit it is not there. Nobody looks into spirit, but one has to look at the letter. Therefore, the submission which is made that in letter it is correct, that the end of the matter, my lord, that has to, my lord, that has to be accepted because the submission made with all responsibility. If that is accepted, nothing survives. The petition has to be thrown out, lock, stock, and barrel. That is, now kindly have a look at this para 23, my lords. As to the argument based on the spirit of our constitution, similar the spirit of, we can do no better than quote from the judgment of the Chief Justice Kania in A.K. Gopalan versus Madras. There is considerable authority for the statement that the courts are not at liberty to declare acts void because in their opinion it is opposed to the spirit. Opposed to the spirit. That is the argument on which the entire foundation of the case of the other side is based. I may repeat, there is considerable authority for the statement that courts are not at liberty to declare an act void because in their opinion it is opposed to the spirit supposed to pervade the constitution but not expressed in words. Where fundamental law is not limited either in terms or by necessary implication, the general powers conferred upon legislators, we cannot declare a limitation under the notion of having discovered something in the spirit of the constitution which is not even mentioned in the instrument. It is difficult upon any general principle to limit omnipotence of the sovereign legislative power by judicial interposition, except so far as the express words of a written constitution give the authority. If the written words are there, that's the end of the matter. There is no spirit to be looked at. Now, Evidence Act 1872, which is the law consolidating, defining, and amending the law of evidence, no provision of which is challenged as violating the constitution, permits relevancy as the only test of admissibility. Relevancy. Not it is illegally obtained in an earlier, he said that's not the test of admissibility, the test is of relevance, not of how it is obtained. Whether it's obtained the first ECR, second ECR, there was a stay operating, that is not relevant. Only you have to see whether it is relevant to the facts of the case or to the matter in issue. Now, in the Evidence Act, which is the law concerned defining and amending the law of evidence, no provision which is challenged wherein permits relevancy as the only test of admissibility of evidence. And secondly, that act or any other similar law enforced does not exclude relevant evidence on the ground that it was obtained under an illegal search or seizure or is obtained, even in a case where it is obtained after a stay. In this case, it is not their case, it is obtained after the stay. That is not even their case. It will be wrong to invoke the supposed spirit of our constitution for excluding such evidence. Same argument repelled, same argument spirit. Letter you are entitled to. Spirit, same argument, Supreme Court says. Nor is it open for us to strain the language of the Constitution because some American judges of the American Supreme Court have spelled out certain constitutional protections from the provisions of the American Constitution. In MP Sharma versus Satish Chandra already referred to, a search and seizure made under Criminal Procedure Code was challenged as illegal on the ground of violation of fundamental rights under sub-article 3 of Article 20. The argument being that the evidence was no better than illegally compelled evidence. In support of that contention, reference was made to the 4th and 5th Amendment of the American Constitution and also to some American cases which seem to hold that the obtaining of incriminating evidence by illegal seizure and search tantamount to violation of the 5th Amendment. The 4th Amendment does not place any embargo on reasonable searches and seizures. It provides the right of the people to be secure in their persons, papers, and effects against unreasonable searches and seizures shall not be violated. Thus, the privacy of citizens' home was specifically safeguarded in the Constitution. Although reasonable searches and seizures were not a taboo. Repelling the submission, this court observed at page 1096, a power of search and seizure is in any system of jurisprudence an overriding power of the state for the protection of social security, and that power is necessarily regulated by law. Where the Constitution makers have thought it fit not to subject such regulation to constitutional limitations by recognition of fundamental right to privacy analogous to the American 4th Amendment, we have no justification to import it into a totally different fundamental right, some process of strained construction, nor is it legitimate to assume that constitutional protection of Article 20 sub Article 3 would be defeated by the statutory process provisions of searches. It is therefore follows that neither by invoking the spirit of our Constitution nor by strained construction of any fundamental right can we spell out the exclusion of evidence obtained on an illegal search. That was a case where they said the search is illegal, therefore you can't look at the evidence. Supreme Court says no, you can't do that. Here there is no illegality as far as the collection of the evidence is concerned. There is no illegality. I stand on a much better footing. He said because there was stay, that stay also I pointed out doesn't have any effect. You can't look at it, which is a better case on merit. But now kindly have a look at para 24 on which I'm relying. So far as India is concerned, its law of evidence is modeled on the rules of evidence which prevailed in English law. And the courts in India and in England have consistently refused to exclude relevant evidence merely on the ground it is obtained by illegal search or seizure.
That's the most important paragraph.
Yes, but you can't exclude what is collected in the first ECIR merely because there was a so-called stay operating, merely because the predicate offense was gone. No, sir, that's not the law. The law is, if it is relevant under the provisions of the Evidence Act, it can be looked into. Maybe you can be prosecuted if you have stolen the property and brought it as evidence, stolen a document, maybe you can be prosecuted for 379 or 380 minutes. That's a different thing. But that evidence can be looked into. Therefore, looking at that evidence at the stage of arrest is not barred. It is permissible. It is legally permissible. Because it is not illegally obtained. Even if it was illegally obtained, there is no bar. I am on a better footing. It is not illegally obtained. It is legally obtained in the first year before there was any stay granted by this honorable court. That stay is limited only to 722. In Barendra Kumar goes for Empress, learned Chief Justice Sir Lawrence Jenkins says at page 50, Mr. Das has attacked the searches and has urged that even if there was jurisdiction to direct the issue of search warrant as a whole, still the provisions of the Criminal Procedure Code have been completely disregarded. On the assumption, he contended that evidence discovered by searches is not admissible. But to this view, I cannot essay it. But without any way countenancing disregard the provisions prescribed by the court, I hold that what would otherwise be relevant does not become irrelevant because it was discarded in the course of a search in which those provisions were disregarded. This clinches the issue, though it is in context of search. So if it is relevant, it has to be looked into whether it is obtained illegally in an illegal search, which is not the case in my case, whether it was produced because there was a stay, that doesn't make any difference. The evidence is there. I read the first judgment, Chamundi, stay doesn't wipe out the evidence for us. Then my lords may kindly have a look. You want to show Puran? This is Puran. This is Puran, sir. As Chumtavana with his shrewd common sense observes, a fact cannot be altered by 100 texts. And as is commented to quality, if a Brahmana be slain, the precepts slay not a Brahmana does not annul the murder. But the absence of precautions designed by the legislature then supports the argument that the alleged discovery should be carefully scrutinized. Then you have to carefully scrutinize. The caution should, that's a different thing. Even if a document is seized in an illegal search, you have to be circumspect as far as examining it, the evidence is concerned. That is a matter of trial. Therefore, you can look into material which was obtained legally during the existence of the ECIR and it is not illegally obtained. The evidence is not wiped off because of the stay which is limited. It is not wiped off because the predicate offence was quashed. Predicate offence has not been quashed because of a finding that no predicate offence is made out. In the absence of a finding that the predicate offence is not made out, the predicate offence still subsists. This is my first submission, my lords. Now, my lords may come to the second submission, my lords. My learned friend, Mr. Chaudhary, had made out a point, my lords, regarding rules 3 and 4 of the prevention of the forms and manner of forwarding copy along with the materials to the adjudicating
Authorized
authority.
officer.
Period of retention rules 2005. Lords. That was probably the last submissions made
That was
by.
the last limb, yes.
Yes. Now, first, I am proposing to deal with this submission in 3 or 4 points. Number 1, there is no pleading. In the absence of pleading, this is a mixed question of fact. Whether it was sent, not sent, is a mixed. We can't raise it without pleading. There is not a whisper in the petition. Now, if there is no whisper in the petition, my lords, it can't be looked into. 2 judgments on this point, my lords. This is a writ petition. There has to be pleadings. My team has checked up. There is no pleadings on this point, my lords. Which is that first judgment? Huh? Raj versus Daud, my lords. No, I'm sorry, my lords. I'm sorry, not Raj. Volume 3, page 24, my lords. That is 2024. Allahabad University versus Gitanjali Tiwari, my lords. Para 46 at my compilation, volume 3. Para 46, my lords. Para 46, 50 onwards. Subject to correction, no, I did not find any pleading. If there is pleading, my learned friend may point out there is a pleading to that effect. This is my lord 2020, recent judgment of Supreme Court, 2024. Para 46. The necessity for appropriate pleadings in a writ petition cannot be overemphasized, particularly when such petitions are mainly decided on affidavit in evidence and not witness action. This is para 46. Then my lords may kindly turn to para 50, lords. Where the lordships refer to Rani Lakshmibai's case. In Rani Lakshmibai Kshetriya Gramin Bank versus so and so, this court noted the settled legal position and interfered with the impugned decision by ruling as follows. It is too well settled that petitioner who approaches the court invoking extraordinary jurisdiction of the court under Article 226 must fully ever and establish his rights flowing from the bundle of facts, thereby requiring the respondent to indicate its stand either by denial or by positive assertions. But in the absence of any evidence in the writ petition or even the rejoinder affidavit, it is not permissible for the court to arrive at a conclusion on factual position merely on the basis of submissions made at the course of hearing. The High Court, therefore, in our view, committed serious error in coming to the conclusion that existed vacancies in the post of field supervisor on material produced before it. In fact, the respondents herein who had the petition, the High Court had not produced any material in support of the stand that vacancies existed. Yet upon the view of the considered opinion that the conclusions of the High Court that there existed vacancies unsustainable law accordingly set aside. Now kindly come to para 52, my lords, which is very important. Based on the aforesaid authorities, we hold that while deciding a writ petition based on basis of affidavits, the writ court's inquiry ought to be restricted to the claims pleaded by the parties and the evidence that they have placed on the record as part of the writ petition or the counter reply affidavit, as the case may be. Findings of the court have to be based on the pleadings and evidence produced before it by parties. It is well nigh impermissible for the writ court to conjecture and surmises and make out a third case not pleaded by the parties based on arguments advanced in the course of hearing. So in the absence of pleadings, it is not permissible to raise this point. One, my lords. The second is that the plea is not raised. What is the purpose, my lord? The purpose is to see that there is no interpolation. The purpose is to see that immediately after the search, the materials are sent to the adjudicating authority, so that you do not have, you do not and cannot tamper. That is the purpose. There is a similar provision in section 157 of the CRPC. There, my lords may see the purpose is set out, my lord. That is probably Raj versus, which is that? State of Rajasthan versus Daud Khan. State of Rajasthan versus Daud Khan. That is prejudice. But 2016 2 SCC 607 page. May I read section 150? 157 is very, my lords are aware, I presume that I'll read 50 because there also the FIR is required to be sent immediately, my lord, forthwith. That's the word used in file 57. It's similar to this provision. To save the time, I'm not referring to it. Now, my lords may kindly have a look at Daud Khan, my lord. Page 154. Page 150, volume 3, page 154.
Yes.
There are 26 and 28. Just give me a minute. Have you got it? Yes. Page? Page 154. There are 26. The interpretation of section 157 CRPC is no longer res integra. A detailed discussion on the subject is to be found in Ram Swarup versus State of UP, which considers a large number of cases on the purpose of the forthwith communication of a copy of the FIR to the magistrate is to check the possibility of its manipulation. Therefore, a delay in transmitting the special report to the magistrate is linked to the lodging of the FIR. If there is no delay in the lodging of an FIR, then any delay in communication, the special report to the magistrate would really be of little consequence, since the manipulation of the FIR would then be get ruled out. Now, the prosecution would explain the delay in transmitting the special report to the magistrate. Therefore, the purpose. In my case, there is no delay, only the procedure is not followed, but there are no averments, my lord. It is sent on the same day. It is sent electronically on the same day, I must say. That sealed cover, it was communicated electronically. But the purpose is to say that manipulation is not there, my lords. That purpose is not flouted in my case because that is the purpose. My lords will keep this purpose because if in the search you do something and then tamper with the evidence, to prevent tampering, this procedure has been evolved. Then my lords may kindly have a look, my lords, para 28. It is no doubt true that one of the external checks against antedating or anti-timing of an FIR is the time of its dispatch to the magistrate or received by the magistrate. The dispatch of a copy of the FIR forthwith ensures that there is no manipulation or interpretation in the FIR. If the prosecution is asked to give an explanation for the delay in dispatch of a copy of the FIR, it ought to do so. However, if the court is convinced of the prosecution words and truthfully and trustworthiness of the witnesses, the absence of any explanation may not be regarded as detrimental to the prosecution case. It will depend on the facts and circumstances of the case. So even if that's a procedural thing, even if it is not sent in the sealed cover but sent by email or something, it does not vitiate the prosecution case. It does not vitiate the arrest. The purpose is not that the arrest gets vitiated. The purpose is to say prevent manipulation, to prevent interpolation. So that whether there's delay, whether the interpolation is there, is all a matter of trial. It can't be raised at this point, my lord. That is another aspect of this submission. Now, my lords, may kindly have a look further, my lords. Even if there is violation under section 157, even if it is not sent, the courts have refused to take notice of it unless prejudice is pleaded and proved. You must plead and prove prejudice. You can't take it as a submission in the abstract. You must prove and establish prejudice and also plead prejudice. 2 or 3 judgments on this point, my lords. So mere non-sending, mere not forwarding doesn't vitiate it unless you prove prejudice. Here we have sent it in time. On the same day we have sent it. Within 2 hours we have sent it. Maybe we have not sent it in the sealed cover. I will have to, unless because I have sent it, that statement may be there. But how we have sent it, only we can reply if there is a pleading to that effect. My lord, the adjudicating authority regulates the procedure. Under powers conferred under section 6 and subsection 15 of the PMLA. Kindly have a look at 6:15, my lords. Section 6:15, my lord, the adjudicating authority has power to regulate his own procedure. And that procedure, it says, now kindly look at this notification of amendment of in adjudicated procedure regulation 2013, 30th of September 2025. In exercise of powers conferred under section 6:15 of the Prevention of Money Laundering Act 2002, wherein this adjudicating authority shall have powers to regulate its own procedures, and whereas e-filing under e-court procedure has been implemented as per direction of the Supreme Court, thereafter the adjudicating authority regulations is modified as under regulation 3, filing of applications and complaint regulation so and so summons, regulation 50, filing of reply, wherever physical filing or receipt of papers have been mentioned in the said regulation is hereby modified as under the application, complaint, provisional attachment order, search and seizure report, arrest order, or any other application document shall be filed on the e-filing portal, e-filing court, so and so, and after scrutiny, a computer registration number will be generated and intimated. In addition, a editable PDF copy and the Word file of the application, complaint, provisional attachment order, search, seizure report, or any other document file be submitted on the email of the registrar of the adjudicating authority. All documents must be signed either digitally or physically with a dated stamp. Similarly, all replies, etc. Replies are skipped, my lord. Therefore, there is now a statutory regulation which permits us to send the copies by email. Electronically updated on the e-portal. That is sufficient compliance. Now, my lords, may kindly have a look at those judgments where they say that prejudice has to be there, otherwise this ground is of no relevance. Page 125 of volume 3, my lords. Judgment is possible. The judgment starts, my lords, at page 101.
Darshan's case.
Yes, I'm sorry. Darshan's case, 2025 SC, online SC 1702 at page 125. There are 20.1.7. In the present case, the arrest memos and remand records clearly reflect that the respondents were aware of the reasons of their arrest. They were legally represented from the outset and applied for bail shortly after arrest, evidencing an immediate and informed understanding of accusation. No material has been placed on record to establish that any prejudice was caused due to alleged procedural lapse. In the absence of demonstrable prejudice, such an irregularity at best a curable defect and cannot by itself warrant release on bail. So this is a procedural lapse at the most, but there is no procedural lapse because of the subsequent amendment in the regulations which say you can file it on the e-portal. No prejudice is caused, no prejudice is demonstrated, no prejudice is pleaded. Substantial compliance is there. Therefore, this ground does now kindly have a look at Radhika's judgment, my lords are aware, and 2 or 3 Fatigo and Kuppuswamy Gowda. 3 judgments I'll cite on this page. 74 of this very compilation, Fatigo, my lord. Page 74. You must plead and prove prejudice. Has any prejudice been caused? Has the record been manipulated? Has there been interpolation? Nothing. It is an argument in air. Page. There are 27, my lords. That was the case of CBI consent. My lords must be aware, my lord. CBI
Yes.
section 6 consent. So the Supreme Court said you
Delhi
must
police
plead
established.
in the present case, there are no pleadings by the public servant with regard to prejudice caused to them on account of non-obtaining prior consent in section 6 of the Delhi Special Police Establishment Act, was then specifically in addition to the general consent enforced nor with regard to miscarriage of justice. Nothing. Then page 99, Kuppuswamy, similar lines. It is not disputed that the play of prejudice or failure of justice is neither pleaded nor proved, Not only that, even the judgment of the High Court does not indicate any possibility of prejudice or failure of justice. Learned counsel appearing for the respondent also did not suggest any possibility of prejudice or failure of justice. Under those circumstances, therefore, the view taken by the High Court does not appear to be correct in view of the language of so and so. So that is based on 462 and 465. There is no prejudice caused, therefore, you have to plead how the order of granting remand is bad, my lord. This would have a direct effect on the order of remand. The order gets vacated if you prove prejudice. You plead prejudice. Radhika, my lords are aware, my lord, may I? Because it's para 12, my lords. It is objections filed by the respondent to the maintainability of the interim relief. That's my document, my lord. Where I've quoted Radhika para 12 in my objections. Page 6 of my objections.
Yes.
I've extracted para 12 of Radhika there. It is pertinent to note. My lords have got it. It is pertinent
Yes,
to
I am
note.
there.
Radhika is 3 judges of the Supreme Court, my lord. Huh?
Yes, sir.
Concurrent view. It is pertinent to note the special acts are established, enacted to achieve specific purposes and objectives. The power of judicial review in case of arrests under such special acts should be exercised power of judicial review in case of arrest under special act should be exercised very cautiously and in rare circumstances to balance individual liberty with the interest of justice and society at large. Society at large, 33,000 people have been duped and 1154 crores scam and technical ground that there
I
is a
find
settlement.
objections ಅಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ
Objection.
ಅಲ್ಲ that 33,000 people are duped.
That is very recent.
No, because absence of pleadings is what is said.
Absence of I'll tell my lords, but this probably will find from my case diary. Huh? Case diary. Because this is arrest, case diary can be looked at.
Yes.
If pleading would be for the petitioners, not for the
Yes, sir.
respondents.
Not for the respondents. Yes, sir.
Reason to, I'll take my lords to the reason to believe and the grounds of arrest. I'll take my lords there.
Yes, yes. No problem. In the lighter ways. That's all. Yes.
I thought I was stumped for a moment. I must say. It is pertinent to note that special acts are enacted to achieve. My lords have got it?
Yes, yes, sir. I'm having it.
It is pertinent to note that special acts are enacted to achieve specific purposes and objectives. The power of judicial review in case of arrest under such special act should be exercised very cautiously and rare to balance individual liberty with the interest of justice and of society at large. Any liberal approach in construing the stringent provisions special act may frustrate the very purpose and objective of the act. It hardly needs to be stated that the offences of PMLA, Customs Act, FERA are the offences of very serious nature affecting financial systems and in turn the sovereignty and integrity of the nation. The provisions contained in the said act therefore must be construed in a manner which would enhance the objectives of the act and not frustrate the same. Frequent or casual interference of the courts in the functioning of the authorized officers who have been specially conferred with the powers to combat serious crimes may embolden the unscrupulous elements to commit such crimes and may not do justice to the victims, who in such cases would be the society at large and the nation itself. With the advancement of technology, the very nature of crimes has become more and more intricate and complicated. Hence, minor procedural lapses on the part of the authorized officers may not be seen with magnifying glass by the courts in exercise of powers of judicial review, which may ultimately end up granting undue advantage or benefit to the person accused of a very serious offense under the Special Act. Such offences are against society and against the nation at large, and it cannot be compared with the ordinary offences committed against an individual, nor the accused in such cases be compared with the accused of ordinary crimes. Though the power of judiciary keeps a check and balance in the function of public exercise for better, more efficient exercise of the powers, such power has to exercise very cautiously, keeping in mind that such exercise of power of judicial review may not lead to judicial overreach, undermining the powers of the statutory authority. To sum up, the powers of judicial review may not be exercised unless there is manifest arbitrariness or gross violation or non-compliance of the statutory safeguards provided in special acts required to be followed by the authorized officers when the arrest is made of a person prima facie guilty of having committed offence under the special act. So manner at looking at the material, therefore manner of sending of the material is hyper-technical, that is, but even otherwise, as whether you could not have looked into the evidence collected in the first ECR, especially when you have taken it on record in the second ECR. But it is not, my contention is, it is not the only material. There are other materials also. It is not restricted to the first materials collected in the ECR and taken on record of this ECIR. Once it is taken on record of this ECR, it becomes the material under this ECR. Whether it was collected in the first ECR pales into insignificance. Now, my lords, may kindly have a look. And Kejriwal also reiterates this for us. Kindly have my objection statement, my lord, at page my written objections, page 8, para 10, where I've extracted from Arvind Kejriwal. I said that merit-based review is not permissible. Petitioner is seeking a merit-based review of grounds of arrest and reason to believe, which has been denied by the Supreme Court with the following observations. Para 39 of Kejriwal. We now turn to scope and ambit of judicial review to be exercised by the court. Judicial review does not amount to a mini trial or merit review. The exercise is confined to ascertain whether the reasons to believe are based upon material which establish that the arrest is guilty of an offence in the PMA. That's the limited scope. How the material was collected, where it was collected, whether it was lifted from that ECR, brought into this ECR is not the scope of this of the judicial review. The exercise is to ensure that the Department of Enforcement acted in accordance with the law. The court scrutinizes the validity of the arrest in exercise of power of judicial review. If adequate and due care is taken by the Enforcement Directorate to ensure that the reason to justify the arrest in terms of 19(1) of the PMLA Act, the exercise of power of judicial would not be a cause of concern. Doubts will only arise when the reasons recorded by the authority are not clear or lucid. I show that they are clear and lucid in this case, and therefore a deeper and in-depth scrutiny is required. So only where it is hazy in-depth, otherwise the in-depth is not even required. Arrest, therefore, arrest after all cannot be made arbitrary on the basis of whims and fancies. It has to be made on the basis of valid reasons to believe, meeting the parameters prescribed by law. In fact, not to undertake judicial scrutiny when justified and necessary would be an application and failure of constitutional statutory duty placed on the court to ensure that the fundamental right of life and liberty is not violated. In our opinion, the key distinction between 19(1) and 45 is the authority undertaking the exercise. In each case, under 19(1), it is the designated officer who records in writing the reason to believe that the arrest is guilty of an offence in the PMLA. Thus, the arrest is based on the opinion of such officer, which opinion is open to judicial review. However, not merit review in terms of the well-settled principles of law. Contrastingly, under Section 45, it's the special court which undertakes the exercise. The special court independently examines pleas and contention both the accused and the Department of Enforcement and arrives at an objective opinion. The special court is not bound by the opinion of the designated authorized officer recorded in the reasons to believe. A court's opinion is different and cannot be equated with an officer's opinion. While the special court's opinion is determinative and only subject to appeal before the higher court, Department of Enforcement opinion is not the same is not in the same category and as it is open to judicial review. At this juncture, we'd like to reiterate and clarify that we are not deciding an appeal against the order rejecting the prior application grant of bail under 45. We are examining the question of legality of arrest of Arvind Kejriwal. While doing so, we would be exercising power of judicial review and not merit-based review, my lords. Then, my lords, 46. Arguments raised on behalf of Arvind Kejriwal will tend to dent the statements materials relied upon by the Enforcement Directorate in the reason to believe, though worthy of consideration, are in the nature of propositions or deductions. There are matter of discussions as they intend to support or establish a point of view on the basis of interference drawn from the material. It is contended the statements relied upon by the ED have been extracted under coercion, a fact that is contended and has to be examined and decided. The argument does not persuade us, given the limited power of judicial review, to set aside and cause the reason to believe accepting the argument would be equivalent to undertaking a merits review. Same thing here, my lord. When they say you can't look at the other material, you are doing what is an examination on merits, which is not permissible. Now, therefore, they have sought bail on the same ground. My lords may kindly have a look at their bail application, which is kindly have a look at para 66, my lords. Arvind Kejriwal can raise these arguments at the time when his application for bail is taken up for hearing. In bail here, in page 9, bottom of my objections.
Page?
Page 9 of my objections, bottom. Para 66 of Arvind Kejriwal.
Huh.
Arvind Kejriwal can raise these arguments at the time when his application for bail is taken up for. In bail hearing, the court
bail hearings.
The court jurisdiction is wider, though the fetters in terms of section 45 have to be met. Special court would have to independently apply its mind without being influenced by the opinions recorded in the reason to believe. To adjudicate bail application, please and arguments of Arvind Kejriwal and ED, including materials that can be relied on and inferences possible, shall be examined. So whether this can be relied on, taken in the earlier arrest, can be examined there, not here. And he has therefore is rightly raised in the bail application. Kindly now have a look at his bail application. He has raised this. He can't ride two horses at the same time. He has raised it because Supreme Court says that is the place where you can raise, not here. His bail application, my lords. Page 20 of his bail application. Same grounds raised.
Where's the application? Have it? Bail application. Lord, he must be having it. Little bit.
Error 36 onwards. Page 20 of his bail application.
We'll take it as same grounds.
Same grounds raised. And why it was raised? Because it can't be looked
Very
at
limited.
with
Very limited. He keeps replying to an argument which was never made. This is the problem, Alex. We are not arguing a bail. We are not arguing a quash. We are arguing a very limited issue of legality of arrest.
The arrest.
Nothing more. We are conscious, my lords, that we should not be exceeding the scope of the petition. In fact, we do not want your lordships to say anything on those things. We don't want to get prejudiced. In case of the bail court.
My submission probably not gone down, my lord, as far as my learned friend is concerned. My submission is this: even though you challenge the bail, you can't raise it in a bail petition. Definitely, I can raise. Whether he raises it, whether it's argued or not, I have to say that this can't be raised in this petition. If I can't argue that, what can I argue? If I can't argue that, he can't raise it here, because he has not raised that. What will he raise, my lord? With great respect to my learned friend, my lord, if he has not argued, am I debarred from arguing that this can't be raised in an arrest petition? I have to deal with only what he says. I can always argue about maintainability. I can argue so many things. It goes to the root of the matter. It goes to the maintainability of the matter and maintainability of his submissions.
Maintainability of
His submissions.
submission.
His submission. The submission that look at this, that can't be looked at in an arrest petition. It has to go before the bail petition because that submission is regarding the admissibility. Whether that is admissible or not is a merit-based assessment which can be done only in a bail application, not here. That's what the Supreme Court says. Whether a particular evidence is admissible or not is a merit-based assessment which can be done, cannot be done in a judicial review of an arrest order. And if my learned friend says it is irrelevant, it is so be it. Now kindly have a look at the reason to believe. It starts at page 104. It starts at page 102, my lords, actually, of his petition.
Reasons to believe.
Just give me a minute, my lords. That the following FIRs have been registered against online rummy apps, websites controlled and developed by Gamescraft Technologies Private Limited. A large number of families, right from the days of Mahabharata, have been ruined because of gambling, my lords. Have been ruined because of gambling. And therefore, the government has now put a ban on these gambling. Not only have they been ruined, but a valuable foreign exchange goes to China. And I'm not saying about this case, but large number of cases, huge amount of foreign exchange has gone to China. In one case where I was there, what happened with people used to bet 100 rupees, 200 rupees, 400 rupees. But collected cumulatively, it went to hundreds of crores. And the person managing it was a lawyer, my lords, and he said privilege under 132. There was no professional involvement. But I'm not arguing that case, but there are cases and cases. But one must also look into the vice of gambling, my lords. The gist of the FIRs are submitted below. FIR number 97 of 26. As for FIR number 97 of 26, registered with Cybercrime Police Station Hyderabad, the complainant alleged that he received phone calls and SMS messaging from affiliates on online rummy platform, Rummy Culture and Rummy Circle. They promoted their website, www.rummyculture.com, rummycircle.com, as government licensed skill-based gaming platform. The promised substantial profit influenced by these assurances, the complainant began paying recording money on the platform but claimed that consistent incurred losses. It further alleged that games appeared one-sided and he ultimately lost 53,000 across multiple times. Later on, contacting customer care to seek clarification, request or refund, he was informed that going to skill-based and operated using a random number generation. I'm sorry about there's heavy rain, therefore there is a disturbance.
Oh.
Later on, contacting customer care seeking clarification, request, he was informed that the games were skill-based and operated using random number generation. According to complaint, referee failed to address the concern, avoiding satisfaction. He claimed to for the screens recording of gameplay, which he believes demonstrate manipulation and unfair practices. The complaint has further raised concern about transparency of the platform, alleging certain players appear to be consistently active at all hours, including later, raising suspicion about their authenticity. He also questioned the integrity of gameplay mechanics, including alleged application of cards, recurring score patterns, favoring certain players, and consistent losses in higher stakes pool games 500 to 10,000 compared to relatively balanced outcomes in low stake fund base. Then FIR 10 of 26, registered at so-and-so Telangana, it alleged that 5 complainants named therein were cheated by unknown persons associated with platform Rummy Culture and Rummy Time. The complaint stated that they were introduced to said gaming application through Facebook and YouTube, wherein fraudulent representation, misleading advertisement, alleged application related manipulations were used to induce them to install the apps. Further, the accused persons represented games as skill-based online games legally operated under valid license from the Government of India. Believing the such representation, the victim deposits money through UPI payment, resulting in alleged wrongful loss of amounting to 1.85 crores. The third FIR. Second FIR, there were 5 complainants, my lords and lords. As per FIR number 330 of 26, Telangana, comes that he came across online rummy advertisement, YouTube to sons and installed rummy culture application operated by Gamescraft Technology India Private Limited. Initially incurring losses, he reinstated the application, began depositing money, allegedly suffering loss of 40 lakhs over time. Complainant alleged several irregularities during gameplay, including suspected collusion among players, acceptance of deposits beyond stated daily limits, forced logout and connectivity error messages resulting in loss of deposit amount. Alleged participant person stated to be company directed despite terms prohibiting such participation. Then, my lord, para 4. Apart from FIR, there is a huge number of complaints were reported by the National Crime Reports Bureau, and many of these complaints are under investigation. An examination of these complaints is seen that certain victims of the accused company were expressing suicidal thoughts due to financial losses incurred by them on the accused company's online rummy platform. Also, allegations of fraud, cheating, and usage of BOTs in the online rummy platform. The accused company, for ready reference, the few complaints are reproduced. The first complaint, my lords, we find there was 4th September. Requested on the last column, requested both the apps Vision 11 and Rummy Culture Fantasy apps to delete my account and ban bank personal information. But they are saying it was not possible. Even asking for many years, no action was taken to remove my data. Now I am leaving of my number due to some unlucky reasons of my mobile number it may assign. Kindly help me to delete my data from the apps and delete my account permanently. They may use my PAN for fraud transactions. Please kindly help me. Then, large number of complaints are received. Number of persons have said they would commit suicide. Kindly come to page 106 bottom. I've been cheated by Rummy Culture, which is online app for playing Rummy, wherein I lost almost 2,50,000, and they have accepted that cheating happens, and sometimes not every time, for which I ask for refund because cheating happens every time. I have proof of it, so kindly help me get back my money back as soon as possible. I'm so depressed. I feel like committing suicide. I'm helpless. I can't even work properly or think of anything else. The next one, I'm playing game of Rummy Culture. First, I lost 42,000 rupees. After that, when I am winning 32,451 rupees and going for withdraw, that time soon your account was suspended due to violation. They are not replying to which, I'm done and I'm not able to withdraw my funds. I'm stuck in. So when you lose, your money goes, but when you win, you're not allowed to withdraw. Because then, after the end of the table, from the above table, it also says that complaints are from the state of Andhra Pradesh. The online real money games are banned. Yet the company was conducting business activities disregarding the business. Because of this disturbance, may I continue tomorrow, my lord?
Tomorrow?
Because of
Everything.
Because of this
disturbance. Force measure. Arrest. Yes, I know. I understand. When is the matter listed before the bail court?
Monday.
No, if the bail is to be granted on the score. Interim bail.
My request is, please, we will rejoin.
pray my lords that your lordship's threshold, knowing that board is heavy. I pray that your lordship passes an order in immediately thereafter. To conclude tomorrow, my lord. Then Monday, my lords, if I can request your lordship to consider.
Oh, so many submissions are made, yeah.
1 month, my lords, I'm there for that. Kindly see, for whatever worth it is, my lords, for 1 month. May I at least request a definite timeline, my lords, because we were expecting that today he will conclude.
No, rains.
Well, it's in case Mr. Raju is able to tell us when he's likely to conclude, Malats.
Sir, how long, how much more time you require, sir?
As per one senior lawyer of this court, half an hour. He argued in the other matter when he said half an hour, it took 1 day.
Which other matter?
I'm finished. I'm on the verge of finishing. Half an hour, I'll finish.
Malats, then today he can finish, Malats. Your lordships.
It rains every day
If it's only half an hour, he can finish it today.
No, then sir, can it be done this way? I'll run through the list and get back at 5 or 5:15. Depends on the mosque.
I'll do one thing. I'll shift to another room. I'll shift to another where the roof is better. I'll give me 2 or 3 minutes. I'll come go to another room and come back.
I'll take it at 5:15. Not a problem.
No, in 10 minutes I'll be ready. 5 minutes.
In 10 minutes, he says he'll be back.
No, it's better because advocates are waiting. I'll just run through the list.
Very well.
And at 5 o'clock sharp, I'll take it.
Very well.
Very well.
Please, Your Lordship. Please.
Obliged.
Please. Your
List number to continue, 33.
My lord, I'm relying upon two main grounds, my lord. In this, my lord, first attachment warrant they brings, my lord. I never object for attachment warrant because before also they brought one attachment.
Where is Deepak?
This I place the records, my lord. That Chaku idkandu.
Oh, this one. Yes, sir.
They bring attachment warrant. Before also they brought attachment warrant. I cooperated. No, my lord, when they brought one more attachment warrant, I showed hand summons.
You showed
Hand summons. Hand summons is there. I want to serve hand summons to complainant. That's what I told. So they told.
That's not what the CCTV is saying.
Lord, CCTV footage I only provided to police station, my lord.
It is their own house. We have collected from their house. It is all part of this.
This is your CCTV footage.
Yes.
This
We
is
only
you.
we only gave that.
No, that's CCTV footage. This is you.
Yes, my lord.
Very good. Yes.
My lord, in the.
Charge sheet agila?
Stay there, of course.
You come after charge sheet. This can't be countenanced. You can't behave however you want.
It is a counter complaint given against.
Whatever it is. This can't be the thing.
Moreover, the ingredients of section 118 also doesn't attract here.
That we'll see. Charge may be something else. You come after charge sheet. Investigation Muksi, I will permit him to approach the court after charge in case charge sheet is filed. The petitioner is before the court seeking the following prayer. Owing to the submissions made by the learned counsel for the petitioner, an interim order stay was granted of investigation. The learned additional SPP places on record papers of investigation conducted till the date on which the interim order was granted. A perusal at the papers would indicate that the investigation must be taken to its logical conclusion by filing a final report either for the petitioner, in favor of the petitioner, or against the petitioner. Therefore, reserving liberty to the petitioner to knock at the doors of this court all over again In the event the final report is filed and the final report would go against the petitioner, the petition stands disposed. All contentions that are urged now shall remain open to be urged in the petition, if any, to be filed in future.
34.
File this IA for direction.
In 7A na?
7A,
Ah.
what has happened is, apart from no demand and other things, there is he is a police inspector.
Yaru?
The petitioner.
Petitioner.
And A1 appears to have demanded he comes to my chamber. There is a CCTV which is installed in the chamber pursuant to the orders of the Honorable Apex Court. He comes and immediately the Lokaयुcta police center. I have not touched the currency. Those cities.
You have not touched the currency. But
CCTV
currency was in your chamber.
A1 carried it in my chamber. He was sitting in the police car. All I'm saying
2026 SSC online essay 960.
all I'm saying is Panchanama says I have collected money, I have given it back to the A1. CCTV footage is 4K resolution. They have taken
4K?
Clarity and voice is very
clarity.
clear. If this is preserved and secured, my lords, I will be coming out clean.
It will be preserved.
One more thing is,
yes, sir.
One more thing is, my lords, this complainant and the inspector, they are in a habit of registering the cases
against each other.
My lord, they fix up some party public servant and I have produced the FIR and complaints copy. And this lady, my lords, the inspector of Lokaयुcta, my lord, I request her that you please check out the CCTV, what has happened. She calls some unauthorized person, they break open the entire CCTV, they take away.
ಏನು ಮಾಡೋದು ಮತ್ತೆ?
ಅವರು ತಗೊಂಡಿದ್ದಾರೆ PF ಮಾಡಿದ್ದಾರೆ that she
PF ಮಾಡಿದಾರ?
ಮಾಡಿದ್ದಾರೆ that shows that I am
PF ಮಾಡಿದ್ರೆ ಇರುತ್ತೆ ಬಿಡಿ.
I have no confidence in the officer. She wanted me to close a case against the complainant. In March I issued a notice for against him. My lord, this is high-handed. Therefore, my lord, this is the only way I can come out is CCTV should be seen.
What to do? This high-handedness is not bought out.
My lord, CCTV footage is very clear. This neither I can do anything nor
You preserve it, sir.
Entry mode is already operating, my lord.
ಏನಂತ CCTV ಅಂತನಾ?
ಅದಲ್ಲ. FIR.
Entry mode stay ಇದೆ, but CCTV footages na you have to save or DVR save ಮಾಡಿ. The respondent state or the Lokaयुcta in whose possession the CCTV footage of the day is available shall not be destroyed, or care should be taken that it remains intact to be produced at the relevant point in time before the concerned court, as the issue revolves around acceptance of the bribe which is allegedly captured in the CCTV. Yes.
I thought,
In the event the CCTV is, in the event the Lokaयुcta or the state would destroy the CCTV, the adverse inference would be drawn against them.
Lordships can place it, summon them and the lordships can see this. 2.5 ನಿಮಿಷ ಇದೆ.
ನಾನು ನೋಡ್ಬೇಕಾ?
Apex Court has done this.
Apex Court will do anything.
Because otherwise, my lord, I am an innocent person. I would not have pleaded with so much of.
Who will say, sir? 7A ಅಲ್ಲಿ who will say ನಾನು ತಗೊಂಡಿದ್ದೀನಿ?
I will not argue one word if CCTV shows something else.
Get it.
Go by that. Let it be produced. I am not going to
PF so made of the CCTV shall be placed before this court on the next date. List the matter on objections ಹಾಕಿದ್ದೀರಾ? ಆಯ್ತು. List the matter on July the 1st, 2026.
35.
Seeking a short accommodation in the matter, my lord.
In this case,
Vacating stage, yeah.
Stay the, my lords. Arguing counsel give personal inconvenience, my lords. Kindly take it up next week also.
Yeah, you have filed it. The eyewitnesses, my lord, and wound certificate is exist.
It may be taken up next
The
week.
entire incident has been recorded in a CCTV.
ಇದು CCTV ನಾ?
Yes, my lords. Although I have produced a USB also.
ಇಲ್ಲೊಂದು TV ಇಟ್ಬಿಡೋಣ.
But it's maybe taken up.
You can see, I can see.
Yes, my lords.
May be taken up next week, my lords. The senior will come and address the arguments.
Photos ಹಾಕಿಲ್ಲ, but.
ಅಲ್ಲ ಫೋಟೋಸ್ ಅಲ್ಲ, ಈ wound certificate ನೋಡ್ತಾ ಇದ್ದೀನಿ.
At page number 6 of my objections.
ಒಂದು ನಿಮಿಷ. Appears to be a case of 118.
Minor injuries are.
Minor. ಇಟ್ಕೊಂಡ್ರಿ. List the matter next week in the same stage as a last chance. In the event no submissions are made, the interim order would stand automatically vacated.
Date may be fixed.
Next week, same stage,
Please, grateful.
Grateful, ma'am.
same day. Date ಏನು? 11.
11th, my lords.
36.
For the petitioner in this case, my lordship. Offense of 420, 468, 470, 471 of IPC, my lordship.
Interim order ಇದೆಯಾ?
Interim order,
This is the
you
case.
filed an application for renewal of passports for me.
This is the case.
ಪಾಸ್ಪೋರ್ಟ್ಸ್ ಎಷ್ಟು ಇಟ್ಕೊಂಡು?
Passports for me, passport.
ಪಾಸ್ಪೋರ್ಟ್ ಎಸ್ ಹಾಕ್ಬಿಟ್ರೆ ಆಮೇಲೆ ಎಷ್ಟು ಇಟ್ಕೊಂಡಿದ್ದೀರಾ?
Singular, sir, singular.
This is the case, my lord. I made my submission yesterday's matter. In connected matter with respect to crime number
ಬಂದಿಲ್ವಾ ಅದು?
505.
ಅದು ಬಂದಿಲ್ಲ.
Yeah, it has been, after arguing length, it was
Oh,
withdrawn.
this matter.
That is not for me, that is for a different accused, he stands
yes.
on a different footing.
Yes,
my lordship.
yes, sir.
May I, sir?
Come, sir.
My
Come
lordship.
On. I mean, come on, merits, sir.
My lordship, the case in a nutshell is that a certain officer, that the allegation is that officer was leasing out HAL lands without any permission from HAL. My lordship, the facts of the case I'd like to take to my lordship, page number 131 of the petition, my lordship. This is the order, this is a judgment of the CBI court, my lordship. It
ನೀವು
sums
ಯಾರು?
up. I'm the first accused for me. In the CBI court, I'm the first accused, which resulted in acquittal. In 131, my lordship, in line 8 of 132, my lordship, I shall read out. This is the entire allegation in a nutshell. It concerns leasing out of 6.5 acres of land in Doddanekondi opposite to ISRO complex in favor of a certain academy, which was looking out for land for training, setting up training institutions in Bangalore, my lordship. That is the allegation. 131, 132, my lordship. 132, 8th line, my lordship.
ಹೇಳಿ.
It states that so and so, there are two accused. The first accused is the petitioner herein, and a second accused, they say, is the director of a company. So the allegation is that in order to cheat a certain company, we have, in respect of leasing out of 6.5 acres of land, which is situated at Doddanekondi, opposite to ISRO, to a certain company, my lordship. That is the allegation. In this particular case, I have been acquitted, my lordship. My lordship, I would like to take my lordship towards the facts of this case. Page number 135, my lordship. FIR was registered, my lordship, under 120B 420. Later, permission was taken, and also section 13(1)D was also considered in the charge, my lordship.
That's again public servants.
Public servant, my lordship. My lordship, this resulted.
ಇದರಲ್ಲಿ it's a PCR or complaint?
This is a complaint, my lordship. This is by the person who was allegedly cheated. This resulted in a acquittal in page number 225.
Which is this the complaint, that page?
Annexure B,
No, page 14, annexure B, that's the
Three
complaint.
complaints, my lordship. I will start with the first complaint.
That's HL itself is the complainant.
HL itself is a
No, my lordship. HL is the complaint. That is right, my lordship.
Correct.
That is right, my lordship. My lordship, this particular complaint, the first complaint where I showed my lordship, in this particular complaint, 2025, I was acquitted. During the pendency of
1st February 2023 complaint.
Illa Swami, I'm only talking about the present complaint which I demonstrated to my lordship in page number 135. Pursuant to this, my lordship, this resulted in acquittal in 2025. During the pendency of this case, my lordship, the second FIR came to be registered, my lordship, which is the HL case. I'd like to take my lordship to the complaint in the HL case, my lordship, which is page number 14. Page number 14 is the complaint by the general manager of FMD, which is the Facilities Management Division. The petitioner herein was the general manager of the road trimming division, not the Facility Management Division. It states in the complaint.
You were also an employee of the HAL.
I was also an employee, but I was not with the Facilities Management Division. That is the division that takes care of facilities, lease, etc. It states that, my lordship, I shall read the concerned portion in the complaint in page number 14.
You are Vel Murugan.
I am Vel Murugan. It says, it has come to the knowledge that some persons in connivance with some others.
Yes, that's a very short complaint I've seen.
My lordship, it does not state my name. It says the signatures.
It's a complaint, sir.
Oh, this Swami. It says that the signatures of HAL officers have been forged. That is the complaint.
Let the investigation go on.
My lordship, let me complete, my lordship. On the same set of facts, I have already been acquitted. The same set of facts. It is the same set of facts, my lordship.
Page.
My
Special,
lordship.
special CC 69 of 2021?
How this one? Same complaint, my lordship. It is exactly the same thing, my lordship.
1 minute, 1 minute.
131, my lordship, is the summary of the complaint, my
Bail
lordship, in the
Murugan.
judgment.
That's CBI, yeah?
That is CBI, my lordship.
Same.
That is by the person who got cheated, so allegedly cheated. He went to the CBI. And HL itself registers a complaint. It's a case of double jeopardy.
Eh?
How this, Swami?
Receiving bribe and cheating.
The first complaint, the person who allegedly got cheated went to the CBI. A complaint, FIR came to be registered. Charge sheet came to be filed. After a full trial, I was acquitted in 2025. During the pendency of that trial, my lordship, in 2023, this particular FIR came to be registered, my lordship, by HL.
What was the date on which the CBI registers this?
2020, my lordship. I shall take my lordship to the consent portion.
7/8/2020.
27/8/2020.
That is right, my lordship.
Same facts is there?
Same facts, my lordship.
Your lordship may see the facts in this case. The incident we're talking about what happened in 2022.
No, my lordship. It is also 2017.
Praveen, 1 minute.
Page 14 only.
No. Now you come here.
Yes, sir.
2020.
Yes, sir.
Same matter of leasing HAL lands, maybe incident of 2020. Identical incident.
So that now they're saying now letterheads of HAL have been
Same
used.
thing. Illu ashte. Leasing out, everything is here. Come to page 132.
He will not get a clean sheet once he get acquitted. He will not get a clean sheet to commit the same offense
No,
again.
no, no. ಅದೇನು ಒಂದ್ಸರಿ ಫೈನ್ ಹಾಕಿದ್ಮೇಲೆ ವೈಲೇಟ್ ಮಾಡ್ತಾ ಹೋಗ್ಬೋದು ಅಂತಲ್ಲ.
So that is what he is claiming. Because I'm acquitted, there's no way I can commit
The
the same
letterheads
crime.
have been subjected to FSL, my lordship. The FSL report is also recorded in the judgment. It is not my signature.
Same letterhead.
That may be, my lord, that incident happened before 2020.
Correct. Incident happens between 15/6/2015 to 3/12/2018.
Correct.
Same conspiracy, same letterhead usage, identical allegations. But if he has committed another set of allegations in the same manner just because he is acquitted, let's see.
That is
But,
what the Your lordship may see now the FIR duration
seriously?
is 2020.
Matte?
No, my lordship, I haven't. I was not even in the same position anymore. I was sacked from that position. I was not in that position. After 2017, I was not in that place anymore. I was not in HL. I was transferred to somewhere in Australia.
Your lordship may see page 10. Duration, time period which you're talking about.
Time duration. Oh, idu 20, but during the pendency of that trial.
Yes.
After 2017, I was not in HL, Bangalore anymore, my lordship. I was transferred to Northern India. I was demoted.
He cannot take a shelter of that
No,
pending
I'm not
case.
on that. Identical allegations.
I understand, my lords. What bothering
No,
my
he
lordship-
cannot take shelter on that, true. But this duration is different.
So let us examine, and then if nothing is there, he can always will file.
One humble submission, my lordship. Thereafter.
But Praveen, what bothers is HAL is the complainant.
That is right, my
And lands that are leased to HAL are on the forged letterheads.
My lordship, that I shall, my lordship.
So if it is the same allegation there, that allegation appears to have been continued now.
Page number 72, my lordship.
Person against whom that land was promised, he files a complaint in crime number 505, which came before your lordship. That was dismissed and sent back for investigation. Now both these cases are clubbed and transferred to CID for investigation.
If I may, my lordship, page number 201, my lordship. 201. This is the judgment where the FSL report on the said letterhead is examined, my lordship. Para number 70.
No, we'll see. I will direct the investigation to be conducted looking into this aspect as well. In case they file a closure report, let them file. Because in 2 of the accused cases, I've already sent it for investigation in the same crime.
In those cases, my lordship.
In the same crime.
However, my lordship, in those cases, that was the person who received the money. The ingredients of 415 were there.
No, that's all right. But once I have sent the matter for investigation in one of the accused, I can't quash it in the other accused. I will observe that the investigation shall look into this as well.
I may be permitted a day's time to seek instructions, my lordship.
For what?
My lordship, the reason being, the allegations against the first accused are different, my lordship.
I will not say, let us see, or you will take a call. I will finish
One
it.
day time code is for me. I'll just confirm. I'll take instructions from my coordinating council, my lordship. A day's time may be granted. It may be posted tomorrow, my lordship. Or day after. I mean, Monday. Any date convenient to this
Monday,
honorable court.
fresh matters.
Any date convenient to this honorable court. my
Monday,
lordship.
fresh matters only for
For me to seek instructions, my lordship.
ಅಲ್ಲಿ
From my coordinating council, my lordship.
There I will pass an order.
Yes, my lordship.
Yes.
Oblige, my lordship.
Yes.
37.
Please, your lordships. My lords, the allegations are of grievous hurt and the Atrocities Act is involved. My lords, the entire dispute, my lord, stems from this. The bus driver of a school, the principal of a school and the secretary of the school have been made accused. My lords, the allegation is that the bus driver used certain offensive language against the parent of that child who would go to school. My lords, this entire thing stemmed from a dispute where the parent registered a case with the block education officer. The school gave a reply and said that it was actually the children who were coming late to be picked up from the school bus. On this, my lords, a complaint finally, my lords, it was going back and forth with the block education officer. A complaint comes to be registered.
Petitioner is the driver.
My lord, the driver, the principal of the school, and the secretary of the school. In fact, even while an interim order came to be granted, this court observed the triviality, my lords, and how the entire law seems to be misused here.
Yes,
My lords,
madam. Who has filed vacating stay?
We have filed.
Yes, sir.
The case and counter case. Both cases have to be investigated because of this. And I'll give the statements recorded, my lord.
Nothing, my lords. In fact, I say they say that
Counter case challenge ಮಾಡಿದಾರಾ?
ಇಲ್ಲ ಅವ್ರು ಮಾಡಿಲ್ಲ my lord.
ಮಾಡ್ಬೇಕು, ಯಾಕೆ ಮಾಡಿಲ್ಲ?
ಅವ್ರು ಮಾಡಿಲ್ಲ. Second. ಇಲ್ಲ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ಮೇಡಮ್, ಕೌಂಟರ್ ಕೇಸ್ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. But my lords, kindly see at page 23 what is the allegation. My lords, kindly see, he says idiot.
Idiot.
That is what he says, my lords. That is how atrocities is invoked. My lords, kindly see 23 last 4 lines. My lords, absolutely we are wasting.
ಗೌರವ ಕೊಡುವುದಿಲ್ಲ. Yes, madam. Anything else?
23 second paragraph.
Huh?
Page number 23.
23, but in my favor that is.
Complaint.
I'm grateful, my lords. That's in my favor. Last 4 lines, my lords. That is the complaint.
23, yeah.
23. Last 4 lines, my lords.
SC/ST Act.
ಡ್ರೈವರ್ ಗೊತ್ತಾ ನೀವು ಅದು ಅಂತ?
And my lords, nothing made out for grievous hurt. In fact, your lordships in Ritesh Payas.
Grievous hurt ಅಲ್ಲಿ ಬರುತ್ತೆ.
No grievous hurt, my lord. My lords, Ritesh Payas, my lords, which your lordship said.
Ritesh Payas, yes.
And that, my lords, recently has been in another connected matter. Supreme Court has.
Justice Anjaria has quoted that judgment.
Yes, my lords, approved it.
Approved it.
Approved it.
That was in the basement car park.
But there also, my lords, had observed there's nothing for grievous hurt. But there, of course, my lords, there was a wound certificate. The wound certificate in Ritesh Payas.
Where?
In Ritesh Payas, my lords.
No, there I said it, they were interested witnesses also.
ಇನ್ನೊಂದು ಕೇಸ್ ಕ್ಲೋಸ್ ಆಗಿದೆ ಮೇಲೋಡ್ ಅದು.
ಇದನ್ನು ಕ್ಲೋಸ್ ಮಾಡೋಣ. ಆಯ್ತಲ್ಲ? ಅಟ್ರಾಸಿಟೀಸ್ ಏನಿದೆ?
SC/ST Act.
ಅದೇ ಏನಿದೆ ಅಂತ ಕೇಳಿದ್ದು.
ಕ್ಲೋಸ್ ಆಗಿದೆ.
ಅವ್ರು ಕೊಟ್ಟಿದ್ದು ಕ್ಲೋಸ್ ಆಗಿದೆ.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್. As far as I know, that's.
ಇದನ್ನೆಲ್ಲ ಕ್ರೈಮಿಗೆ ಬಿಟ್ಬಿಟ್ರೆ ಅಷ್ಟೇ. ಎಲ್ಲ ಮಿಸ್ಯೂಸ್ ಆಫ್ ದ ಕ್ರಿಮಿನಲ್ ಜಸ್ಟಿಸ್ ಸಿಸ್ಟಮ್. ನಿಜವಾದ ಕೇಸ್ಗಳು ನಡೀತಾ ಇಲ್ಲ ಅದಕ್ಕೆ. NDPS ಕೇಸ್ಗಳು ನಡೆಯಲ್ಲ, ಮರ್ಡರ್ ಕೇಸ್ ನಡೆಯಲ್ಲ, ರೇಪ್ ಕೇಸಸ್ ನಡೆಯಲ್ಲ. ಯಾಕಂದ್ರೆ ಆಲ್ ದೀಸ್ ಫ್ರಿವಲಸ್ ಕೇಸಸ್ ಕೋರ್ಟ್ಸ್ ಆರ್ ಎಂಗೇಜ್ಡ್. Yes. The petitioners accused 1, 2 and 3 stand at the doors of this court calling in question registration of a crime in crime number 129 of 2025 registered for the following offences. Heard so and so facts enumerated are as follows. The second respondent registers a complaint. The second respondent registers a complaint before the block education officer regarding the inaction of the principal and school administration who allegedly enraged, which has allegedly enraged the principal. The second respondent then seeks to register a complaint against these petitioners on the score that the driver of the bus and the principal and
secretary of the
and the office bearer of the school have all indulged in hurling of abuses against the petition, against the complainant, and also did assault him. This becomes a crime in crime number 129 of 2025. A counter case is also registered by the petitioner, the principal of the school, against the complainant, which becomes a crime in crime number 130 of 2025, albeit for different offences. Therefore, it becomes a case and a counter case. The learned counsel for the complainant submits that the counter case in crime number 130 of 2025 has since been closed by way of entering into a settlement between the parties. Therefore, what remains is the present case.
I'm not sure about that, my lord. I think it's still pending. This.
Settlement. The registration of the crime has driven the registration of the crime has driven the driver and the principal and the secretary to this court in the subject petition. The learned counsel Gautam Bharadwaj, appearing for the petitioner, would vehemently contend that the provisions of the Atrocities Act are misused and abused in the case at hand for no reason whatsoever, as the children of the complainant were arriving late to come into the bus for pickup to the school, which had derailed the entire timeline of the bus arriving at the school. When this was sought to be complained at, the driver is in fact hurled abuses at and not the other way around. And notwithstanding this said fact, a crime comes to be registered against the driver, the principal, and the secretary of the institution, alleging offences under the Atrocities Act. The learned counsel seeks quashment of the proceedings. Per contra, the learned counsel representing the complainant would submit that the matter involves hurling of abuses against the member belonging to the scheduled caste or scheduled tribe, as the case would be, and would become the ingredients of the Atrocities Act. And therefore, the counsel would submit that the matter must be permitted to be investigated into in the least. The learned additional SPP would toe the lines of the learned counsel appearing for the complainant, but however would place the material on record with regard to the statements recorded of the hurling of abuses, if any, against the complainant. I have given my source. The aforenarrated facts, link in the chain of events, and the dates are all a matter of record. They would not require any iteration. The entire issue has now sprung from the registration of the complaint. Therefore, I deem it appropriate to notice the complaint. The complaint reads as follows. The complaint narrates that the driver of the bus has hurled certain abuses, and the principal was looking at the hurling of abuses and stood silent and did nothing. The secretary, who was nowhere, is also dragged into the web of proceedings just because he is the secretary of the school. This becomes a crime in crime number 129 of 2025 for the aforesaid offences. The primary offences are of the Atrocities Act. The offences are the ones punishable under section 31R and 31S of the Act. Section 31R and 31S would require hurling of abuses in a public place or a place of public view. Neither of it is even averred in the complaint for an investigation to be permitted to be continued against these petitioners in the case at hand. Jurisprudence is replete with the fact of jurisprudence is replete as to how the ingredients of the offences under section 31R and S must be present in a given case. The apex court in the case of Hitesh Verma versus State of Uttarakhand 2020 SCC on 2020 10 SCC page 710 has held as follows, para 10 to 17. The said judgment is subsequently reiterated even in Gunjan 2026 SCC online SC page 834, where the apex court considers the entire spectrum of the Act and all the entire spectrum of the law that is laid down by hitherto, and lays that hurling of abuses in a secluded place, hurling of abuses in a basement or within the four walls of a particular property would not become a public place or a place of public view. The same goes in the case at hand. Therefore, permitting further investigation even in the case at hand would become an abuse of the process of the law. What remains is the offences under section 352, 351 and 115 of the IPC. They are 323, 504 and 506 of the IPs. Interpretation of those provisions as well need not detain this court for long or delve deep into the matter. The apex court in the case of Mohammed Wajid versus State of Bihar, 2023 SEC Online AC page 951 has specifically interpreted these provisions. If the elucidation of law by the apex court in the aforesaid judgment is pitted against the facts obtaining in the case at hand, what would unmistakably emerge is permitting investigation even would become an abuse of the process of the law. Allowed cost.
They have filed a complaint in case if that's pending, let them.
Adu challenge ಮಾಡಿ, will close that also. Madam,
ಅದ್ರ ಬಗ್ಗೆ ಏನು ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ತಗೊಳ್ಳಿ. ಚಾಲೆಂಜ್ ಮಾಡಿ, ಗೌತಮ್ ಈ ಕಡೆ ಬರ್ತಾರೆ. ಕಾಸ್ಟ್ ಮಾಡಿ.
That's this matter, that's going to be disposed on 15th of April.
ಏನಾಯ್ತು? What has happened?
Direction supposed to have given to police station, my lord, for further investigation.
That's that day after hearing us, my lord said that we referred to the police station for further investigation.
ಏನಾಗಿದೆ ಇಲ್ಲಿ?
Is remand ಮಾಡಿದೀರಾ ಸ್ವಾಮಿ? You've sent it back to the magistrate. The last paragraph.
Lordship may recall, this is the case.
Oh, ಇದು further, this is the signature ಆಗಿಲ್ಲ ಅಂತ.
Oh,
Correct.
correct. This is the case.
Oh, I said I will myself direct further investigation.
Correct.
It's okay.
बड़े बड़े देशों में छोटी छोटी बातें होती हैं. Yes.
I have filed an IA for that, to that effect. That's
Well, allow the IA, I'll correct it and
great for me. That's
further investigation I will myself permit.
yes.
Yes.
That's one request. I would care time bound, that's within 1 month.
ಅದು
2
ಮಾಡಿ,
months.
that I will do. Yes.
Great.
Further investigation ಅಲ್ವಾ, 1 month ಸಾಕು. Yes. Monday will release it, corrected ಮಾಡಿ.
Yes.
39.
7A.
Yes, please.
7A ನಾ?
Yes, please. 7A.
ಮೇಡಮ್ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋಣ. 2nd ಹಾಕ್ಲಾ? July? 2nd July. Objections if any by then. Next.
40.
Samir.
Matter pertaining to medical negligence on 25/6/2025, the lordships had allowed the petition and directed for registration of an FIR.
Oh, this, it is not done still anta.
No, the FIR, if you I filed a memo, I filed an IA on 15/4/2026. IA for direction. Could the lordship just take up that IA?
IA ಏನು ಸಮೀರ್?
IA for direction, because the FIR is registered. If the lordships come to page 58. Page 58.
This that hemoneurothorax.
Yeah, please. The perma catheter on the right hand side.
Perma catheter on the right hand.
The relevant portion of a lordship's order is at page 54.
ಅಲ್ಲ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಹೇಳಿ?
ಇವಾಗ FIR has been registered. There's no difficulty on that on 2/7/2025. Now after that, in terms of the 3 judgments of the Honorable Supreme Court in Jacob Matthew, Martin F. and Lalita Kumari, they're refusing to send it to any other medical board or independent medical expert. Now those judgments say after the FIR is registered, before a charge sheet is drawn up, you have to again place it before a medical board or an expert. Now that they are not doing. In fact, if the lordships were to just come to page 9, I have stated on oath as to what is it that I'm suffering from. Page 9, I have said, lordships has page 9. No effective or meaningful investigation has been undertaken by respondent number 4.
No, Samir, you tell me, how can I now tinker in
No, I'll tell you,
IA for
lordships,
direction?
because the basis of that is in your lordship's order.
Now, FIR is registered.
Yes.
FIR, the investigation will be done in a manner known to law.
No, if your lordships were to please say, I bow down what is falling from your lordship. Could the lordships just come to page 54 in your lordship's own order? Page 54 is where the operative portion begins. And then at page 55, your lordships in the operative portion say, and proceed further in accordance with law.
Correct.
Now, my only difficulty is this, FIR is registered. Now, after that, what has to be done in the manner known to law, which is to place it at the hands of an independent medical board in addition to what was already placed before, because if lordships were to recall.
See, madilla antandre, you come.
They madilla. Madila, that is my grievance. My grievance is during the pendency of this petition, it was placed before Victoria Hospital. They took a particular call. Your lordships have recorded the observations of that in your lordship's order. Now, after that, after the registration of the FIR, they'll have to again place it before another independent examiner, independent medical board or a doctor. Now that they are not doing. In fact, if lordships were to now see page 9.
Samir, I cannot now direct the investigating officer to go in a particular manner. I cannot direct the investigation sitting here.
Not at all. I am not
Then-
asking for a predetermined conclusion. Not at all.
Yes.
I understand. If they take a call saying, if the second medical board takes a call saying there is no negligence, I bow down. But my problem, the grievance that I'm suffering before lordships is they're not even placing it. In fact, whenever we have personally gone and requested, they say that we don't know whom to give it to. You please suggest a name. Now it is not my lookout to suggest a name because it has to go to some independent government
That
authorized
they will do.
that they're
No
not
wa-
doing. That is my
no
grievance,
warrant
which is
for-
why I waited for a year. This your lordships disposed of this matter in June last year. I have, in fact, if your lordships were to please see at page 56, I have given an intimation saying the order has been passed. Please do the needful. They have registered the FIR. After that there is no mahazar that is drawn up. There is no statement
No,
of mine that is taken up.
let something come out. You seek for further investigation. No problem at all.
Yes.
But now to direct the investigating officer, you do X, Y, 1, 2, 3, 4. No, that's not the scope of this court.
And my only limited grievance was, I leave it at this. Limited grievance was your lordship in your own lordship's order say,
Maybe
in accordance with law.
See, I cannot. It's not a continuing mandamus where I
understand.
keep the matter and say investigation should be carried out in a particular manner. No.
Not at all, not in a particular manner. Just by what your lordships have said in accordance with law, which is what the three judgments of the Honorable Supreme Court they say. Now,
If
at
they
least
will
let
do,
them,
we'll see. If they don't do it, come back.
they have not done it.
No, if they don't, final report is filed.
Absolutely nothing has happened.
We'll see. What's the stage of investigation? You see.
Let those records be summoned.
The
That is my-
investigation, no.
In the application of my learned friend, whatever making is
No,
sufficient.
that he is wanting to rely on Supreme Court judgments to a particular manner, which I will not entertain.
Well, at least if
We
you
will
have
reserve
written-
liberty to you to approach this court in the event investigation is not done. It's a shoddy investigation or slipshod investigation, you can definitely come.
If there was at least some fodder for me to go by, I understand. But here, there is no movement at all.
No, I I
also
cannot
can be
create fodder.
All that I'm saying is because if your lordships were to recall in that previous adoption matter also, something similar had happened. Lordships
What
had-
happened to that?
That now the Kara has issued the
Guidelines
the
also.
NOC.
NOC issue ಮಾಡಿದ್ರ?
Adralunu, your lordships were kind enough to allow the petition. I filed an application. Certain orders were passed. Now, my only respectful submission is in the four corners of what your lordships have said in this particular matter, at least let them demonstrate as to what it is they have done. Because
No, you do one thing. If they don't do it in a say 2 or 3 months time, if they don't file the final report, you approach the court. Anyway, it has to come back before me only.
if that observation is made, then I think the purpose
No
of this
observation, no observation is necessary. Let them do their investigation. If they do, as I told you, slipshod or a shoddy, you can always come.
the difficulties are not even referring it. If they refer it, if some result comes out, there is no difficulty.
That IA will be beyond my jurisdiction. I'll
Sorry,
be
Your Lordship.
overstepping, yes. I,
Observation be passed on this.
an application is preferred by the petitioner in a petition that stood disposed dated in last on the score that the investigation is not going in a particular manner which the apex court has directed in two or three judgments concerning medical negligence. The learned counsel Samir Sharma would seek to contend that this court must issue directions to the investigating officer to investigate the matter in a manner in which the apex court has directed such investigations to be done. The application prima facie would not become entertainable for the reason that directing the investigating officer to investigate in a particular manner is not the scope of the power that can be exercised at the hands of this court. In that light, if the investigation is not going in accordance with the directions of the apex court in identical cases, it's always open to the petitioner to seek further investigation or re-investigation into the matter in a manner known to law. With the post observation, the application stands disposed.
Or take such other steps in accordance with.
I think yes.
Great.
Next.
41, 7.
7A.
Second.
Yes, please.
Objections hakidira?
Yes. There is an interview.
Second. Whatever is there.
42, 7.
7 mm.
appearing for the respondent complainant.
ಈ ಕಡೆ ಇದ್ದೀರಾ?
ಅದೇ ಮೊದಲನೇ ಸಲ ಈ ಕಡೆನೂ
ಹಾ ಹಾ.
In fact, senior counsel Arun.
ಐಪ್ಯಾಡ್ ತಂದಿದ್ದೀರಾ?
Yes.
ಹಾ ಮತ್ತೆ ಓಪನ್ ಮಾಡಿ.
No, my lord. In fact, senior counsel is engaged.
ಅವ್ರದ್ದಾ ಅದು?
Short accommodation.
No short accommodation. Vacating stay application ಇದೆ. If vacating stay was not there, I would have granted. Yes, yes, ಹೇಳಿ.
Kindly pass over.
5 ಗಂಟೆಲಿ ಪಾಸ್ ಓವರು. ಇಂಡೈರೆಕ್ಟ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟು ಇಲ್ಲ ಹೇಳಿ.
No, my lord.
Will vacate the interim order.
No, my lord. Kindly.
What is the interim order?
Stay of investigation. I think.
ನೀವು ಕಂಪ್ಲೇಂಟ್ ಈಗ
Please, Milods.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
ಅದು 3 ತಗೊಂಡಿದ್ದಾರೆ.
3 ಲಕ್ಷ
ಇನ್ನ 7
ಕೋಟಿ.
Milods, after the orders passed by the deputy commissioner to transfer the khata in my name, the special Tehsildar says you go and meet the accused number 2. Then we go and meet the accused number 2. He puts a demand of 10. So then there is a conversation. 10 lakhs. Then there is a conversation between accused number 1 and 2. Not the first, he asked us to go and meet at a particular place. Then the conversation between A1 and A2 Milods is recorded because he wants to converse in our presence on WhatsApp call. We have recorded. Page number 56, they have themselves produced. So this A1 asks him whether he has given the money. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ 3 ಕೊಟ್ಟಿದ್ದಾರೆ ಬರ್ಲಾ ನಿಮ್ಮ ಮನೆ ಹತ್ರ ಬಂದು ನಾನು ಇಸ್ಕೊಂಡು ಹೋಗ್ತೀನಿ. All these conversations are recorded. Now the only grievance which they have raised is that there is no direct demand, there is no direct acceptance.
At Supreme Court.
Rangayya's case, that's the.
Rangayya. Gone.
Kindly, my lord. A short accommodation.
ಯಾರು ಸೀನಿಯರ್?
Arun Sham.
ಗೊರ ಕೇಳಿ.
Yes.
ಇನ್ನು 5 ನಿಮಿಷಕ್ಕೆ ಮತ್ತೆ ತಗೊಂತಾರೆ ಅಂತ ಹೇಳಿ.
Yes.
ಬಂದ ತಕ್ಷಣ ತಗೊಂತೀನಿ. ಏನಿಲ್ಲ ಇದರಲ್ಲಿ. ವಿಕೆಟಿಂಗ್ ಸ್ಟೇ ಇದೆ ಅದಕ್ಕೆ.
ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಬರ್ತಾರೆ ಈಗ.
ಯಾವುದು? ಹಾಗಾದ್ರೆ ಅದಿದೆಯಾ? ಹಾಗಾದ್ರೆ 5 ನಿಮಿಷಕ್ಕೆ ಬರ್ತಾರೆ. ನೀವೇ ಇಲ್ಲೇ ಇರಿ, ಅವರೇ ಬರ್ತಾರೆ.
ಅವ್ರಿದ್ರೆ.
Yes.
43.
43, 44.
Vicating stay ಇದೆಯಾ? ಇಲ್ಲ.
7 name.
Second July objections if any by then. There is no
one minute, on the last
interim order ilva?
Interim order illa. Last date your lordship said.
Lord, in this case, investigation is already completed.
Final report is sent for
charge sheet ಹಾಕಬೇಡಿ ಅಂತ ಹೇಳಿದಿರಾ?
ಇಲ್ಲ, charge sheet ಹಾಕಿದ್ದಾರೆ. I have challenge.
ಹಾಕಿಲ್ಲ.
Your lordship,
my objection is also ready. 2nd July.
4 times your lord. Last date objection.
No, this earlier case is not the interim order granted by me.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
7A ಇದರಲ್ಲಿ ಏನು ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೆ ಲಾಸ್ಟ್ ಟೈಮ್ your lord, failing which this court will be constrained to grant. ಹಾಕಿಲ್ಲ.
Lord, objection is ready. Lord, IO is official duty. Search ಹೋಗಿದ್ದಾರೆ. Search ಹೋಗಿದ್ದಾರೆ.
ಯಾರನ್ನು ಸರ್ಚ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
ವಾರಂಟ್ ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ. Lord, I'll file it in the counter tomorrow itself. I'll serve a copy.
ನಾಳೆ ಹಾಕಿ. 2nd July. Yes. ನಾಳೆ ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ
I'll file it.
Please.
45.
Proportionate asset. 13.
Objections are ready. I'll file statement of objections and I'm filing.
ಫೈಲ್ ಮಾಡಿ. Yes. List on ಇದು ಬೇರೆ ಡೇಟ್ ಕೊಡೋಣ.
DA.
ಅಲ್ಲ DA ಬೇರೆ ಡೇಟ್ ಕೊಡೋಣ. 7th July.
Order 46.
My lords, I paid for the petition.
Hearing for respondent, my lord.
ಏನಿದು?
I
Filed an application for vacating stay.
ಎಲ್ಲಿದೆ? ಇದೆಯಾ?
My lords, I seek time to file objections, my lord. There are transcripts of the audio. They have produced the transcripts of the audio recordings, my lords.
ಏನು offense ಏನು?
498.
Conversation between the.
498 ಏನು? You are the complainant.
I am for the complainant.
Who are the petitioners?
ಎಲ್ಲರೂ ಇದ್ದಾರೆ. 1 to.
Husband also?
Husband also.
Husband ಗೂ stay ಆಗಿದೆಯಾ?
No, my lords. Because the telephonic conversation between A3, who is the elder brother of A1, and he is in possession of all the Sridharan articles, including the jewelry. Everything is in telephonic conversation.
ನಿಮ್ ಜ್ಯುವೆಲ್ರಿನಾ?
Yes, my lord.
ನೀವು ವಾಪಸ್ ಕೊಟ್ರೆ ಕ್ರೈಮ್ ವಾಪಸ್ ತಗೊಂತೀರಾ?
Yes, my lord.
Jewelry ಕೊಟ್ಬಿಡಿ.
Objections, my lord. There are audio transcripts.
Give up the jewelry. Everything goes.
My lords, I'll take instruction from my senior, my lords. We'll file objections as well.
List on
Short date, my lords. evidence started in criminal trial.
ಆಯ್ತು. List on 30th June. Yes. Next. ಇಲ್ಲ withdrawal. ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಫಾರ್ಮ್ಯಾಟ್ ಇರ್ಬೇಕು ನೋಡಿ. Withdrawal, yes. Next. 48.
48 ಆಗಿದೆ 49.
Yes. ಸ್ವಾಮಿ.
Okay, please, my lord. A7 is before this honorable.
ಓ ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ದು A7 ಇವರು.
The offences are under NDPS Act, please, my lord. That, my lord, on
Post
4/11/22.
immediately after service of notice of second respondent ಯಾರು?
That, my lord, the police officer, my lord, who lodged the complaint with the
The
jurisdictional
learned
police.
additional SPP is directed to accept notice for the second respondent as well, thus completes the service of notice. List the matter on 17th.
That, my lord, insofar as other accused are concerned, my lord, the stay has been granted by this honorable court, please, my lord.
Same crime?
Yes, yes, please, my lord. There
Tag
are-
along with so and so, same order. Next.
Obliged,
17th.
Obliged.
Yes.
50.
Post immediately after service of notice upon the respondent. Intermodal, yeah?
ಇಲ್ಲ intermodal, he is advocate in US, my lords. That
Advocate in US?
No, no, my lords. What has happened? Someone has sold his father's property, created a GPA, my lord, and sold the property, A3 and A5. Now they are fixing, I also entered into conspiracy. That's the allegation. There is a civil suit, sir, there, my lord.
Right, we'll
He
see.
has to come to.
Post immediately after service of notice upon the respondent. Next.
51.
Same order. Withdrawal. Withdrawal in terms of memo. Next.
52.
Post immediately after service of notice upon the respondent.
53.
Same.
54.
Served. What offense?
Here, this is not 406, 420, under DNS plots.
Charge sheet or?
Ecclesiastical tribunal not having served
Yeah.
the notice.
Post immediately after service of notice upon the respondent. Interim order subsisting shall continue to the next date of hearing. Next.
170.
Raj Prabhu. Any office objections?
So the matter is settled, please, your lordship. The
Offense.
offense is 323 and 324 of IPC.
Parties.
Both present, please, your lordship.
Yes. Anvija.
Bali.
Closed.
Filing
Yes.
worker for respondent.
Odd sheets in it.
Compromise petition.
Yes, next.
56.
56, huh? 56. Oh, ಇದು 7A, 2nd July.
Yes, please.
Objections ಹಾಕಿದ್ದೀರಾ?
Objections ಹಾಕಿದ್ದೀವಿ 56.
Objections if any by then. Yes, next.
File ಆಗಿದೆ objections.
57.
7 minutes. I
Appear on behalf of Shanti.
But
I
short
appear on behalf of
validity
Mr. Shanti
passport,
Bhushan.
my lord. Short validity passport, my lord, was issued by this court.
ಏನಾಗಿದೆ? Where is Arun Sham?
Lords, he is elder before court all 18.
ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದೀನಿ.
Have informed. Lords,
On account of a stay, he was already
You are back?
granted. Yes.
Supreme Court Raja ಅಂತ you are back here. Yes.
Lords, wide order dated, my lords.
A short validity passport was already.
Is already
on account-
granted.
so the same benefit
Period
may
of
be
1 year
extended.
it was granted.
All right.
Lords, now, my lords, that 1 year has expired.
Where do you want to go?
London, my lords.
London?
Please.
All right, well, regular passport.
See, the short
Now
validity
Supreme
is
Court says you can't, no SVP.
No, I believe that is with respect to the pendency of an appeal.
Now
As of
Apex
now,
Court
he's-
says you can't withhold grant of passport.
As of now,
Despite the charge sheet pending.
I will,
Apex Court interprets 62F itself. You've not seen?
I haven't.
You haven't?
Got an opportunity to
What
look
do you
at it
mean?
in its entirety. I may be permitted.
Ask Shanti Bhushan, I'll tell you. Yes.
I may be permitted to differentiate that then. As of now.
No
the short-
distinguish, what Supreme Court judgment will distinguish? Same facts, yes.
No, as of now, he's sought for a short validity passport and that may be granted. And then considering that it is only a stay that
Wait,
has been
wait, we'll
granted.
take you, we'll get that judgment Monday. Monday fresh matters. We'll grant him a regular passport. In offense, in
304A, my lords.
304A, and whom did you kill?
Lords, history and my lords.
Huh?
Lords, in fact, my lords, there is no prayer for interim order also, my lords.
What is, your accused number 1?
Please, my lords.
What is the incident?
Lords, an accident occurred, my lords. My lords, in fact, my
You are
lords.
the driver?
Please. Lords, my prayer, my lords, is limited, my lords, for the issuance of short validity passport.
I will see Monday, yes.
Wide annexure re, my lords, my complaint is the first, my lords. Subsequently.
Notice ಮಾಡಿದ್ದೀನಾ?
Notice ಆಗಿದೆ. I have the protection, but my lords, what my grievance is, my lords, 3 notice have served.
Fresh process ತಗೊಳ್ಳಿ first. needful to be done.
The
by
grievances between
by-
police, my lords, not between.
Needful to be done in the next 1 week. List the matter.
Monday, my lords,
No, sir.
Tuesday.
No, sir. But don't tell every day now.
Grievance in Gota, my lords,
Hmm.
my lords.
Hmm.
Here, my lords, first notice, the same set of facts. Second notice, same set of facts. Third notice also same set of facts, where, my lords, I have been taken into the custody, kept 1 week, and sent to the judicial custody, obtained bail. Now, my lords, here, my lords,
Now, what is your prayer, sir?
I have demonstrated.
You have not yet demonstrated. What is your prayer?
Prayer is, my lords, to quash the cognizance, my lords.
Alva.
Because, my lords, Annexure E, my lords, may be looked into, my lords. What
Look into
Annexure
it.
E?
Wait, Avinash.
Please, my lords.
15, 16th, fresh matters.
Grateful,
Yes,
my lord.
next.
59.
Post immediate left service of notice upon the respondent. Interim order continue.
I am for respondent number 2, my lord.
Oh, idira?
Yes, my lord.
Yes, Learned Counsel so and so undertakes to enter appearance for the second respondent, register to print the name of this so and so second respondent, thus completes the service of notice. Yes.
My lord, and implicit.
Proposed.
Yes, my lord. Implicit
Well, where is
application
your
has
band?
been on online. They
Huh?
are a party, my lord.
Oh, respondent in person.
Of the victim, my lord.
And R2 is
New
present, my
respondent
lord.
in person.
Respondent number 2, my lord.
What's the case about then?
There is
Hoodwinked so many? Huh?
there is a brothel. There is complications in the pub, my lords.
Complications in the pub.
My lords, they are all the.
Pub always complications happen.
My lords, pub ಒಂದು miscommunication ಆಗಿ ಜಗಳ ಆಗುತ್ತೆ, my lords. ಹಾಗಾಗಿ they are filed.
ಇವರೆಲ್ಲ ಹೊಡೆದ್ರ ಅವ್ರಿಗೆ?
My lords, we are the owners, my lords.
Who beat you, sir?
There are bouncers of 1522 pub, my lord.
Bouncer, 1522 bouncers, sir.
Including manager, my lord.
1522 pub.
It's located in Malleshwaram, my lord.
Huh.
So White House company,
Huh.
it's owned by Mr. Chetan.
Ayo, who's bothered about who owns it? Yes.
Manager also included, along with 7 to 8.
Okay, bouncers
my lord.
ಇಟ್ಕೊಂಡಿಲ್ಲ.
Lords, we are here
They
before.
stabbed this impeding applicant, my lord. I
Both
filed
have
a
been-
complaint against the Subramania Nagar police station.
Police
We
station.
will file a detailed objection, my lord. Kindly direct them to furnish a petition copy.
Yeah.
Get the records.
Yes. Wait, Tuesday.
Please, my lords.
We will not allow the case to bounce. Yes. Rest the matter on 16th.
Yes, so please, my lord.
16th, on the application, stay ಇದೆಯಾ?
Please, my lords.
On the vacating stay application haki.
Please, my lord, please.
With respect to
So registry to put up all the applications on the said date.
interim order,
Interim order will continue.
please.
Wound certificate ಎಲ್ಲ ಇದೆಯಾ ನೋಡಿ. What is the injury cost? We will take care of the bouncers.
Please, my lords. We are here before your lordship for the owner, my lords.
Oh, owner. Yes, we'll see.
Please, my lords.
Next.
Plus for the petitioner in the CL number 61, my lords, and the respondent number 1 was.
60? Wait.
Apologies.
Second, 7A.
8, my lord.
Huh?
8.
D under 7th, yes. 61, post immediately after service of notice upon the respondent.
My lords, and the last occasion that like the respondent number 1 was.
Stay
directed to
interim order
furnish the-
ಇದೆಯಾ?
No, my lords. That is the reason like, I wish to make a
What's the
submission in this
offense?
regard. 65 and the 66 offense, my lords. And the lordship has granted
we'll
a stay
see.
in the 65 and
Madam,
66, my
admission,
lords.
Madam.
My lord, I would like to furnish the lordship the judgment in this regard, my lords.
Settlement
Same to
ಇದೆಯಾ?
same facts.
ಆಯ್ತು, ಒಂದು ನಿಮಿಷ.
Plus, same to same facts.
Same to same.
I mean, exactly same allegation, my lords. The lordship has issued a stay in this case, my lords. The simple allegation, my lords, the transfer of data from company's email to my personal mail. In this case also same to same case, my lords.
As we'll see. List the matter on 15th in the fresh matters list. We'll see. 15th. Yes.
30 more matters.
ಎಷ್ಟಿದೆ ಮೇಡಮ್?
Fresh matter. Seal number 1.
5 more minutes, I'll take it, yes.
Pawan Kumar G.
Challenge crime.
Then Pawan Kumar G Pawan Kumara. Pawan Kumar G ಅಂತಾನೆ ಕರಿಬೇಕಾ ನಿಮ್ಗೆ? ಸರಿ ಕೊಡಿ.
Withdrawal.
Withdrawal, yes.
Liberty challenge charge sheet.
Yes. All liberty.
Seal number 2. Start, Suman.
Huh?
4-9.
Siddharth, what is this?
PMLA proceedings initiated against rice vendors in West Bengal. I have nothing to do
Rice
with this.
vendors.
Rice vendors. We have sold rice in 2020 to 2023 to one entity called PWIP Food Tech. Now, this appears to be a fraudulent company because after I got this summons from ED, I did my research. There are about 2 or 3 FIRs registered all across India as against them.
Bani.
Now here, I sent out an email because I got a notice, the petition number 1. He's paralyzed. We sent out an email saying that, see, the situation is such, we'll provide whatever documents you require. In fact, I myself may also be aggrieved against this particular entity. But the problem is, they're still insisting on his physical presence here. Now, I have no difficulty giving all these documents. I can send a representative, because that's the only issue. I served it on Mr. Unikrishnan's colleague.
He's suffering from some problem which he cannot attend.
The disability certificate is also here. I think. There's no dispute on that.
He will cooperate with the investigation.
Can I send a representative, because if that's the case, I'll send a representative whatever documents they want. Because I may also be agreed with this.
A medical certificate idea?
There's a disability certificate itself from West Bengal. So,
more
live. Cooperate ಮಾಡ್ತಾರೆ.
I will send somebody else.
ಅವ್ರ ಕಸ್ಟೋಡಿಯಲ್ ಇಂಟ್ರೋಗೇಷನ್ ಏನ್ ಬೇಕಾಗಲ್ಲ, ಇದು ರೈಸ್ ಗೇಮ್ ಅಲ್ಲ. It is not online rummy.
24 ಅಲ್ಲಿ the ECR is
really not. Tomorrow.
I had served Mr. Unikrishnan's colleague that I would.
ಆಯ್ತು, ನಾಳೆ let him.
Please.
ನಾಳೆ. The only grievance is that he cannot appear. He will send his representative.
Have you,
We must have given 50 summons.
Please.
50 summons.
Section
50 summons.
My nephew, will come because he's also part of the rice mill itself.
All right.
Please. Tomorrow, fresh matters.
ನಾಳೆ fresh matters.
Please. Grateful.
Hearing on IS, seal number 3. Sundaram MV.
Arjun, ಇದೇನು ಇಲ್ಲಿ?
It is
Sir,
not special
disabled?
Disabled. This
Elections,
pertains to Bowring Club. There's been an issue going on at that club for some time now with regard to purchase of lands, etc.
Correct. I also had dealt with some GMCPC.
Can I now just point out a few things? Since that time, over 800 members have been added now by this particular person without any reference.
I will not complain to the registrar.
That's why, we've complained umpteen number of times to the registrar. In fact, the previous registrar was himself also made a member of the club. Now, the approach is.
Have you served it on the state council?
Yes,
Yeah, who is there?
She said she's coming.
Who?
Yeah. Madam Sarita said she's coming.
Where is it? Barak ಹೇಳಿ. Wait, pass over. ನಾಳೆ election na?
Naale Sanjay can be taken up in the morning if my lords wants.
I'll take it in the morning then. I'll also go through the papers. ನಾಳೆ ಹಾಕಿ madam.
Great.
Yes. Fresh matters. Tomorrow fresh matters. Ravi Shankar sir had appeared in one of those matters. ಅದೇ GMCP ನೀವು appear ಆಗಿದ್ರಾ?
I think Mr. Rajgopal had appeared.
Rajgopal. Correct. Yes.
Number 4, withdrawal lot.
In terms of
5 also.
5 also. Yes.
Seal number 6,
Jayanti.
courting settlement. Srimati Jayanti R.
Offense.
I appear for
326,
320, 326, 323,
Parties.
320. Parties are present.
All right. Close.
Grateful, Your Lordship.
Yes.
Courting settlement.
ಏನು offense?
323, 324, 326, 504.
ನೋಡಿದ್ರೆ 326 ಇದ್ದಂಗಿದೆ. ಒಂದು ನಿಮಿಷ ತಾಳಿ. ಇದು ಪಬ್ಬಲ್ ಗಲಾಟೆ ಆಗಿರೋದಾ?
No, Your Lordship. Road ಅಲ್ಲಿ. Road ಅಲ್ಲಿ.
ರೋಡ್ ಅಲ್ಲ. ಯಾರು ಹೊಡೆದ ನಿಮಗೆ ಹೊಡೆದ್ರಾ? ಇಲ್ಲ ಸುಮ್ಮನೆ ನೋಡಿದ್ರಾ? ಇನ್ಯಾರಿಗೂ ಹೊಡಿಬೇಡಿ. ಆಯ್ತು.
Odd sheets. Reporting settlement.
ಎಷ್ಟಿದೆ ಮೇಡಮ್?
108. 108. Time cable.
ನೆಕ್ಸ್ಟ್ 12th ಹಾಕ್ಬಿಡಿ. 12th ಬೇಡ, 15th. ನೆಕ್ಸ್ಟ್
109 urgent. 110. Ashokti. 110.
15th.
111.
What is the present, my lord?
Offense.
My lord, 415, 416, 417, and
420. 465.
465, 468, 471, and 420.
Respondents council ಇದಾರಾ?
Present, my lord. ಬಂದಿದ್ದಾರೆ.
Parties and council.
Parties and council present, my lord.
ಆಯ್ತು, ತೊಗೊಳ್ಳಿ.
Affidavit.
Affidavit ಅಲ್ಲಿ. ಸರಿ ಆಯ್ತು, ಎಸ್ ನೆಕ್ಸ್ಟ್.
Order sheet.
Obliged.
ಇದು ಕರೆದು ಬಿಡಿ ಮೇಡಮ್. ಏನದು ಏನದು?
Serial number 112, my lord.
112 ಕರೆದು ಬಿಡಿ, ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಇದೆ. ನಿಮಿಷ ನೋಡೋಣ.
112.
112, my lord, allegations of misconduct.
13
Misconduct, my lord. In fact, the Lokayukta themselves, my lord, have stated that there is no role to play on reply
Correct.
given by the.
That interim
That is
order.
the only issue.
Where is Venkatesh Arbatti?
My lord, they have been
ಇದು
seeking time on
ಕೆಲ್ಸ
multiple
ಮಾಡಿ.
occasions. my lord.
Release the matter from the status of being part heard post on Tuesday in the fresh matters list. Yes.
Please, my lord.
Next.
113.
ಅರುಣ್ ಶ್ಯಾಮ್, ಅಲ್ಲೊಂದಿದೆ 7A.
7A ಇದೆ.
ನೀವೇ ತಗೊಂಡಿರೋದು, ಆಡಿಯೋ ರೆಕಾರ್ಡಿಂಗ್ ಎಲ್ಲ ಇರೋದು. ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ಮೇಲೆ ಬಂದ್ಬಿಡಿ.
My lord, there is no demand and acceptance.
ಅಯ್ಯೋ, ಲೇಟೆಸ್ಟ್ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನು ಬೇಕಾಗಿಲ್ಲ.
There is no work pending.
ಅದಂತೂ ಮುಂಚೆನೆ ಇಲ್ಲ.
Work
See,
pending.
in so far as work pending under the Prevention of Corruption Act went away in Sita Soren.
That alleged, my lord, recording is prior to the registration of the FIR.
No
My lord,
problem.
it has nothing to do with.
ಎಲ್ಲ
My lord,
I will
it
not
is-
look into all that at all.
And it is not, my lord, it is not a case where, my lord, they have recorded from the call
ಆಯ್ತು,
record. It says
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ಲ ಅಲ್ವಾ?
from the tape recorder they have recorded.
ಚಾರ್ಜ್ ಶೀಟ್ ಇಸ್ ಫೈಲ್ಡ್.
No, not yet.
ಮತ್ತೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ಮೇಲೆ ಬನ್ನಿ ಬೇಕಾರೆ, ಇಲ್ಲ ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಳ್ಳಿ.
Lord, the charge sheet has not yet been filed, my lord. All that needs
No,
to be
sir.
considered is, my lord, that alleged recording, voice recording is prior to the registration of FIR.
So what?
It is prior to, my lord, and there is a
Has to
delay,
be
my lord.
prior
They
to
have,
the record.
ಅಲ್ಲ, ಪೋಸ್ಟ್ ಪೇಯ್ಡ್ ಅಲ್ಲ, ಇದು ಪ್ರೀಪೇಯ್ಡ್ ಕರೆಕ್ಟ್ ಆಗೇ ಇದೆ.
post paid. They say, my lord, there is no work.
If the voice recording is prior to registration of the crime, it is case worse.
Lord, now only thing is, there is an inordinate delay in lodging the complaint.
ಏನ್ ಡಿಲೇ?
That tape has been recorded according to them on 27/1/25.
ಸರಿ.
Next month, my lord, they register FIR.
Towards our latest judgment, I can't look into all that.
But now,
ಮೊನ್ನೆ look into Rangaya's case, ಏನು ಆಗಲ್ಲ.
that is there.
No, come after charge. If that is there, it is what it is.
No, my lord.
Come after charge.
Kindly see the date, my lord, where.
Sir,
And apart from this, my lord, the charge
you
sheet.
you don't have a case low-key also.
No, Lord, the trap merger has been drawn in the police station, my lord. That also, my lord, needs to be
ಅದು
considered.
ಅವ್ರ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಲಿ, ಎಲ್ಲ all contentions open. This will not stay.
But now,
No, Arun Sham sir, ಕೊಡೋ ಕೇಸಲ್ಲಿ ಬೇರೆ, ನಾಟ್ ಇನ್ ದಿಸ್. ಹತ್ತೆ ಹೇಳ್ಬಿಟ್ಟು 3 ತಂದಿದಾರ, ಅಲ್ಲಿ ಬನ್ನಿ, ಇಲ್ಲಿ ಹೋಗಿ 3 ಲಕ್ಷ ಕೊಡಿ. What is all this?
my lord, even before the registration of FIR, Panchas are called to the police station.
Procedural aberration, you can always argue that in the trial.
Not that. Before that, this is nothing but, my lord, putting the horse behind the cart. That totally contrary to the
Horse
principles.
before the court ಇಲ್ಲ ಇದು. ನೋಡ್ಬೇಕು. Court is full of corruption. Horse, wherever it is, no problem.
He has not accepted. There is no test, my lord, nothing. He has not accepted. The only thing is, my lord, now.
Not accepted what? You have asked him to give it to someone else.
No, my lord,
That is
not at
exactly
all.
what Rangaya says.
There is no allegation at all.
No, that is exactly what Rangaya says.
No, that may be the Rangaya case. I
No,
agree, my
sir.
lord. But here, he has not demanded. It is only, my lord, the two private individuals demanded and collected is that allegation.
ఏమి లేదు.
My lord, entire allegation in the complaint is that hearsay, my lord. If they say he has, the third party says so and so has demanded. I has not been, my lord, involved. I have not been involved.
As I told you, it is what it is. So you'll have to face
But all these
what it
things, my lord,
is.
where? The work also, my lord, on the date of the complaint, work was not pending at all.
Ayod Sita Soren itself, Supreme Court says work pending is no ground.
Even according to the
No, no,
complaint
sir.
prosecution
You
version,
come,
there is no.
ನಾನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗೋಗಿದೆ ಅನ್ಕೊಂಡೆ.
ಇಲ್ಲ, charge
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಆದ್ಮೇಲೆ ಬನ್ನಿ, ಆಲ್ ಕಂಟೆನ್ಷನ್ಸ್ ಲೆಫ್ಟ್ ಓಪನ್.
Very well.
Yes. No, no, that is, that's a good order actually. Discretion, sir, the best part of valor.
And my interest may be protected, my lord.
Your interest ah?
ಅಂದ್ರೆ
ಏನ್
I have
interest?
not been arrested, my lord, in this case, and
ಯಾರು ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ ನಿಮ್ಮನ್ನ?
public servant, my lord, if their protection may be given.
Say, take bail. Immediate ಆಗಿ ಸಿಗುತ್ತೆ ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್.
Interim order is there, my lord, till today. Now,
I'll continue it for 15 days. You secure bail. ಇಲ್ಲ ಅಂದ್ರೆ ಅದೊಂದೇ.
Your lordship may continue the benefit of interim order for 2 weeks, my lord, or 4 weeks.
Only two.
ಅಲ್ಲಿ 4 weeks ಇಲ್ದಿದ್ರೆ ಫೈಲ್ ಮಾಡಿ ಬರೋದಿಲ್ಲ. ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿಕ್ಕೆ ಇವರೇ ಟೈಮ್ ತಗೋತಾರೆ.
No, ಯಾರು?
ಪ್ರಾಸಿಕ್ಯೂಷನ್.
ಏನಿಲ್ಲ, 2 weeks.
We have seen in the other case,
Approaching in 2 weeks. ಅಲ್ಲಿ ಮಾಡ್ಕೊಳ್ಳಿ. Yes.
Supreme Court
say
said
4
bail
weeks.
has to be decided in 1 week.
Huh?
Supreme Court said bail has to be decided in 1 week.
ಮತ್ತೆ ಆಯ್ತು.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳ್ತಾ ಇರ್ತದೆ, ಬಟ್ ಡಿಸೈಡ್ ಆಗುದಿಲ್ಲ.
ಆಗುತ್ತೆ. ಹಾಗೆಲ್ಲ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ, ಹಾಗೆ ಆಗ್ತದೆ. But ಇದು
Request, my lord, your lordship may grant 4 weeks time, my lord, so that.
Heard the learned petitioner is before this court calling, seeking the following prayer. Heard the learned senior counsel Arun Sham appearing for the petitioner, learned senior counsel D.R. Ravi Shankar along with Srimati Kirti Reddy appearing for the complainant, the learned counsel B. Latif appearing for the Lokayukta. State idara? Lokayukta. The issue revolves around demand and acceptance of bribe, which is shrouded with seriously disputed questions of fact. In the teeth of these factors, the investigation in the least is a must. There is an interim order operating in the case at hand. The learned senior counsel would submit that the interim order be continued for a period of 2 weeks so that he would take steps to secure bail at the hands of the concerned court and would seek liberty to approach this court in the event a final report is filed, and the final report would go against the petitioner, reserving such liberty to the petitioner to reproach this court at a later point in time. The petition stands disposed with the interim order continuing for a period of 2 more weeks to enable the petitioner to secure bail at the hands of the concerned court. Merely because interim order is extended by a period of 2 weeks, it does not mean that the concerned court would be swayed by the extension of interim order to grant bail. It shall be considered only on its merit, ordered accordingly. All contentions remain open to be considered.
Only one request, my lord. Your lordship may say, my lord, 3 weeks at least, because my lord, practically it is difficult.
1 week ಅಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡ್ತಾರೆ.
ಆಗೋದಿಲ್ಲ ಸಂಬಂಧ.
ಅಲ್ಲ, in the event the petitioner approaches the concerned court within 2 weeks as observed herein above, the concerned court shall answer it in the light of the directions of the apex court to consider the bail applications.
Please.
ನಂದೇನಿಲ್ಲ, apex court ಹೇಳಿದೆ.
Apex court ಹೇಳಿದೆ, but practically, my lord,
ಹೇಳಾಗಿದೆಯಲ್ಲ ಈಗ.
they will take 2 weeks time, my lord.
ಯಾರು?
Prosecution will take 2 weeks time, my lord, in all cases. But it's practically impossible. That is the only reason why I am making this request.
ಅದು ಹಂಗಾದ್ರೆ ಬನ್ನಿ ಇಲ್ಲಿ.
Only 3 weeks, my lord, I am requesting. Another 7 days, my lord.
ನೀವು 2 ಅಲ್ಲಿ ಬನ್ನಿ.
All these days, my lord, that we had the benefit of interim order.
ನೀವು ಬನ್ನಿ ವಾಪಸ್
ಬರುವಷ್ಟು ಟೈಮ್ ಕೊಡುದಿಲ್ಲ ಅವರು. That, my lord, they will oppose, my lord, and they will, my lord, even frustrate my case.
ಏನು ಮಾಡಲ್ಲ, ನೀವು ಬನ್ನಿ 2 weeks ಅಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡ್ತಾರೆ.
All that, my lord, 7 days I am requesting extra, my lord.
Yes.
Apart from
Ravishankar sir.
3 weeks is reasonable.
I would only say this, my lords. It is an apprehension which they are expressing. If in case they are seeking time and the judge, the concerned judge wants to spill this beyond a period of 1 week after the filing of the application, they can always be before the court.
Lord, it is very difficult for me to come and file an application. All that I am praying, Lord, 3 weeks.
Arun Sham sir, this order itself is a concession.
Yes.
Once I am closing it, I would not have extended the interim order.
I can very well understand, my lord, that is the concession given. I am all that requesting, my lord. It is very difficult for me to, my lord.
ನೀವು ಇನ್ನು even before going before the court, you are expressing so many things.
My lord, here itself they will take 2 weeks time. In other matters,
no,
your
sir.
lordship
Have faith in the judgment of the Supreme Court.
Exactly,
and the
sir.
presiding officer.
Lord,
If nothing happens there, they
No,
can
that
come
is why
back.
it is said, if
For
you,
apprehensions.
that is why it is said, if you suffer before it is necessary, you will suffer more than it is necessary. Now go.
Great.
ಈಗ ಹೋಗಿ ಬನ್ನಿ.
Only 3 weeks, my lord, I am
ನೀವು
requesting.
ಹೋಗಿ ಬನ್ನಿ
because
sir.
it's very difficult otherwise.
Yeah, no difficulty. First go and come.
Yes.
But I have to get the certified copy. I have to
ಈ
produce.
ನಾಳೆ
Your lordship may say, sir.
ಈಗ ಟೈಪ್ ಮಾಡಿ ನಾಳೆ ಬೆಳಗ್ಗೆ ಅದು ಅಪ್ಲೋಡ್ ಆಗ್ಬೇಕು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ. ಎಸ್.
Great.
ಅಂತೆ.
Grateful.
Further hearing, 113.
Or this matter where, my lord, the police, my lord, quarters is situated in a place where, my lord, the accused number 1, a lady, my lord, she is the owner. My lord, she entered into sale agreement with the 2-3 people, my lord. They are now arrayed as.
ಇದು
accused
ಪೊಲೀಸ್
number-
ಕ್ವಾರ್ಟರ್ಸ್ ಸೇಲ್ದಾ?
Yes, yes, yes.
ಮಲ್ಲೇಶ್ವರಂ.
ಹೌದು. My lord, we have produced the additional documents. Today, my lord, we have filed along
ಏನ್
with
ಸ್ಟೇ
IA.
ಇಲ್ವಲ್ಲ ಇದ್ರಲ್ಲಿ?
Stay illa.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ತದೆ, ಆಗ್ಲಿ ಬಿಡಿ.
IA that we have filed today, there are additional documents to show that, my
ಅಲ್ಲ
lord, EC is standing in
you-
the name of the
no
landlord.
problem. ಇದು ನಾಳೆ ತಗೊಂತೇನೆ. You come on merits, will answer it on
Very well, my
merits.
lord. My lord, here it is a case where, my lord,
ಪರವಾಗಿಲ್ಲ.
all documents are standing in favor
That's
of
all
the
right.
lady.
I'll take it tomorrow.
landlord.
You'll hear it on merits.
Nothing is there with the prosecution, my lord, to show that land belongs to police department.
We'll see.
Absolutely zero documents.
Sir, land belongs to police department from 1950.
That is their
Police
claim only.
quarters
There
is
no
there.
document. Let them
Policemen are living there.
They are
And you
living,
sell
not-
away
not-
the police
no
quarters.
doubt that they are living there, but there is no
No,
document to
that's
say
why I was
that they are the
telling,
owners.
if this is permitted tomorrow, this building is not safe.
But, my lord, from consistently from, my lord, 50s, records are standing in the name of the accused number 1, who is a landlord.
No.
My ancestors, my lord.
So policemen are encroachers, huh?
Exactly, my lord.
Oh.
And there are 2 suits filed. In one of the suits, police also party.
They've
Civil
encroached-
dispute is pending.
They encroached and
As
built
an
a police
afterthought, they
station in
filed.
1930 and continue to be there, and thereafter they built a quarters. Since then,
Let them show a single piece of paper, my lord. We will withdraw the petition.
I mean, your courage should be appreciated. Police quarters you sell away.
That is why I am only before your lordship's hand, my lord. No protection at all. Now police lodges a complaint before another police station, and they, my lord, arrested
That's
me.
all right. You have
They, my
sold,
lord,
you have
give
sold the
away all
quarters.
the-
You have sold the quarter which is police quarters for the last 50 years, and the policemen are living there. Agreement of sale.
Agreement,
Ah.
that's it.
No problems. Yes.
And
Your
they have
agreement
not
holders.
arrested, they have not secured the vendor, who is the title holder. Now allegation against the agreement holders.
ಆಯ್ತು, we'll see. ನಾಳೆ ಆಗಲ್ಲ, ನನಗೂ ಆಗಲ್ಲ. ಮಂಡೇ or ಟ್ಯೂಸ್ಡೇ ತಗೊಂತೀನಿ.
Please.
ಟ್ಯೂಸ್ಡೇ, ಎಸ್. ಆಯ್ತಾ, ಇದು ತಗೊಳ್ಳಿ ಮಾಡಿ. Back to ED matter. Admission matters which have not reached will reach,
IA for
will listed on another day.
IA for production of document.
Wherever interim order is there, will continue.
IA for production of document maybe.
7A matters alla 2nd July, 13 PC Act matters alla 7th July.
List number 2, serial number 6 passed over matter. It may be connected along with 91.
Wait.
Any date may be.
Pawan G, wait. Yes.
Number 3, my lord. Serial number 2, 498, my lord. 498 in-glass, my lord.
ಯಾವ್ದಾದ್ರೂ ಅಷ್ಟೇ. Yes.
Number 89,
It will get repeated on next week. Wait.
Serial number 89, my lord.
You want to go home?
Serial number 104, my lord. List number 3.
You want to go home? Wait.
Serial number 89.
List number 2, my lord.
My lord. Serial number 89, first day, my lord. Because the
ಎಲ್ಲ Thursday ಬರುತ್ತೆ.
My lord, sir.
cross examination was tomorrow, my lord. 89.
Huh?
89.
11th, sir. I'll time ತಗೊಳ್ಳಿ.
My lord.
But they are not giving time for.
Who will not give time? Yes, we'll see. Yes.
My lord,
Judgment post ಮಾಡ್ಲಿ ಬೇಕಾದ್ರೆ stay ಮಾಡ್ತೀನಿ. Don't worry about it. 11th, all these matters on 11th.
My lord, list number 2, serial number 104, my lord. There is no stay, my lord. Offense is
11th.
grateful, my lord.
Your lordship, serial number 67, list 2, it's for withdrawal, your lordship.
Thank you. Withdrawn. Yes.
My lord, serial number 88, my lord.
With liberty to, because it's become infectious, with liberty
Yes,
to.
sir.
challenge
Yes, sir.
the- Please, your lordship.
All on 11th.
So list number.
Interim orders ಎಲ್ಲಿದೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಎಲ್ಲ 11th. Yes.
List number 3, my lord. List number 3, fresh matter, my lord. Serial number 2, 498 in-glass, my lord. Aged.
List number 3 ಅಂದ್ರೆ ಇರಿ ಸರ್. Yes.
Serial number 88, my lord, I am seeking statutory bail, my lord. Serial number 88.
Which serial number?
88, my lord. I am seeking statutory bail.
Why?
Petitioner is 76 years old, my lord. He has already served more than one half of the
Offer-
mandate at present.
Serial number?
88, my lord.
Jagdish sir, what is that 88? Just
Statutory
Huh?
bail, yes.
ED matter.
My lord, he has already served more than
Madhu,
half of
copy ಕೊಟ್ಟಿದ್ದೀರಾ?
53. They have even filed the objection.
Monday, fresh matters. Yes. 11th. 11th. Yes. Yes, yes, all 11th. Don't ask. Interim order will continue. Huh? 7A, see, if it is 7A PC Act, 2nd July. If it is 13 PC Act, 7th July. All other matters on 11th. Yes. Yes, yes. Next. Age, sir.
115?
Mine also can go on 11th, my lords.
No, no, sir.
Almost 6 o'clock. I don't want to trouble my lords.
No, no, sir. That's all right. Yes. Yeah, anyway, it's only 30 minutes. You can finish it off, sir.
Very well. I was reading the ground reasons to believe.
11th. ಇವತ್ತಿದ್ಯಾ ನಿಮ್ದು 11th.
ನಾಳೆ ಫಸ್ಟ್ ಲಿಸ್ಟ್
11th. 11th. 11th ನೆನ್ಪು ಮಾಡಿ ತಗೊಂತೀನಿ.
ಇದು ಲಾಸ್ಟ್ ಅಲ್ಲ
11th ತಗೊಂತೀನಿ. Yes.
ಸ್ವಾಮಿ 6 ಮಂತ್ ಆಯ್ತು ಸ್ವಾಮಿ.
ಏನು
ವೆಕೇಟಿಂಗ್ ಆಗ್ಬಿಟ್ಟು ನನ್ಗೆ ಕಂಟೆಂಪ್ಟ್ ಮಾಡಿದ್ರೇನೋ ಒಂದು 3 ಮಂತ್ಸ್ ಪನಿಷ್ಮೆಂಟ್ ಆಗ್ತಾ ಇತ್ತು ಸ್ವಾಮಿ. 6 ಮಂತ್ ಆದ್ಮೇಲೆ
No problem. Yes. 11th.
ಇಂಡೈರೆಕ್ಟ್ಲಿ ನನ್ಗೆ ಪನಿಷ್ ಆಗ್ತಾ ಇದೆ.
11th. Yes. ಇದಕ್ಕೆ ತಗೊಳ್ಳಲ್ಲ. ಅದಕ್ಕೆ 11th wait. 11th I'll take it. You make my submissions on merits and leave it. Extra ಮಾತಾಡಿದ್ರೆ ತಗೊಳ್ಳಲ್ಲ. 11th ಮಾತ್ರ. 11th.
ನಿನ್ನೆ ಇವತ್ತು ಅಂತ ಅದೇ ಹೇಳಿದ್ರಲ್ವಾ?
11th. Yes. ಎಲ್ಲ 11th sir. Yes.
This 2-7 is passed over. It may be taken on 11th. Yes.
What is the interim order ಇದೆಯಾ?
ಇಲ್ಲ ಇದ್ರಲ್ಲಿಲ್ಲ. I'm pressing for it, but
when do you want? 11th.
Any date, madam. Fresh matters, madam. Please.
ಏನ್ ಮೇಡಮ್ ಅದು? ಇರ್ಲಿ ಬಿಡಿ, ಅವ್ರು ಇದ್ದಾಗ ಮಾಡೋಣ. ಎಸ್. ಇರಿ ಸರ್. Wait till 7 o'clock. Yes, sir.
Please, my lords. But I was reading the reason to believe.
Sorry, I'm 30 minutes late.
No, it's all right. Lot of pressure on my lords. My lords.
This is just the first week. As weeks pass by, it is. Yes, sir. Yes, sir.
After the table, my lord, para 1.4 bottom.
Yes, sir.
From the above table, it also, I am at page 107. From
Yes,
the
sir.
above table,
Yes.
it is also to be seen that the complaints are from the state of Andhra Pradesh, wherein online real money games are banned. Yet the company was conducting its business activities disregarding the prevailing laws of the land. So the situation in Andhra Pradesh is slightly different because online gaming is banned there.
Yes.
Then 1.5 complaints filed by victims through email to the accused company. Apart from the complaint received by NCRB and FIR registered against the company, the accused company itself has received lakhs of grievances complaints from its users who were victims of fraudulent activities carried out by the company. I was saying 33,000, now it appears to be lakhs. Also notices under section 91 of the CRPC from local agencies of various states. These data were seized during the search conducted under section 17 of PMLA at the premises of Mr. Gamecraft in the month of November 25. Similar to the above tabulated complaints, these grievance complaints are very serious in nature and no less than equivalent to heinous crimes. For ready reference, few complaints are reproduced here under the list of complaints. Just a minute, my computer is hanged for a minute. Series is no less equivalent to heinous crimes, but a ready reference of few complaints are reproduced here under list of the complaints filed by the victims submitted annexure 2. First one is ticket ID. Please disable my account permanently, immediately. Please delete. Otherwise, I will commit. So people are forced to have their account and forced to, in a way, forced to gamble. He says, I will commit suicide. Second, 19656 suicide. Emergency emergency call back from the team. Otherwise, we will have to go for mass suicide. Give me permission for suicide. Committing suicide. Watch Goldsmith murders. 500. I commit suicide after falling in death trap. Tamil Nadu on YouTube. Watch online rummy losers drive man to suicide. TV9 and YouTube. Suicide. You people suck money. I will do suicide. Write your name first soon. My suicide letter. My suicide letter. I'm going to suicide for rummy culture today. I'm going mad for total money loss. No one game. I will totally one-side gameplay. My money of so and so not given. I'm in trouble going suicide. I'm going to commit suicide regarding cheating in rummy.
Reading the list. Yes, sir.
Didn't refund my money. Suicide case. I'm going to suicide for rummy culture. They have taken all my bank balance. I have no way to live. Watch online rummy losers drive man to suicide. TV9 on YouTube. Even in TV9, the suicide is there. I'm getting suicide. Yes, I want to do suicide. I'm going to do suicide. Please, my request, my account is closed. Mobile number so and so. Please, my 13 lakhs loss. My suicide कर रहा है. Please, अब बचाना होगा. Block करो. Please, my account is closed. Please, my rummy culture account is 14 lakhs lost. Please, night MI suicide कर रहा है. Please, my account block कीजिए. My request. Next is I feel like committing suicide. 143414 committing suicide. Then ticket number 1027 complaint on cheating in rummy culture website. 1044 one more complaint regarding cheating in rummy culture website. Cheating game. Again found game cheating. Again cheating in game. Again found a game cheating, doing cheating, etc. That is still. I come to the bottom of that page. 5263 seems like cheating. 5308 blindly I believe your website, but today I explain that you're controlling the entire game and you're cheating in pool game as well as in points game. I'm least bothered about money, but I continue to understand why you're doing this since you're talking good. Then, my lords, ticket number 5, a fraud game. So many complaints, my lords. Then notice under 91 CRPC, game scrap technology. These are police station cyber Hyderabad, Sandeep 68. As soon then ticket number 970072. As soon as hold and refund alleged amount, provide details. CC number so and so cyber cell district Mathura. Then my lord 1008537 urgent notice CRPC rummy complaint number so and so dated so and so cyber it's into Gurgaon my lord. 1009356 notice 91 CRPC Kotak Mahindra Bank rummy complaint number so and so MHA PS Cyber ASI Anil Kumar notice 91 CRPC Kotak Mahindra Bank rummy complaint number so and so MHA dated so and so Cyber Anil Kumar. So many notices etc. My lords may go to the next page and page number I am at page number 113 my lord. After the table is over, look at the number of complaints. It is not that it is an individual stray case like 722. Further, there are many online complaints and negative reviews about rummy culture across consumer forums and review sites. The most common grievances include allegations of rigged gameplay or bots, heavy financial losses and gambling addiction concerns, withdrawal payment issues, poor or unresponsible customer support, claims of unfair card distribution or manipulation, account blocking and verification disputes. Then, my lord, rating is 1.5 and 1.0, reviews, etc. Then next page 114, regarding fraud by rummy culture, consumer complaint court, rummy culture cheating. Then furthermore, 6 number of FIRs were registered against various police stations in Tamil Nadu as people committed suicide, and allegation is that cause of death for suicide is addiction to online gaming. The details of FIR registered given below. So I said 6 suicides committed, but those are most of them are Coimbatore. Based on the above complaints are categorized under the following categories broadly. Suicide, distress, psychological harassment. Certain complaints disclose allegations that victims were subject to severe psychological pressure, emotional trauma, coercive conduct, financial distress, and continuous harassment arising from losses incurred in online rummy game. Due to their losses, victims suffering from extreme mental agony, social humiliation, financial ruin, and emotional instability, thereby driving certain victims into conditions of suicidal indication of severe psychiatric distress. In certain cases, the victims pleaded with the accused company, rather threatening them to block their accounts or they may commit suicide. This complaint demonstrates severe mental agony, emotional trauma, financial desperation, and psychological pressure experienced by victims as a consequence of unscrupulous activities by the accused company. Fraud. A substantial number of complaints received from the victims contain allegations of fraudulent conduct of online rummy game by the accused company. 3. Users of bots. Several complaints containing allegations regarding the deployment of use of automated software system bots, algorithmic tools or scripted programs used to manipulate the outcome of online rummy game by the accused company. The complaints alleged that such bots were used against them, and due to the dishonest practices, the accused company, some of the victims reported suicide or suicidal tendencies. Cheating. A large number of victims alleged that rampant cheating had taken place on rummy online platform, which caused them huge financial losses. 5. Restriction on withdrawal of monies by victims. A significant category of complaints pertain to allegations that victims were restricted, delayed, or unlawfully obstructed from withdrawing their own monies from online gaming platforms, rummy culture, without any prior intervention, not releasing their legitimate monies. Rampant blockage of account wallets. Many users have complained about blockage of their wallets on online gaming platform rummy. As recording as offences under section 420, cheating, dishonest inducing delivered property, cheating, invoke the aforesaid FIR's residual offences. White number so and so has been recorded by this office. Now, kindly for a moment pause and examine this with the 722 minutes. Kindly have a look at this. This is the allegation as far as this investigation is concerned. Now have a look at 722 in this context. Where is 722 page? Page 35. In their petition.
The allegation in 722?
Yes, I'll just give it. Page number 31.
That is page 47.
Yeah, 32. 30, just give me a minute. It starts at 31, my lord.
31.
Yes. And my lord, the right hand top is the number, my lord. It is 720, left hand side, 722 of 21, 0722 of 24, my lord, left hand
Yes,
side.
sir.
Below Bengaluru.
Ah.
Now look at the translation 51, my lords are right. Now compare this with the allegations which are there as far as nothing to do with 722. This is totally different. They were entitled to register a separate ECIR. Now look at 722. Today, there are column 16 at page 51. Brief history of the case, my lord. Today, case file was obtained by PSI Priyadarshini Police Station. Examined the summary of the case is as follows. Complainant Nishant Srivastava alleged filed case against Nirdesa Networks Private Limited, which operates the online gaming platform Pocket 52, for engaging blatant fraudulent activities that have caused me substantial financial loss exceeding 3 crores. One individual 3 crores on Pocket 52, whereas the others are mainly rummy, my lords. Even complaint alleged that Gamescraft and its CEO, along with the leadership team of Pocket 52 and others, complained so and so account was created on 26/4/23. In December of last year, because of following multiple user complaints regarding fraudulent activity, Pocket admitted that fraud was indeed happening on their platform. However, they failed to disclose the full extent of fraud, its nature, whether fraudulent activities were conducted by players or bots. This lack of transparency strongly suggests Nirdesa Networks Private Limited was complicit in these activities. The compensation offered to affected users was inadequate, leaving many, including myself, with no recourse. Complaint observed a consistent pattern where complainant would win small pots but always lose in large ones. Regular players repeatedly emerge victorious in large pots, raising concerns of collusion and manipulation. When complainant raised these concerns, complainant received dismissive replies from Pocket 52 customers support, who suggested complainant play at a smaller table to increase my chance of winning. This response confirmed that outcomes are manipulated based on table size. Complainant experienced numerous glitches, including an incident where two clubs of 99 appeared on the table simultaneously. Such occurrence, two clubs where same cards appeared twice, which could not have appeared on the table. Such occurrence indicates either a faulty RNG or deliberate manipulation of game outcome. Pocket 52 dismissed this incident as mere glitches, failing to provide satisfactory explanation. Pocket 52 removed the hand history feature from its platform, preventing users from reviewing previous games and raising concerns about fairness. When complainant requested data on his gaming status, including the number of games complainant played, won or lost, they refused, claiming no such feature or reported existed. This lack of transparency is unacceptable and indicates an effort to conceal ethical practices. Pocket 52 lacks responsible game measures. There are no caps on deposits or gaming time, yet withdrawals are arbitrarily restricted. One the platform deposit free into dormant accounts lure users back into playing. Such tactics exploit players' vulnerability to violate ethical standards. Complaint observed collusion wherein regular players work together to ensure wins in larger pots. Despite repeated complaints, Pocket 52 ignored these concerns, further highlighted their lack of accountability and commitment to fair play. Therefore, please take action against CEO of the Pocket Game Club and others for their roles in handling fraudulent practices, etc. So this is the individual where he has lost 3 crores. It has nothing to do with the second ECR, which encompasses a larger conspiracy. Now kindly have a look at 2 judgments in this context. This is the Babu Bewal. Which is this? Volume 2. Kindly have a look at volume 2, of my compilation. It's 77. Can I show this? Now kindly come to M. Krishna Ballad, which is at page 18 of my compilation, volume 2. It starts at page 18, my lords. Kindly come to page 21, my lords.
Which judgments? Which?
Says, my lord, M. Krishna was the state of
Krishna.
Karnataka. M. Krishna. Before I read this judgment, I just want to make one submission, my lord. FIR is a statutory instrument required to be mandatorily registered in view of the provisions of section 154. Therefore, it can be subject matter of quashing. And my lord, ECIR is not a statutory document required to be mandatory registration. Investigation can be conducted even without an ECIR. There is no requirement in law that you cannot conduct investigation of a PML offense unless you register an ECIR. Unlike an FIR. Without an FIR, you can't investigate. FIR has to be registered first, then you can follow the procedure either under 156, 157 CRPC. Therefore, there need not be an ECR also. It's another thing that is an ECR in the present case. Now, in this background, kindly examine this, my lord. Now, kindly have a look at para 3 of this judgment where contentions of Mr. Sibal have been recorded. Mr. Sibal, the learned counsel appearing for the appellant, contended the assets of the appellant. This was a DA case, my lord. Assets of the appellant for the period 1878 to 2489 having been subject matter of an investigation pursuant to crime number so and so, and a B form having been filed by the investigating agency, which was approved by the magistrate, inclusion of the said period in the fresh FIR itself is bad. This was a case not by consent or not by mutual agreement that the FIR was quashed. This was a base summary report filed on the basis of investigation. And the base summary report was accepted. And for the same period and other period, a fresh FIR was registered. Now kindly have a look at what the Supreme Court says. They were having been investigating agency approved. And the inclusion of the said period in the fresh FIR itself is bad. Therefore, the FIR is liable to be quashed. So what is their argument? That the stay in the earlier ECR, therefore evidence collected in that ECR can't be looked at. It's a similar argument here. Now kindly have a look at further. Mr. Sibal also contended that in view of subsection 8 of 173 of investigation agency has the right to file a fresh report on the basis of fresh material, but not having done so, implement FIR for the period of 1878 till 25/7/78 cannot be sustained. Same argument of fresh material which was canvassed by the other side. Same argument. You can't look at the old material because the old FIR has gone. In this case, old ECR has not gone. There's only a stay. Eclipse, as my lords have rightly pointed out. According to the very fact the investigation is not aware of the earlier criminal proceeding and investigation thereupon which ultimately ended in B form, except by the court indicates total non-application mind and pursuing the appellant maliciously, and therefore the court should interfere in the proceeding. According to Mr. Sibali, after the FIR is given, whatever statements are received are in the course of investigating the 160 on the Code of Criminal Procedure. That being the position, there cannot be two FIRs for the period 1878 till 2489. The learned counsel then, my lords, kindly come to para 5. Having considered the rival submissions made by the counsel of the parties and having examined the provisions of the CRPC as well as the PC Act, we find ourselves unable to agree with the submission of Mr. Sibal. The learned counsel appearing for the appellant that the present FIR itself is bad in law. We do not find any provision in the code which debars the filing of an FIR and investigating into alleged offences merely because for an earlier period 1878 to 89 there was a first information report which was duly investigated and culminated into B form which was accepted by the competent court. Here, Mano, the ECR is not accepted so far. My case stands on a better footing. At the same time, we are also of the opinion that the conclusion of the High Court that the present proceedings relate to fresh alleged assets and the fresh check period is not wholly correct, inasmuch as admittedly check period from 1878 till 24/8/79 was subject matter of the criminal case 22 of 89, and the same ended in submission of B form. Though the earlier period could be a subject matter of investigation for a variety of reasons, like some assets not being taken into account or some materials bought during investigation not being taken into account, yet at the same time the results of earlier investigation cannot be totally obliterated and ignored by the investigating agency. But that cannot be a ground for quashing the first information report itself for injuncting the investigating authority to investigate into the offence alleged. Then we also find force in the argument, Mr. Sabun, that the assets which are valued in the area and proceeded in the particular value cannot be valued at a higher. That is on valuation, my lords. You can stick to the same valuation. Therefore, my lords, may kindly have a look. The last page 22. For the aforesaid reasons, we are not in a position to quash the FIR, but we will make it to the investigation. We will certainly look into the earlier proceeding and result of investigation thereunder and submission of B form so duly accepted by the competent court while investigating into present proceedings as well as observation made by us in this judgment. That is where the FIR pertain to one single person, not large number of persons, which is the second ECIR. Now that's the larger conspiracy. Now have a look at Ramlal Narang's case. There can be a separate FIR for a large number, for a larger conspiracy. Babubai page 70 summarizes the law. Therefore, our second ECR is for a larger conspiracy.